Good morning, good morning, good morning. It's day 26 of the Commonwealth versus Karen Reed. We are now going into week 8. I can't believe we are here. I am exhausted. You are exhausted. I'm sure the jurors are exhausted. We left off Friday with a very fiery voir dire of the Commonwealth's accident reconstruction expert. So we'll see what the judge does with that. And again, if the defense expert is going to testify about the collision of the vehicles, then it might be that the court is like, hey, this would come in rebuttal. But I think at this time it's late discovery and it should probably be kept out. We'll see what the judge is going to do. And we've got a full week. Today is Monday, June 17th, a full day. Tomorrow is a full day of voir dire. Wednesday is a federal holiday, so Juneteenth will be no court. Thursday is a full court day, and Emily zooming out of here at the very end of court, exactly on time because she has to get on a plane. Friday is a half day, but there might also be a hearing in another case that I need to peek in on. So that's what we're doing today. This cross-examination is going to be fiery. I don't know how I feel about this expert. Yes, I do. I'm going to tell you. Here's how I feel about this expert. I don't think this accident reconstruction expert is well familiar with the data from Karen Reed's vehicle. I don't think he knows the system that he downloaded that is a diagnostic system proprietary towards Toyota. It is not the same information that we saw in like a Murdaugh where they got all of the car data info. He does not seem to really know well exactly what he's looking at. And if you don't know the data well, I don't think you can interpret it well. So if you can't interpret the data well, then we're going to get, you get what you get. But I don't know how a jury gets beyond a reasonable doubt based on data that is unclear because this expert cannot make it clear because I don't think they understand it. So that's where I'm at. Happy to see a different opinion on that. Would really like to. Really can't believe that this is where we're at. But here's where we're at. So let's just roll to court, shall we? I am tired. Are you tired? This case, man. Let's just go to court. Let me know where you're coming in from, what you're drinking. I've got green juice. And it's time to roll. Let's go. Hey there. I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it. My audio got a little spicy on my end. I hope it didn't get spicy on your end, but everything tech-wise has been spicy on my end this morning. Well, let's go back to court and hope that we can zoom through the immediate, inevitable sidebars, but also, y'all.
Bring the jury.
So I saw a few in the chat saying, Emily, are you okay? Oh, my eyes are just super puffy still because I am tired still. So no, we're just puffy. That's all. There's no fixing the face this morning. The eyes are just puffy because we're tired. So it's weariness at this point.
Hear ye, hear ye, hear ye. All parties having anything to do before the Honorable First Justice Beverly Canoni, now sitting in the Norfolk Superior Court within and for the County of Norfolk, draw near and give your attendance, shall be heard. God save the Commonwealth and this good court. Thank you. Be seated for the now session.
Good morning again, Counsel and Ms. Reed. Good morning, jurors. I hope you all enjoyed this gorgeous weekend. I have those 3 questions.
I hope it was a gorgeous weekend locally. Sounds like it was. Court will be louder when people are at the mics.
Friday. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here? Everyone said no or shook their head.
All right.
Thank you very much. Could we please have Trooper Paul?
It's so wild to me that it's just, I don't know. Day after day. The attorneys were at sidebar when we came into court before the jurors came in. The court did not put anything official on the record, so we will see. Court is quiet.
Morning, Trooper.
It will be louder as we get everybody to the microphones. I have it gained up about as much as I can without it starting to peak really badly.
All right, Mr. Lally, whenever you're ready.
So,
Good morning, sir.
Good morning.
If you could, just again, please state your name and spell your last name for the jury.
Yes, it's Trooper Joe Paul. That's Paul.
And sir, if I could just take you back to a couple different portions of your testimony from Friday. With respect...
it's too early for me to start singing, but
the acceleration and braking
it's happening in my
tests
brain.
Conducted, in the
This is witness
driveway area
64.
outside of Camden Police Department. Was that before or after Ms. Hartnett from Crime Scene Services Section had processed the vehicle?
After.
They needed
And so as far as
to
anything
circle
was
back to
removed
that.
by her that was done prior to you conducting any of your tests, is that correct?
Correct.
They did not make it clear that the testing in the parking lot happened after the car was processed.
Investigated.
It needed to be.
Approximately 191 crashes.
We
over your
suspected.
time with the cars unit with the state police, correct?
Correct.
Now, I'm going to ask you just some general questions with regard to a number of those crashes have involved motor vehicles, collisions with other motor vehicles, correct?
He's trying
Yes.
to reestablish
Now,
foundation.
in general terms, with respect to motor vehicle collision, what, if any, we talked a little bit last week about
We're back in front of the jury,
sort of area of impact. And
so
point.
not voir dire.
Correct.
Now, that's with regard to the roadway, is that correct?
Yes, it is.
So with regard to the vehicles coming in contact with each other, what, if anything, regarding damage would you expect or anticipate based on your experience in general terms when vehicles come in contact or touch with each other in a collision sequence?
Crystal, she corrected it at the very end of her
I'm gonna allow
testimony.
it. In general terms, what do you
She processed it on the first. She was wrong through most of her
it's
testimony and
two
then
times
corrected
of
it.
damage onto a vehicle. One's contact damage and one's an induced damage. So when we look at vehicles, we are looking for what's called as contact damage. And the induced damage is basically...
Don't turn towards the judge. Your back's to the
contact
jury.
damage is the
Look at the
damage
jury.
that has actually made direct contact with another vehicle. And induced damage is the damage that did not make direct contact. So for example, if you push in one piece of metal to make contact, the rest of the metal will make a rippling effect that would more cause induced damage.
And just again, in general terms, as far as vehicles coming in contact with each other in a collision sequence, what, if anything...
He's getting more into the background of
based
this.
on your experience to sort of transfer from one vehicle to the other event?
It's possible when you transfer, you can have paint
The judge would have told them at sidebar she did not put that on the record.
transfers
That I saw
come
this
from one
morning.
vehicle to another. You got a tire rub off that go from one vehicle to another. Scratches that would come from one vehicle to another.
And again, sir, just in general terms, when it comes to vehicles interacting with each other in a collision sequence, what, if any, role does the respective heights of those vehicles play in respect to contact damage or inducement?
Yeah, it depends on their heights and how they relate to each other. So that kind of shows if one vehicle is taller, one smaller, it's going to show where the contact damage would be from one vehicle to another based on their height.
So based on respective heights, contact or induced damage could be in a different location from a bigger vehicle to a smaller vehicle, correct?
Correct.
Now, if I could turn you back to the text stream analysis that you conducted with respect to the defendant's vehicle. Now, there were two events that occurred. On that 12629 miles beat, there were two events that occurred within that trigger.
Oh, this is
within that mileage.
painful.
Is that correct?
Correct.
And based on your analysis with respect to the odometer readings and the mileage, where is it?
I don't know if she's letting it in
What
yet.
is your
We'll
belief as
see.
to where the vehicle was when those two events, being the three-point turn and the backup straight for approximately 60 some odd feet, where did those occur within the travel path of the defendant's vehicle?
So The first one, where the three-point turn, in this case, it appeared to be possibly on to, it was a Cedar Crest, which,
Possibly.
because we know based on testimonies that she missed the exit to Fairview and had to make a U-turn onto Cedar Crest, and that would make sense to why they would occur with close proximity to each other. They're within the same odometer mileage and on the same key cycle.
And so that reverse 24.2 miles per hour for 60 some odd feet, where would that have occurred?
He did say a U-turn on Friday.
The odometer reading.
It should occur probably on Fairview.
He said it should occur probably on Fairview. I don't know if I've ever seen a less confident expert. It should occur probably on Fairview. How do you know that?
Now, sir, based on the totality of your analysis and your investigation in this case, what, if any, conclusions did you come to as to how this collision sequence occurred or how this crash occurred?
Yes. Should I go my report for that, or should you want me to just...
Tell him
Kinda
your
go off it.
conclusion. Do you need me to look at my report for that, or do you want me to just tell you? Tell him your conclusion.
Case, what, if any, conclusions did you come to as to how this collision sequence occurred or how this crash occurred?
Yes. Should I go my report for that, or should you want me to just kind of go off it?
Asking to look at your report? Is that what?
Yes.
Sure, go ahead.
Okay.
You don't remember your conclusion about the crash? Really? Your conclusion is central. I wonder if he's a little nervous about what's to come next from Alan Jackson based on their exchange with one another on Friday. Perhaps Jackson has already... Anybody in the chat play water polo? Do other sports do this? Where the first couple shots on goal, depending on who the goalie is, you maybe don't aim to get it in the goal. You maybe aim to get it on the goalie. Anyone else? Make them a little shy. Doesn't work with all goalies, but the super nervous goalies, it works real well with, and then they get a little nervous. So it feels like the initial shots taken by Jackson have made this witness nervous. I love all of you being like, yeah, we do this across sports. I don't know other sports. It's a universal, right? You just you take a few shots at the other team first, and then they're nervous the rest of the game. This is him being completely rattled from Friday, because Alan Jackson came in outside the presence of the jury and roasted him, and now he's nervous. He's kind of flinching out of the way.
Can we continue?
If you could, please.
Okay.
What, if any, conclusions did you come to through the course of your investigation?
So on Saturday, January 29th, 2022, at approximately...
You're reading it. You're reading from your report. Where is the objection to reading from his report? Also, sir, you are mumbling. Lally is mumbling. I don't know if there's anything we can do to help the volume today. All of you are mumbling.
12:45.
So you can look at your report, but you can't read your report.
I'm just
So,
reading my conclusions based on what they asked me to do.
No.
yeah.
Yeah. Fuck no. Oh my God. Did you all just see what happened? So the defense didn't even get the opportunity to object, and the judge stepped in. I know some of you think this judge is very anti-defense, but this judge stepped in before the defense could even object and stepped right in and was like, sir, what you can't do is whatever the fuck you're trying to do. And he just clapped back at the judge. Sir, with minimal
So-
respect, you can't do this. Have you ever testified before? Because you can't do this. You can't do this. We're going to watch it again for my own joy.
Can we continue?
If you could, please.
Oh.
What, if any, conclusions?
Now he's got his report.
Can we continue?
If you could, please.
Okay.
What, if any, conclusions did you come to through the course of your investigation?
So on Saturday, January 29th, 2022, at approximately 12:45.
So you can look at your report, but you can't read your report.
I'm
So
reading my conclusions based on what they asked me to do. Okay.
yeah. So I can't hear you.
Sorry.
Okay. So
She's glad she didn't hear him clap
take
back.
your time, read your report, and then answer Mr. Lally's question. And if you need to look at your report, we'll see about that again.
All right.
Ask the question, Mr. Lally.
Based on the totality of your investigation, what, if any, conclusions did you come to with regard to
Excuse me, sir. It's actually a memory test. You're the expert.
how this collision occurred?
So this collision occurred on Saturday, January 29th, 2022, at approximately 12:45 hours. A 2021 Lexus LX570 was traveling southbound on
He keeps looking at his report.
on Fairview Road, in Area 34 Fairview Road.
Yeah.
It appears that.
So,
Sorry, I'm trying to
so
oppose it.
you know what? I don't, Mr. Lally, break this down. Ask
Yes, please.
He just said, all right, fine, I'll close it.
simple questions so that the witness can answer your question.
Your Honor, how do you think telling Lally to ask simple questions of a witness is gonna go?
We don't need a narrative.
Actually, technically, experts are allowed to give a narrative when it comes to their conclusion, but he should ask, what is your conclusion about the manner of the crash? What is your conclusion about this? What is your conclusion about that? I don't know if Lally can do that. I don't know if this witness can do that, and the judge is done with all of it, it seems.
From your investigation, what, if any, conclusions did you come to as to where this collision occurred?
Where?
All right. So on the night of Saturday, January 2022, at
This is
approximately
terrible.
12:45 hours, a 2021 Lexus LX570.
Can you slow down, sir?
Yes.
So forget all that part,
Okay.
Trooper.
All
Just
right.
answer the question.
Okay.
Where did it occur?
It
We're
occurred in
not
Area
even-
34 Fairview.
We're not even to cross yet. This is the state's expert. Even if you're sitting there going, I don't know what happened to John O'Keefe. I don't know what involvement Karen Reed had. I don't know how this is supposed to help you make that decision. I don't know how this moves you past, I don't know what happened.
Road.
And who, if anyone, were the participants in this collision sequence?
Lally, I can't believe this is your expert in a
The
contentious
operator appeared to
case.
be Karen Reed, and the pedestrian was John O'Keefe.
This is so bad.
And where was the vehicle located in reference to the residents of 34 Fairview Road?
It was located along the southbound travel lane and to the left side of the house as you look at it from the front.
And as far as the vehicle, what, if any,
I'm waiting for Jackson to stand up and just be like, so you'd like us to believe that? Okay.
directionality did it head in, and what, if any, interaction did it have with Mr. O'Keefe?
So the vehicle was traveling in reverse along the southbound travel lane, traveling north.
And how fast was the vehicle traveling and over what distance?
The vehicle traveled up to 24 miles per hour and approximately 62 feet.
And at the time that the vehicle was traveling approximately 24 miles per hour over approximately 62 feet, what, if anything, occurred then?
The right rear of the Lexus struck the pedestrian John O'Keefe.
And post-collision, what, if anything, occurred with regard to Mr. O'Keefe?
Mr. O'Keefe was projected forward and to the left along the front yard of 34 Fairview Road.
And post-collision with Mr. O'Keefe, what, if anything, did the defendant's vehicle do?
The Lexus continued traveling in reverse before they left the area.
Now, as far as the vehicle itself, from your inspection, what, if any, role did any mechanical aspects of the vehicle play in this collision?
There were no mechanical defects.
And as far as your analysis of the roadway and other factors related to that, what, if any, role did they play in this collision sequence?
There were no roadway or environmental factors that contributed to this collision.
Now, sir, with respect to your investigation, what, if any, opinions did you draw based on your training and experience in regard to this collision and how it occurred?
May I look at my report real quick? Just to make sure.
Yes.
Just to make sure. I'm not really sure what my I don't know what I decided.
So throughout my investigation, this appeared to be a single car collision involving a pedestrian. The vehicle was traveling at a higher acceleration when, sorry. The vehicle accelerated at a high rate of speed before it struck the pedestrian John O'Keefe on the
My
roadway
God.
and subsequently left him at the scene.
And with respect to the backup safety system that you observed in this vehicle and made use of in the course of your visibility analysis, what, if any, role do you, is it your opinion that that played in how this crash occurred?
Based on the visibility analysis. So even if the camera systems were
This is
covered in snow,
worse than I
even the
thought
systems were defective anyway,
gonna be.
and even the mirrors were blocked, an attentive and a reasonable operator would not travel in reverse, especially at a high rate of speed. They would have cleaned the mirrors off. They would have made the cameras and systems, if they worked, if they didn't work, they would have done all this prior
these
to
things.
accelerating in reverse.
The objection sustained.
Move to strike.
I'm going to strike that.
Now, with respect to your observations during the course of the visibility analysis, the exemplar pedestrian that you placed in the right rear of the vehicle, was that exemplar pedestrian visible to you at the time that you conducted that visibility analysis?
Yes, it was.
The reason they're getting into visibility is because they have charged this as both a hit and run and operating under the influence or operating while intoxicated, causing death, and an intentional, volitional homicide, a second degree. So if she didn't see him, that's not intentional. At some point, they're going to have to get to her backup camera system would have been beeping. All of this information would have been happening, and she had to continue anyway. But he, I don't think, is experienced enough to get into that testimony, which means in this type of case, he is not the proper expert. And I don't know what the Commonwealth is doing.
Thank you, sir. I have no further questions.
Okay, cross-examination.
No further questions. So for all of you asking about whether the court allowed him to render an opinion with regard to how the accident happened in the driveway at One Meadows between Karen Reed's car and John O'Keefe's car, no, he was not allowed to get into that testimony. He was allowed to give general terms about what you would expect to see in certain types of crashes, and the Commonwealth can try to argue that later, but he was not allowed to render a specific opinion about the video. So Lally got enough that he can argue it. I don't know if it's even going to help at this point, but the judge did not allow that in. Now, the defense may accidentally open the door to that. I doubt it, but the court did not allow it in. All right, y'all. The part that this witness has been waiting for, let's get to cross.
Thank you, Your Honor.
Whatever's in that's not going to help. And I say whatever because I don't know if it's water or coffee.
Do you hold any degrees in the scientific discipline of mathematics?
I do not.
Do you hold any degrees in the scientific discipline of physics?
I do not.
Hold any degrees in the scientific...
Start guessing about what the experts that the defense did not hire but that the feds hired. Start guessing about what their credentials look like. Just start guessing now. Just start guessing now.
discipline of biomechanics?
No.
How about in engineering?
No.
How about in kinematics?
No.
What's the highest degree that you do hold, sir?
I have an associate's degree.
In what?
Administration of justice.
You mentioned kinematics on Friday. Do you hold any certificates in the specific area of kinematics?
Yes, it's covered in the basic crash investigation classes,
Okay, so you took a class, in other words, correct?
at multiple classes.
Like 120 hours of
Idea of what kinematics is.
crash
right?
investigation
Correct.
courses.
Testified about that on Friday.
Yes.
Define kinematics, if yours.
It deals with the aspect of motion.
It's
Good.
a subfield of what broader field?
Kinematics?
Is a subfield of
Kinematics
what
is a
broader field?
Subfield of what broader discipline of science?
Wouldn't that be physics?
I'm not sure.
Which would be physics
Be physics.
for 100.
Yes.
Alan,
Describes how points and objects and systems of objects, how they move, and how the rate they move and the rate of their velocity, correct?
It deals with emotions.
What's that called? The rate of velocity. What's another word for that?
The rate of velocity?
Correct.
I mean, it deals with the motion. It deals with forward, and also deals with speed. It deals with travel and speed. If something's moving, it also has a speed to it.
Right. The word you're looking for is acceleration, correct?
Sure.
sure?
What role does acceleration play in the field of kinematics?
What role does
Are you just going to
what
repeat every
role does
question?
acceleration play in kinematics?
Correct.
It talks about, like you just said, it talks about the speed and talks about motion.
Is kinematics also known as the geometry of motion?
I'm sorry to all the engineers in the
I've
chat
not
who are
heard that.
dying
I've
inside.
heard that. What's the difference between constrained and unconstrained motion?
Constrained and unconstrained motion.
Repeating the question doesn't help.
Constrained motion. I can't recollect at the moment.
He's like, why is this a
Constrained
test?
motion is motion on a predetermined path, isn't it?
Yes.
Unconstrained motion is what?
When it doesn't have a predetermined path.
Free movement, correct?
Correct.
Couldn't remember that from your class?
Nope, sure couldn't.
For the most part, we don't go that in depth, constrained and unconstrained.
We don't
Constrained.
go that in depth. Sir, I think that's exactly his point.
Unconstrained, not restrained.
That's what I said. Sorry, unconstrained. Yes.
Kinematics uses algebraic formula to model these motions, right? The motions of these points and systems of points, correct?
Yes.
And it includes concepts like displacement and speed, velocity, distance, acceleration, which we've talked about, correct?
Correct.
And it looks at how these things, these values vary over.
And yes, chat, for all of you asking, Alan Jackson was a jet engine mechanic in the United States Air Force and a technician. So I don't know if this witness knows that, but we know that. So
Point in time or duration in time, is that right?
Yes.
I
Do
imagine
you actually understand
Alan knows a bit about physics.
behind the study of kinematics?
No.
Yes.
The word you learned in class.
Yes, we had to go over the physics part of it.
On Friday, you said that this incident is a pedestrian strike from a vehicle. You reiterated that again this morning. Is that right?
Correct.
Said that a
I want to be
lot.
clear, that is your opinion based
Yeah.
on your training and experience, correct?
Yep.
Yes.
And there's nothing wrong with that. But
And
opinions
on Friday,
can
you
be
said
challenged.
you based that fact, or you based that rather opinion, on the fact that you noted a half-mile-an-hour decrease in speed and a steering input of less than 10 degrees at some point in that reverse motion, correct?
I said that was consistent. That data point in general was consistent with something that you would see within data of a pedestrian striker striking something else. I do go in my report saying I can't say that's definitively where a pedestrian was struck, but
I'm sorry, I could barely.
it wasn't definitively. Sorry, in my report I do say I can't say that is definitively where the pedestrian struck.
Cannot say
Definitively.
Okay, the court reporter can't hear, Alan can't hear, and what we can hear very clearly on the mic is I can't say definitively that's where a pedestrian strike occurred. That data is consistent with the possibility of a pedestrian strike. It's going to get worse.
Yes.
Okay, so you're going to have to slow down and
Speak
speak up, okay?
All right.
You just said, I just want to make sure I'm hearing you correctly, and I apologize.
Okay.
You said you cannot say definitively that that resulted in a pedestrian strike.
That data point within the text stream data is what I'm talking about.
Okay.
That specific point, that time frame.
Because there's a multitude of reasons why when someone is driving in reverse, they might slow down by a half a mile an hour, right?
Right.
It's when I say when it's consistent, it's because there's the other aspects of it is the fact that the accelerator is consistently strong.
Let him answer. Finish your answer.
So the accelerator is at a constant rate, and then it just drops by half a mile, and the steering wheel all of a sudden abruptly goes to the right. That's
I don't know. Couldn't that be consistent with like ice? Just a thought.
That's what I'm talking about when I say it is consistent with a pedestrian strike. That's something that you would see. It's not going to be a huge change of speed during this collision.
You also note that at the time, it had begun to snow, correct?
Yes,
There would be snow on the lawn, right?
correct.
There would be snow on the cars,
Yes,
Snow on the
trees,
ground.
yes,
On the
snow
ground?
roadway.
Is there snow on the ground?
Snow on the roadway could impact how tires move over the roadway, correct?
in a way.
In what way?
And obviously, there are a multitude of reasons why somebody might input a 10-degree input on a steering wheel, correct?
In
Correct.
what
That's
way?
why I said I couldn't definitely say it.
Right. So every time somebody slows down, going in reverse or forward, and introduces a 10-degree input on the steering wheel, doesn't mean they're looking to hit a pedestrian, correct?
Correct.
You testified that you determined the area of impact by basically following, if I heard your testimony correctly, basically following the debris field from the body from where you believed John O'Keefe's body's final resting place was, almost linearly to the furthermost piece of debris that was found. Did I get that right?
Yes.
In other words, you established what in your mind, or what you were told was his final resting place, and what you were told was the debris field. And you indicated that the furthermost piece of debris would basically be the area of impact, right?
It's within that line. I didn't say that is the area impact where the furthermost piece of evidence is.
All right.
It's just the linear, like you said earlier. It's that linear. We're throwing that path. That's the path that he traveled post impact
LG in the
with
chat said
vehicle.
so far AJ
And
is
that's
being gentle.
That is on which
I wonder if this witness's apparent nervousness has, either that or the weekend, has moderated Jackson's level of spice at this moment, because he did not come in nearly as hot as he did on Friday, which is probably appropriate, because at some point you can turn the jurors off by going way too hard, because it's not needed. His answer was, I can't say definitively. That's his expert conclusion. It's consistent, but it's not definitive. So what else are you going to do?
that fact that you stated is on which what you, it's a terrible question. That's the basis for your opinion of where the area of impact was, correct?
Yes.
Let's take a look at exhibit, with the court's permission, 587. It's your diagram 3. If I may approach, Your Honor, just for...
Okay?
C-Mac in the chat said, I can feel his anxiety from Scotland. This is uncomfortable to watch. It is uncomfortable, which is probably why Jackson has toned it down, because the jury is probably also uncomfortable, right?
May I approach?
Yes.
So you can see it. Your Honor, may we publish exhibit 587? diagram
Yes.
3? Okay. Sir, you see diagram 3 on the board. You also have it in front of you, correct?
Yes.
It's easier for you to refer to what's in front of you because that's a little bit further away. Just let me know.
Okay.
See, at least with like Dr. Spiegel and Dr. Hughes, they didn't seem nervous. They seemed angry. He seemed scared.
What I'm highlighting right now indicate basically the debris field that you explained to the jurors on Friday, correct?
Yes.
And then there's a point of an arrow that comes back to a wording that says pedestrian's final rest, basically right there, correct?
Yes.
And the debris field ends right in the middle of that spotlight, correct?
Yes.
All right, so that's the area of impact that you indicated to Mr. Lally you believe occurred because of the debris field and the linear portion of that debris field going from the pedestrian's final rest all the way out to that final little red arrow that says red plastic B in parentheses, correct?
Yes.
Yona, can we have exhibit 492 published to the journal, please?
Okay.
Approach.
Yes.
All right, he's approaching.
While that's coming up, have you ever seen this?
Look,
No, I haven't.
Take a look.
sir, this is going to be a problem if you didn't see the rest of the things that were recovered and when and where, and that's why Alan is going through them.
Just above the arrow, Your Honor, with the court's permission, maybe highlight or magnify the area just above the arrow.
Okay.
You see that?
Yes, I do.
Right underneath fire hydrant, correct?
Correct.
What does that look like to you?
Piece of plastic.
It's debris, correct?
Correct.
All right. Can we go back with the court's
No, he only
permission?
used the debris from 129.
87,
Okay.
diagram 3.
And he said it's not his fault. He's responsible for his opinion, and debris
Yes.
field is a huge part of his opinion. So if the DA didn't give him all the photos, it's on both of them, but it could change his opinion. So that's between him and the DA, but he should have the entire case file.
Fire hydrant's right there, correct?
Correct.
That's another, according to your scale, that's probably a good 30 feet from the pedestrian's final rest, correct?
Yeah, that's about right.
That is the furthermost, in this diagram, the furthermost piece of debris on the diagram, correct?
Correct.
So now, your testimony changed that this, in fact, is the area of impact.
No,
Why not?
because it's just a piece of debris. I'm talking about the path. You follow the path of debris field. Debris
Well-
can move and change.
The debris doesn't fly backward, does it?
I'm saying you pointed to like just the fire hydrant as the area impact where the debris, where that one piece of plastic was, saying that's the area impact is right next to the fire hydrant.
Are you asking me a question?
Yeah, that's what you said, right?
I'm asking you,
I'm making sure I'm understanding what you're saying.
That's what you
I
said,
can
right?
answer right.
Ask the question again, Mr. Jackson.
in fact, you indicated on Friday that your analysis of the area of impact was predicated on, based on, the furthermost piece of debris from the pedestrian's body that you were aware of, which is right there. Red plastic B, correct?
I said I said you said earlier with the linear equation. I mean, it might have moved it over more, but it's the debris, the start of that debris, and where that is. I can't say that's definitely the point of area impact or the point of impact.
You can't
I
or
just,
can't?
I cannot say that is the point of impact right there. You just kind of follow the linear path because they have to
You
follow
just
in
kind
a
of
direct
follow the path.
that way.
Okay, so now your testimony is that's not the area of impact.
I never said that was the area impact. I said it's after that.
Trooper, we were all here on Friday.
Okay.
It's exactly what you said under questioning by Mr. Lally, wasn't it?
Objection.
Sustained.
Didn't you
I don't know
say
why
on
that's
Friday
sustained.
that you determined the area of impact for Mr. O'Keefe, the point of impact was red plastic B because that was the furthermost piece of debris
Yeah.
you were aware of
That's what he said.
from the final point of rest from Mr. O'Keefe's body. Isn't that what you said?
I don't believe that's my exact words.
Okay, I'm not asking if it was your exact words. I don't
Isn't
know if
that your
that's-
conclusion?
I'm asking you, is that what you tried to impart to the jurors?
What I said to the jury, I said after that. That's the start of, that's last point of evidence that I had I said the area impact is probably along the roadway after that point. I mean, like before it, if you have to walk towards him.
I'm sorry, I keep doing that because I think you're done. Are you done?
I am done now, sir.
He keeps saying afterwards or before. Some of this is because of how loud it is in the courtroom with the AC units and the fans, which those in court have talked about quite a lot. So we will continue.
Now you're aware that there's a piece of debris, looks like taillight material, right under the fire hydrant, correct?
Correct.
If the area of impact, which you indicated on Friday was where this red plastic B is, you would be wrong, right? Your analysis would be flawed.
No, because that's not what I said. I said it's along the roadway, and it's going to be after that point.
Okay, so is the area of impact now where the fire hydrant is?
Objection.
Ask it differently.
Are you now indicating, because now you realize that there's a piece of debris directly under the fire hydrant, are you now indicating that that's the area of impact where John O'Keefe's body
I'm going to mute
was found?
myself and answer
Objection.
my husband real
Sistine.
quick because it's probably about coffee.
Let's take a look at exhibit, with the court's permission, 279.
Okay?
Taking a look at exhibit 279, I want to draw your attention to that piece right there, okay, of plastic. You see it?
Yes.
You describe it for me. Just physically, what does that look like?
It looks like clear plastic with a little bit of red and the black on the top part.
Okay, maybe in a triangular shape, is that fair?
Correct.
Okay. Now, if we could go back to, with the court's permission, exhibit 492,
Okay?
and highlight just above the ruler. How would you describe that piece of material?
It looks like the same piece.
Does that, based on that, does that appear to be part of the taillight material that was found at the scene?
Correct.
Okay. Now, based on that, are you now suggesting, if we could go, with the court's permission, if we could go back to 587, I'll stop jumping around just a second, I think we
Okay?
could just get back to 587. Oh, sorry, the diabetes.
Jan in the chat said, I'm grateful AJ is keeping the intensity and snark to a minimum. Yeah, it's not needed with
Now,
this
seeing
witness.
what you've just now seen,
This witness is backtracking from their opinion
plastic
in real time.
appears to be
So
taillight. Does that appear to be under the fire hydrant, which is highlighted? Same piece.
Yes.
Okay. Based on that, does that change your opinion? Is that now, the fire hydrant now, the point of impact?
No.
Where is the point of impact now?
It's along the roadway. I don't know the exact point of impact.
So you don't know the area of impact?
I said the area impact is along the roadway after the debris.
Okay.
I mean, only thing it would change, only thing it would change is maybe it's a little further away. But besides that, it's a linear field. I'm not talking about like one point. You kind of follow the middle of the debris field, and that should be the path.
Well, if the point of impact is along the roadway, where along the roadway, if you can show the jurors, where along the roadway, in your expert opinion, was the point of impact?
oh, the emphasis on the word expert.
It should be within, if you follow from the pedestrian's final rest here, just kind of follow it back.
Somewhere along there.
That's what I'm talking about, linear field.
You know what we don't know? You know what we don't know? We don't know what the victim's injuries were. So could he have been walking around? Could he have been walking towards the house to get help? Assuming this is what happened, that is an assumption. I am not saying that's been proven. But we don't know what movements the victim may have taken. So how can you say that final rest is from the collision when we don't know the victim's injuries? We have not seen an ME. We do not know if the victim, well, it's been alluded to that the victim did not have broken bones that would have prohibited movement in that way. Look, the DA could have interviewed this witness and said, where is the supervisor to make this decision? who has testified in court more, because this is not helpful and it's not going to go well.
So now you've indicated an area, if I can follow your laser pointer, an area along here, correct?
Yes, somewhere in there.
All right, if I have my spotlight, is that, if I leave it right there, is that about where the middle of the spotlight, about where you believe the area of impact is?
It's within, I guess you can say it's within that area. I don't know definitely. There's nothing on the roadway that has a definitive point that says this is the area impact right here. It's within the roadway based on the evidence at the scene.
Okay. Mr. Paul, sorry, Trooper Paul.
Along the
I'm
roadway
asking
within
you,
the evidence on the
based your
scene.
expert opinion and your conclusions,
Oh boy.
based on your full analysis, can you point me to within an area of 5 feet or so on the roadway where you believe the area of impact is? Is my spotlight basically highlighting the area that you believe, in your opinion, is the area of impact?
Do you have that laser pointer?
I do.
Why don't we let him show you? It'd be easier for the jury to see.
So what I'm trying to say is, so we follow the linear path back around this area.
Okay, can you?
And sorry, I'm trying to keep it straight as much as I can. Follow back to here. I can't say like if this definitely is, but it's possibly based on also vehicle damage to the back of the vehicle. So if you follow all the way back to here, that could be a possible area impact.
So when you say that area there, just I want to be very clear for the record that what you highlighted is an area basically just to the left of an X that's on the roadway, on the bottom of diagram 3, toward the lower part of diagram 3,
It's
correct?
you would use your circle almost kind of be a good area around.
Sorry, you need to.
You can use a circle around here. This would be around the area.
Okay.
Okay.
So using your scale, that scale is going from full left to full right. It's plus or minus 40 feet, right?
Switch. Can't see it. So say again. Say the question.
That scale is 40 feet, going full left, full right, 40 feet.
It's 40 feet. It's a 10-foot scale.
Okay, sorry, 20 feet. My mistake.
I was okay.
Eyes are terrible. 20 feet. Thank you. All right,
Jackson's
so
like,
use
I
that
just
scale,
can't
and
see
you
it.
estimate for the jurors. I'm just going to use this X as a starting point. You estimate for the jurors from this X that I've highlighted to the pedestrian's final rest. What's that number? It doesn't have to be exact. Give me an estimate.
So, I mean, it could be within 30 feet because I tell you this. Also on my scale, this 2 and 3 is 50 feet from each other.
Is how much?
50.
Okay.
50.
50.
So would you agree that from this X down here to pedestrian's final rest, as the crow flies, that's probably a good 35, 40 feet?
I mean, I could try to use the scale, but it is me as a scale.
If you wouldn't mind.
I can try to use the scale if you'd like me to use the scale. Yes, sir. That would be helpful to
please.
him.
Court's permission?
Okay.
Here's where the defense, well, the prosecution has this too. The defense and the prosecution have the reports
Thank you.
from the other accident reconstructionist,
You need a pen?
I got one. Thank you.
presumably federal. So they have the advantage of knowing what the others will say. This witness, though, should have also seen those reports. He's an expert. He's allowed to look at other expert witnesses' reports. And like we saw with the tech expert, who was able to say, these were the other experts' conclusions, and this is why I think they're wrong. This witness has not been able to do that, and I don't know if this witness can.
It's a little around. It's approximately 30 feet.
We're up approximately 30 feet.
That's what everybody just said.
Can you place, with the court's permission, can you estimate 30 feet in here?
Just to add some snark, I will say that it's appropriate that when Lolly asks what, if anything, sort of is the conclusion, that this witness is like, well, sort of this is kind of the answer. So I don't know if we get anything definitive. at all.
Can I
Can you point to a place in the courtroom that looks like it's 30 feet from you?
Objection.
No. Next question.
Does the court have a diagram of a diagram of distances?
In this courtroom? No.
Most courtrooms
indicated
do,
just
so you
now-
can say from the witness stand to the back doors or whatever is this far. So most courtrooms you can do that in.
And then I'm finished with this. Thank you, Mr. Bates. You indicated just now, in answer to Mr. Lally's last couple of questions, that in
Real
your
Happy
opinion,
33 said we're in court though, sort is not acceptable. I agree with you.
the SUV struck the pedestrian, John O'Keefe.
This is where we're at.
Quote, projected forward and to the left,
Bananas.
the front yard to
Jackson.
the place of rest.
Alan, can you please go back to the microphone for the love of the stream? The chat would like to hear your questions.
Yes.
So your expert testimony is that John O'Keefe was hit with the SUV and flew 30 feet.
Projected mean like I don't say he flew all the way there. He was projected in that way. He got pushed forward in that direction.
Which, if he was rendered incapacitated,
We don't know that.
landed there, he'd have to sort of fly there, correct? Didn't walk there.
We don't know that.
Would you definitely flying like literally off the ground the whole entire time? Or,
Well, you tell me, you're the expert.
I mean, when we say projected, we mean he gets projected and they usually have a landing phase and they land and then they either roll or tumble to final rest.
Okay, how far do you think he landed? How far was it until he landed of that 30 feet?
I don't know. There's no indication of where his exact landing spot was.
Right. Was there any evidence whatsoever that he landed and rolled?
And there was no evidence that he landed or rolled. Or no, rolled.
According to you, the evidence that you have in front of you is that you get hit, fly 30 feet, land where he ended up in his final rest, right?
Objection.
Sustained. Ask it differently.
Based on
It's
your
a fair question.
expert opinion, you believe that he was projected through the air to his final rest place.
That's not what I was saying.
But you said there's no evidence that he rolled.
And there's no evidence that he flew through the air either.
So how'd he get there?
Exactly. Right? Exactly.
Objection.
Sustained.
You said on Friday that in your experience, people tend to lose objects that are not strapped to them. Is that right?
Yes.
In other words, get hit by something, car, truck, bus, whatever, train, and if you have something in your hand, boom, you lose it, you drop it. If it's not strapped to you, correct?
So how was the
Correct.
victim's phone and cup still with him?
How do you suppose that Mr. O'Keefe, in your opinion, held on to that glass cup that was found right next to him over the course of 30 feet being projected?
Objection.
I'll allow
That's
it.
a fair
You have
question.
Mary on that?
I don't know. I mean, it just could have been with him the whole way. I don't know. I wasn't there, so I don't know how the glass stayed with his body and went with him to the final rest.
So I mean, it's just common sense. You have to believe that if it was in his hand, he held on to it the entire time he was being projected 30 feet, correct?
It could have been in his hand. It could have been tucked next to his clothing. Did
you say tucked into?
I mean, like, could have been next to his body. So when he projected, maybe the glass was with his body as it was also flying. So there's
We're back
a
to
number of reasons
flying.
why the glass, because it also got projected with the body
Well,
while he was holding it.
I thought you said on Friday, and you just agreed with me, that people drop things
Yeah.
when they're hit.
Yes, body not everything it tends to fly off. I mean, some stuff flies off, some stuff will stay on.
Shoes. Shoes are going to fly off.
It's not uncommon to find piece of clothing and stuff, that you find at the scene.
Piece of clothing.
Like clothing, like shoes, like shoes and stuff like that to come off the body during a pedestrian crash.
Well, that's not what I asked.
I know, I'm just saying, you asked me, you said what I'm just responding to what you said. And trying to make sure you understand what I'm saying.
No, I don't, but I'll
Yeah.
ask another question. Shoes are strapped on. by
Nobody
definition.
objected to that, Snark. I don't even know if they called
Yes,
it.
but it's very common for shoes to come off.
How about a cell phone?
Cell phone, yeah. Yeah, it depends. Depends on where it is.
Well, it was under his body.
Okay.
How do you account for that? He held onto a cell phone with one hand and held onto a cup with the other.
Objection.
Sustained. Ask it differently.
If a cell phone was found under his torso, under his body. What's your theory on how that cell phone ended up flying 30 feet with him?
It just did.
It just did.
And somehow,
That's your
as he
answer?
landed, tucked that cell phone underneath his body, so he landed on top of it.
You're the expert.
It just did. That's the evidence at the scene. I didn't put the evidence there. So
Well, you didn't.
Objection.
All right, so jurors,
Oh,
I've told you
shit.
before, lawyers cannot make.
Alan's gonna get himself close to getting fined. That is too much. I'm gonna back this up. At some point, the judge is going to fine him. It's a lot of comments that are really inappropriate. And though from us sitting here, the snark is hilarious, it's not appropriate. And she is going to have to rein it in. If the prosecution did even half of this, Alan would be asking for a mistrial. There's no need for it, though. It's so clear that this witness's testimony is just like, I don't know. There's no need. It is not court appropriate.
Somehow, as he landed, tucked that
I
cell
backed
phone
it up. Don't
underneath
worry,
his
Chad.
body,
We're gonna-
So he landed on top of it.
We're not in court. We're going to relive it. I'm just letting you know. Any of you that are like, I want to become an attorney, don't do this in court. You're going to end up getting fined. Or just get out your checkbook and report yourself to the state bar and just roll with it. But there are rules. There are rules.
it just did. That's the evidence at the scene. I didn't put the evidence there. So
Well, you didn't.
Objection.
All right, so jurors, I've told you before.
So this trooper said, that's the evidence at the scene. I didn't put the evidence there. And Alan Jackson said, well, you didn't. I don't think he can help himself. The jury might not have heard him because Alan is just like, well, you didn't. And that's the court and the DA at the same time were both, okay, jurors, this is inappropriate. And the court is going to admonish him. I'm going to let it play now, this time, third time.
Just did. And somehow,
Live
as he
replay.
landed,
So
tucked
fun.
that cell phone underneath
when
his
court
body,
casting.
So he landed on top of it.
it just did. That's the evidence at the scene. I didn't put the evidence there. So
Well, you didn't.
Objection.
All right, so jurors, I've told you before, lawyers cannot make comments, so disregard it. Mr. Jackson, don't do it
I
again.
understand. So in
You
one hand-
understand, but don't do it. Your answer's always, I understand. Don't do it.
Yes, Your Honor. Cell phone in one hand, cup in the other hand, flew through the air. Right?
Objection.
Sustained.
I imagine everything from now on out will be sustained. I'm just gonna take a guess real quick.
You were informed of this incident on January 29th, 2022 at about 2:30 in the afternoon. Is that right?
yes,
At the time, you were working out of the CARS facility, which is located on West Grove Street in Middleborough. Is that right?
yes,
By the way, that's a facility that has multiple garages. Sally ports, I don't know if they're called Sally ports, but garage bays, correct?
the mechanic shop are there.
The mechanic shop
Yes,
is, if you're going to review, for instance, for
Oh, the reason that everything is going to be sustained is the judge is not going to give him any leeway at all. And if it's a close call, it's just going to get sustained and he's going to have to rephrase. Because the judge, Jackson has kind of broken his trust with the judge to adhere to the rules of court. So the response to that is going to be to continue to narrow things down. That's what's going to happen based on his behavior. So Jackson he's like, whatever. I don't think he can help himself, but it's wild.
purposes of reconstruction, if you're going to review a vehicle, is the vehicle placed in those mechanics bays?
no, not there. That's for state police vehicles.
Okay, so where are the mechanics bays, sorry, reverse that. Where are the Sally ports where you would do your analysis, your reconstruction, your review of the vehicle, inspections, things of that nature?
We don't have Sally ports for that.
You don't have anything dedicated to that?
No, the only time we would use a Sally port is the crime scene would have some Sally ports that they would do to document their crime scene stuff. And I've gone there, they've done my inspections, but most of our inspections are done
You don't?
either at the tow yard or some type of facility for that.
Ultimately, was this
I would imagine the reason most of their inspections are happening at the tow yard because most of the collisions they're dealing with, cars are completely totaled. Some of the police departments that I worked with, because I did a lot of vehiculars, which is part of why this is probably hurting my head. I did a lot of vehiculars during a portion of my career, and a lot of those accidents, the cars were so incredibly damaged that the tow yard was really the only place to put them, and that's where they would be inspected from. So that doesn't surprise me that they are also inspecting them from tow yard. That's not completely uncommon. So this vehicle is probably one of the least damaged vehicles that his unit has ever dealt with. Normally those vehicles are crumpled substantially, and then you are dealing with all the rest of it. So I imagine they are not dealing with many vehicle collisions where the vehicle's minimally damaged.
SUV ever taken to the Middleborough facility?
Yes, it was.
Where was it placed?
There's a fenced in area inside it's a fenced in area
Is it outside or inside?
outside.
Okay. Did it remain outside in that fenced-in area the whole time?
I don't know the exact time. It was there for a while, then it got moved.
Where did it get moved to?
I'm not sure exactly where they moved it immediately after it left Middleborough.
Are you familiar with the Foxborough location at MSD?
Yes.
Does that have Sally ports or bays for inspection and evaluation?
It has garages in it, but we wouldn't use them. We don't normally use those garages for inspections.
Is it possible to use those garages for inspections?
It is possible.
Okay. It's happened before, correct?
I've not used the inspection in the garages.
But it's,
I'm going to ask you to keep your voice up and
Sorry,
speak
yes.
slowly.
but you know that it could be used.
Sorry.
You know that those bays could be used for inspections or analysis or evaluation if needed, correct?
Yes.
All right. Given the fact that the SUV that was being seized on January 29th was being seized as potential evidence, best practices would suggest that you'd want to get it in and out of the bad weather, the inclement weather, as quickly as possible, correct? You wouldn't want to subject it to continued forces from
I think
nature,
that's why
like
they took it
rain,
to
wind,
Canton.
Snow, sleet, hail, right?
That would be beneficial, yes.
All right.
He's going to say Foxborough's
You're aware
closer.
that the Foxborough location and the Middleborough location with the mechanics bays are all closer to Dighton than Canton, right?
Both Foxborough and
Foxborough and Middleborough are both closer to Dighton than Canton. In other words, you have to pass by, depending on which way you
Sir?
go, pass by Middleborough, pass by Foxborough to get to Canton.
Aren't the roadways like your thing?
so from where?
From Dighton.
Sorry.
So from from Dighton.
Where the vehicle was seized in
Yeah.
all going toward Canton.
Sir,
pass
you are a
by either
challenge.
Middleborough or Foxborough to get to Canton, right?
I don't believe you'd pass by Middleborough to get to Canton, but you've passed by Foxborough.
All right.
Are they both closer to Dighton than
The car
Canton?
was not taken to Foxborough, was it?
No.
As a matter of fact, the car was taken basically double the distance all the way to Canton to that Sally Port, correct?
Objection.
Do you know that? Is that double the distance?
I don't know the exact distance. I know it was in Canton.
And you know it's farther to Canton,
From Dighton, yes.
right?
For those of you
also
asking if
aware
this
that
witness is purposely
you've been to the
being
scene.
obstructive or obtuse,
Correct?
I don't think so.
For Fairview.
Yes. Yes, I have.
And you've been to Canton.
I think he doesn't understand.
Yes, I have.
You know that those two locations are about 3-4 minutes apart.
Yeah, I can say that.
And for all of you
You
curious,
started-
this morning I got a shiny Sudowoodo in my Pokemon Sleep game. That's exciting.
Let me ask this a little bit different way. Before you began any review on this case, any physical review on this case or analysis on the case, you were told that there had been a crash, correct?
Yes.
You testified to that at the state court grand jury in this matter. Is that right? That you've been told in advance this was a vehicle pedestrian crash and you were asked to analyze it, right?
Yes.
You wrote in your report that it was a single vehicle collision involving a pedestrian and you were, quote, assigned to reconstruct that collision, correct?
Yes.
So when you began your analysis,
Right. The conclusion had already been made. Not, hey, can you take a look at this car, this victim, this debris, and tell us what you think happened? Which is a better approach. Versus, hey, this is a vehicle versus pedestrian. Do you agree? It's not the same.
Trooper Paul, you were told conclusively by the lead investigator, Michael Proctor, that the deceased was hit by a car and your job was to reconstruct it. Is that right?
Objection.
Okay, so there are lots of parts to that. Break it down.
Sure.
That's common.
Were you told by Michael Proctor to reconstruct this incident?
Objection.
So were you told that by Trooper Proctor?
I was not.
Okay,
Were
next
you
question.
asked that by Proctor?
Who were you given your instructions by
Instructions for what?
to reconstruct this incident?
I wasn't given instructions to reconstruct it. It's just I was assigned to it.
Right.
That was requested. My assistance was requested to reconstruct it.
That's my question. Who assigned you to it?
I talked to my sergeant at the time who gave me the phone call.
And you were told some basics about that reconstruction.
Who talked to
that-
your sergeant?
The event that you were asked to reconstruct, correct?
Yes.
The information that you were told came from the case officer. Is that right?
Who's the case officer?
The information that this was a pedestrian vehicle incident, as opposed to motor vehicle incident.
And now I can't tell the difference between whether he doesn't get it, can't hear, or is being
You were told it
obstructive.
was a motor vehicle pedestrian incident that you were asked to reconstruct, correct?
Yeah, I was told that. Yes.
All right, and you had to be given some basic parameters of how that incident occurred. The car was going in reverse, it's got a damaged taillight, things like that.
Some basic stuff. Yeah.
What I'm trying to get to is, who gave you that information? Where'd it come from?
His sergeant.
That the car was traveling in reverse. Like which part of the information? You asked me at several different things just now.
Were you given information from multiple sources?
So you're not going to win this interaction. Just
Or did someone give you a summary of what you were being asked to do? At the very beginning,
Yep.
who gave you the summary?
Summary of the whole entire.
oh my
what?
God.
Of the event that you were asked to reconstruct?
I was passed down when I got to the garage. That there was nobody that sat there and gave me the summary like that I can remember. I was told that it was a pedestrian crash. I knew it was a Boston police officer involved. That this was the vehicle, and that it was traveling in reverse. That's all they had.
Okay,
That's a summary.
what I'm asking is, that's great. Thank you for the summary. Who gave you that summary?
I don't know if it was definitely anybody from the get-go that was like I talked to.
Who told you shit? It didn't just materialize out of the ether. Who told you?
From where?
I don't know if it's anybody that I could definitely say that was the person. There was multiple people going around when I got there. I think I talked to Trooper Zach Clark. He was doing the crime scene. I think he was Zach Clark. He was the crime scene photos at the time. I knew him from past crashes. He just said this is the vehicle, and I think he kind of gave me a little bit of a lowdown on.
You got a lowdown of what happened from the person taking photos of the car?
What the vehicle was.
Okay.
So
My question is this. When you got that, did you call it a lowdown? He gave you the lowdown?
he gave me information. Yes.
Right.
He did
You
say
got
the lowdown.
You were
Not
told
funny, Trooper.
Boston police officer was involved. The vehicle pedestrian incident. Car was going in reverse. Ultimately led to the death of the pedestrian. Struck the pedestrian in reverse, correct?
Correct.
All right. And you were assigned specifically to try to reconstruct that incident.
Yes.
Have you ever heard of the phrase confirmation bias?
We have
I know the phrase, yes.
You know what it means?
I can't definitely say what it means.
Developing a conclusion and then trying to find evidence to fit that conclusion. Does that sound right?
If you say so.
You noted
If you say so.
in your direct examination that there were scratches on the passenger side rear bumper of the Lexus, correct?
Yes.
How exactly were you able to scientifically determine that any of those scratches were from an incident on January 29th, 2022, as opposed to any other time?
I didn't have anything else on the time. Is that those scratches happened prior to this collision?
I'm sorry.
I didn't have any information that those scratches
Happened
were
prior.
caused from a prior collision. And so when
Couldn't they have just
when
come
I
from
looked
other
at the
stuff?
evidence, I knew it was in that same area, the right rear tail light. So when I looked at it, it didn't quite fit the pedestrian thing. So when you showed me the video,
It didn't quite fit the pedestrian thing, is his expert testimony. Sir, the pedestrian thing, so they told you it was a motor vehicle versus pedestrian, and then you were now looking for explanations of what would fit or not fit the pedestrian thing. I'm so glad these questions came after the confirmation bias questions, because look, the less defensive this trooper is with Jackson, the worse he makes things for himself, because the more he talks, the worse it gets. It didn't fit the pedestrian thing. How are... I have never seen expert testimony quite like this. Spiegel's was weird in a different way, but wow. Just wow. Just, yeah, yes, chat. I needed code confusion, but Code Red's gonna have to do this morning because it didn't fit the pedestrian thing. That for me is where we're getting to what the fuck is happening. So for those of you that are new to the chat, hello. Code Red is our code DEFCON what the fuck. If you are flash sensitive, it is flashy until the music ends, and we are going to DEFCON Red in 3, 2, 1. What the fuck? Didn't quite fit the pedestrian thing.
so I saw the video like a year ago on Court TV. I said that could be.
You asked the question, so next, keep going.
Jackson's trying not to open the door to the video from the two cars hitting each other. And he might have just. Hold on.
Happened prior to this collision.
Were from an incident
All right. He's talking about this. Jackson's asking about the scratches on the Lexus.
on January 29th, 2022, as opposed to any other time.
I didn't have anything else on the time. Is that those scratches happened prior to this collision?
I'm sorry.
I didn't have any information that those scratches were caused from a prior collision. And so when I looked at the evidence, I knew it was in that same area, the right rear tail light. So when I looked at it, it didn't quite fit the pedestrian thing. So when you showed me the video, I saw the video like a year ago on Court TV, I said that could be.
You asked the question, so next,
I
keep
did.
going.
It's not responsive.
He's answering. Next
trying to-
question. Then
You guys
go
have
ahead.
scientifically
Hold on.
thought the scratches were.
Hold on. Ask a
Sorry.
question, Mr. Jackson.
You know what normal wear and tear on a vehicle is, right?
Yes,
Bumpers get scratched myriad ways, correct?
correct.
When I saw the video a year ago on Court
Goes to a
TV.
store parking lot, right?
Yes,
Shopping cart can bounce off the back of the car.
A bike,
scratch the bumper, scratch the
putting
side
bikes
of the
into
car.
cars, out of cars.
sure.
I mean, I don't want to go through it, but there's thousands and thousands and thousands of ways that a car can get a scratch, correct?
Correct.
My question is, do you, as you sit here, do you have any scientific evidence that those scratches occurred on January 29th at approximately 12:45 a.m.?
What do you mean by scientific evidence?
Well, do you have
Evidence
any evidence whatsoever that you
that
can
is
point to
sciency?
that those scratches occurred on that date and at that time, rather than any other time in the history of that vehicle?
Like I said earlier, the video seems to appear that's what it looks like that could have been from.
Well, you said on Friday, let's talk about those scratches for a second. Because
Okay.
when you testified Friday, you were pretty clear. You said that, if I can find it exactly.
This is so bad. It's just so bad. It's just so bad. It's so bad for so many reasons. I am zooming.
Quote, the dent and scratches for his hand could be, those are consistent with striking the Lexus. Remember saying that?
Yes, on the tailgate.
I remember him saying that.
So, the dent and scratches you talked about on Friday, you said were from his hand.
Yes, hand in the glass cup.
Okay. Then, are those the same scratches you're talking about in terms of the bumper?
No.
No.
So,
What are you talking about? The scratch inside the bumper that we've been talking about?
correct.
Okay.
That's what I'm
No.
talking about.
He's talking about the tailgate.
Is there any way to scientifically date a scratch?
No.
If you go out in the parking lot right now, even as an accident reconstructionist, you walk out in the parking lot.
Actually, if there's rusting, it can help give some indication. It just depends on the type of scratch, because wear and aging and rust can play a factor. And it also, some scratches leave like curled indicia of scratching. Some scratching leaves paint transfer. Like, there are a lot of ways to know if it's really fresh or not really fresh, but okay.
Right now, look at a Toyota Camry sitting there. It's got a scratch on it. There's no analysis that you could engage in to date that scratch, could you?
Objection.
So you can ask it differently, Mr.
No,
Chair.
plastic doesn't.
Is there any way
But
that you could, in
Some
engine,
cars do.
look at a scratch and say, that scratch is from such a
Jackson's asking about all scratches always in general, not just the Lexus. So I would think a complete answer would be, well, in some cases, there is all of this. In this case, there is this. But he's not answering like that. Jackson's asking for all scratches in the history of the universe.
such date.
Objection.
I'll allow it.
Nothing more.
I'll allow it.
You cannot say. You can look at evidence and shows that it may have been older than what the newer evidence would be, but there's no way to say that specific date and time and that a scratch would come from.
Right.
Right. Some things say it may be older.
That any or all of those scratches on the Lexus could have predated January 29th, correct?
Well, there
No.
wasn't rusting on the damage to the tailgate.
The ones that are on from the taillight and the other parts of it
Scratches anywhere on the car?
depends on what you got to pick the other scratches. You got to show me other scratches on the car.
I'm saying it's possible, since you can't date the scratch, it's possible that any or all of those scratches could predate January 29th. It's a simple question, right? It's possible.
You're being pretty broad on your scratches here.
I'm not being brought it. Let me ask it a different way. Let me ask it again. Is it possible that any or all of the scratches that are noted on that car predate January 29th?
Any and all of the scratches? See, that's what I'm saying. You're being pretty broad. Any and all scratches on the car
Answer that question. If
that it
it's possible.
predate.
Objection.
I don't know every single scratch on that car. I could mean
Overruled. So can you answer that question?
no.
You testified that you
Go
noted
picture by picture.
glass on the rear bumper of the SUV, correct?
Yes.
And
Rob,
you
I'm with
said
you.
Something about that glass coming from the cup.
Correct.
You also said that you did not see anything on that SUV that could be the source of those glass pieces on the bumper, right?
Yes.
when you did your reconstruction and your analysis, were you informed that none of the glass pieces, not one of them,
It came
would
up.
match to a cup?
It came up.
I don't know anything about that. I don't know that.
So if you knew,
So you didn't read the case file. They're asking about the glass on the bumper because he said the glass on the bumper indicates that it came from John O'Keefe's hand, but we know those aren't a scientific match, that the glass on the bumper and the glass from John O'Keefe are not the same. And he said definitively the glass on the bumper did not come from the damage to the Lexus. It came from the victim.
that the glass pieces on the bumper do not match the cup. Does that change your opinion
Objection.
about that glass?
Can you answer that question?
I cannot.
Hey, B.
You can't answer the question.
Worst witness ever.
It's what was told to me as evidence
Got it. By whom?
Not credible?
by the crime scene.
Just bruh.
Who told you?
As crime scene that was there, it says it's glass from the cup. When I did my initial inspection, that's what it was on from.
That's not what you just said. You said that's what was told to me.
Yeah, by crime. No, yeah, I can see by crime scene. While I was at my inspection,
Wait, what?
it was told to me by the crime scene when I was at my inspection, at the initial inspection.
So what you meant by that's what was told to me is the crime scene talked to you.
Yes.
Crime scene say anything else?
I don't know what else you want me to say.
Did Trooper Proctor tell you that those pieces of glass
Somebody told him.
are somehow associated with the cup?
Somebody told him.
No.
Somebody told you.
Just the crime scene told you.
Correct.
But if
I
you-
think he means the crime scene tech that was taking the pictures that told him about the other stuff. I don't think the crime scene in general spoke to him. I think he means the crime scene technicians. But we'll see. No, I know. He keeps saying crime scene.
crime scene was incorrect, and in fact, those glass pieces don't match the cup, did that change your opinion?
Objection.
Sustained.
Why is that sustained?
Would it change your opinion in any way if you knew that the glass pieces do not match the cup?
Objection.
I'll allow that.
That's in evidence.
No.
Why not?
Sorry, no, you.
I don't. It's glass from a cup. It's glass. It's not. It doesn't belong to the vehicle.
Right,
It's glass.
So,
but if I told you it didn't match that cup,
What,
change your opinion.
Objection.
Does that change your opinion?
are we talking? Which cup are we? We never established which cup we're talking about.
How many cups have we been talking about, Trooper?
You said that cup. One at the, from the scene.
earlier I thought he just didn't understand. We're not there any longer. We have moved on from I just don't understand to I'm just not answering the question, which I don't think is a good look for an expert. If you're an expert that knows your shit, it's not hard to answer the question.
Okay.
That cup, I'm talking.
I just want to make sure that we're on the clear path here.
We're not.
Clear-
We're not.
we're ta-
No. What we're the fuck not on is a clear path.
Talking about.
Absolutely.
Okay.
Really sure.
All I said, it's
It's found next to John O'Keefe's body.
We're not
in
talking about the red
snow
Solo
at
cups.
34 Fairview
For the moment.
on January 29, 2022. You got the cup in mind?
yes.
Okay. That's the cup. When I say
Now
cup,
the snark.
that's the cup.
Okay.
Would it change your opinion if I told you that the glass pieces on the bumper don't match that cup?
What's my opinion on it? All I said was glass from a cup. That's the only opinion I had. It's glass from a cup
was
that
a
was on a
fa-
bumper.
It was part of a factor of why you considered this as a collision with the victim. It was one of your factors. He's like, what's my opinion on it? It's glass. But it's not that glass. So could the car have fucking hit something else that had glass? And maybe that glass came from whatever else the car hit, because there is glass in the street and glass on the bumper that don't match the glass the victim had in his hand. So where's the other glass from? Thanks, darling. Where's the other glass from? There aren't enough goat screams in the world this morning. The court reporter is asking him to rephrase.
A cup. A cup. It's not glass from the car.
Could it be glass from another car?
That was my opinion on it. I didn't never said it matched to the scene.
You didn't.
I never said that in my thing. I said it's glass from a cup.
In my thing.
Okay.
How do you know it's not glass from another
You
car?
didn't do any testing to determine the forces necessary to shatter a taillight on a 2021 Lexus 570, correct?
I did not do testing.
He has just.
Your report indicates.
He is not
we
good at
talked
his
about this
job.
a little bit. I'm going to go back to something we talked about earlier this morning. Your report indicates that John O'Keefe came to his final resting place about 7 feet from the roadway. And that's
I'm
what
having a
you
hard
based your
time
diagram on.
hearing AJ.
Yes.
Who told you that number?
I measured it from my diagram.
You should say that again.
I measured it from the diagram.
You determined how far the victim was away from the curb on your diagram by measuring your diagram? So then why did you put the victim where he is on the diagram then?
Okay, what I'm asking is how did it get on the diagram? In other words, who
Oh.
told you that his body was 7 feet from the roadway?
Well, wait, I was told by Lieutenant, was it Gallagher, Paul Gallagher, Cat PT. He told me this is where the body was found. Okay. So I used my devices to mark that location.
He used his devices.
But before you used your devices, he just pointed someplace on the ground and said he was about here, correct?
That's correct.
Did Lieutenant Gallagher tell you that Lieutenant Gallagher never saw John O'Keefe in place at the scene? Did he say that?
No.
Right.
Did Lieutenant Gallagher tell you that the first officer on the scene estimated his body at being approximately 15 to 20 feet from
Right.
the roadway?
No.
If he had told you that, then it changed your diagram?
Objection.
No, that's a fair question.
He told me this is where he was found. I marked that location. That's all.
That's not the question. The question is if Gallagher told you that the first officer on scene had a difference of opinion about how far away from the roadway the victim was, would that change your opinion? Remember back, chat, just take a breath with me. Remember back to when they were doing the retrograde extrapolation expert from the lab, and they said, if this number changed, would that change your whole opinion? And the expert's like, yes, that would change my entire opinion. We should be there here with this expert. If there's new information, does that change your opinion? Or was your opinion so predetermined that no information changes it? That's what Jackson's getting at.
All that was.
And you marked basically every other piece of item. Sorry, that's a terrible question. Every other item you marked
This is
based on a
wild.
distance from where you were told John O'Keefe's body came to rest, correct?
Yes.
Right.
And that was by Lieutenant Gallagher just pointing at the ground and saying it was about here.
Correct.
Right.
Was there a single member of the team that was out when you were being shown where the body came to rest? Was there a single member of that team who actually said they saw John O'Keefe's body in place?
Objection.
I'll allow it.
He's the expert. He's allowed to rely on hearsay. Hearsay's not
what do
the
you mean
thing.
team? Canton PD?
Whoever was there, who was there with you when you started doing your?
Did anyone who actually saw the victim on scene tell you where he was? Because we know the answer is no, but he wants the jury to hear that the answer is no.
Your measurements, et cetera.
I
Or Fairview.
said Lieutenant Gallagher. That too.
Just you and him?
And myself and I was training a trooper at the time. She was there.
You were training.
Trooper at the time?
Yes.
Okay, so it was just, my mistake. I assumed that there were several people out there. Just you and Lieutenant.
Run.
Yes, that's why
Trooper.
I was confused by the team.
All right. And again, Lieutenant Gallagher didn't tell you that he never saw John O'Keefe's body in place.
No, I don't think so.
did document in your report that the items that you noted on.
I know
your
we're
diagram-
not done, but chat, for all of you that are so frustrated, please keep in mind Trooper Proctor's text messages that said the night of the 29th, she hit him with the car. This is all happening because everyone was just like, she hit him with the car. So yeah, the victim was somewhere over there. She hit him with the car. Yeah, there's pieces of taillight all over the place because she hit him by the car. She hit him with the car. Everything in this investigation that you are seeing is because they all decided she hit him with the car. And that's kind of the defense's point. Because now, even if she did hit him with the car, I don't know if we have credible evidence to prove to the jury that she did that. I'm going to try to gain this up one more time, but the audio is difficult today. And I don't want it to start peaking because it hurts everybody's ears.
Looked at a few minutes ago. Those were found by the CERT team, correct?
Yes.
It's me. It's me. I did this.
And you indicated in your report that the members of the CERT team located
Sorry.
a single Nike sneaker that's noted on your report. Is that right? On
Correct.
your diagram, rather.
Yes.
You also indicated that, quote, in the same area, 2 red plastic pieces and 1 clear piece of plastic of a taillight was discovered.
Yes.
So your report is clear that in total, the items discovered by the CERT team on January 29th were a shoe, right?
Yes.
A partial glass cup broken, correct?
Well, it was that on there. I can't remember if that's on their diagram or if that's what's I was told at the scene, but yes.
Sure.
Yes.
You knew that a cup was found?
Yes.
Or you were told a cup was found?
Yes.
And 3 pieces of plastic, 2 red, 1 clear.
Yes.
Not 5 pieces of plastic.
That goes back
Correct.
to Tully's report saying 3, but the evidence
You
bag
didn't
saying
measure
5.
those items, is that right?
I didn't. What do you mean measure them? Like
Measure
at
them
this?
relative to John O'Keefe's final place of rest. 10 feet from it, 12 feet from it, we're gonna go over those numbers.
Yes, I used their report to place those items onto my diagram.
So, and I'm gonna get to that question in just a second. I wanna make sure that we walk through it sort of.
That's the
methodically.
issue.
You then
He was using Tully and Cert's report. Remember, Tully's report said 3 pieces of plastic, but the evidence bags showed 5. So even Tully's report wasn't complete. So he's relying on Tully's report, but Tully's report has information that's not in the report that's only on the evidence bags. Do we see the problem?
use some calculation, some
Isn't supposed to
tools
go like this.
Measure distances. Like there's where I assume John O'Keefe's body was. Here's a final rest place. I'm going to use that as
There's
point
too many
A,
assumptions
and
to
I'm gonna
base a
measure from
conclusion
there
off
and
of.
go 7 feet to where the shoe was found, or the first red plastic piece was found, or whatever, right?
Yes.
Who told you where the pieces were found?
They were in Lieutenant Tully's report. He put measurements in his report.
Okay. And
Tully
you
said
noted that the shoe was 9 feet.
that his evidence bag
Yes.
is more accurate
Back
than
in
the
your
report
diagram.
in
Correct.
his cross.
You noted that the glass cup was 1 foot from John O'Keefe's body, correct?
Correct.
1 foot is about that long, right?
I'm trying to finish
Yes, it
my
was,
greens
they
so I
basically
can
said
get
it was,
to
it was
coffee.
found next to him.
Right.
Yes.
A piece of red plastic 7 feet from John O'Keefe's body, correct?
Correct.
A clear plastic piece 10 feet from John O'Keefe's body, right?
Yes.
And a red plastic.
Spicy Cat, this is the accident reconstruction expert on the stand. So when you're saying, did nobody try to recreate the accident? No, they just tried to say, well, this is how what you told me happened. I imagine when we get to the federal experts, we're going to see their testimony tomorrow. It's going to be, I imagine it's going to be different. I imagine it's going to be a lot different. But that's for tomorrow.
Piece 12 feet from John O'Keefe's body, correct?
Correct.
What part of his body were you measuring from?
Like center of mass.
So he's 6'2".
Yes.
Did Lieutenant Gallagher tell you where his center mass was?
No, I measured from, he just said he was here, so I tried to put like where his head, where his feet, and try to measure the middle between those two.
So ultimately, because Lieutenant Gallagher was not at the scene when he was found, Lieutenant Gallagher had to sort of guess where the body was found, correct?
Objection.
Sustained.
Calls for
You had
speculation.
no photographs of John O'Keefe in place, correct?
Correct.
There were no establishing shots, and there were no perspective shots, correct?
Correct.
There were no relative shots, meaning this is relative to that, and I can measure that and figure out distances, correct?
AJ,
What,
get
like
back
from
to
the picture?
microphone.
Yeah, so you know how that's done in science, right? You want to find out a relative position of something, so you take 2 or 3 or 4 shots. You know that something is never going to move, like, I don't know, a flagpole. You can measure from there.
Sure.
You get cross coordinates, right?
Right.
Sure.
Left and right, and where the 2 coordinates match, that's where the item is, right?
Be
Correct.
so
None of that was
good.
done, right?
That was done.
From the pictures,
None of that was done
Ever.
to do your measurements.
I use, like I said, I used the measurements from, measured on my diagram in itself, and I measured from those points off my diagram.
Right, but the starting point was a guess, wasn't it?
Objection.
Sustained.
Did you have to sort of guess at where you thought John
Sort of.
O'Keefe's body was?
I didn't guess where his body was.
Did you guess at his center of mass?
Yes.
Objection.
Did you guess?
I did not guess.
Next question.
He measured based on a guess.
You stated in your report that you Google mapped Miss Reed's path of travel. Well, let me ask a different question. If I could withdraw that question with the court's permission.
Yes.
Withdrawn.
Your diagram has all those arrows pointing at specific locations. Very, very specific, very thin arrows point, correct?
Yes.
If you start off with an incorrect assumption about where John O'Keefe's body was, right? Hypothetically, if you were to start off with an incorrect assumption where John O'Keefe's body was, every single item that you note on that diagram would then be off as well, wouldn't it?
Objection.
Yeah.
Is that true?
Yes.
I mean, I guess hypothetically, depends on how off you want to be.
But the answer is yes, correct?
Hypothetically.
You stated in your report.
Sir, if the information given to you is not good, then your measurements aren't good. That's not necessarily on you, but it's data. So if it comes in wrong, then everything you're doing is wrong. The answer is yes. That no one's blaming you, but that's just a fact.
Report that you Google mapped
Hypothetically.
Miss Reed's path of travel on January 29th based on what you determined to be, quote, it's likely the two, and you said that it's, quote, it's likely that the 2 events, meaning the triggering events.
Oh my God, Alan, that's a
occurred
terrible
at the same
question.
time the Lexus was at 34th Fairview at the time of the collision, correct?
Yes.
The first triggering event was what? Was it a 3-point turn or a U-turn? I thought I heard you say both.
I guess it would be more, 3-point turns, essentially, I guess it's a 3-point turn.
Okay.
Yes.
Not a
But
U-turn.
Did you say U-turn on Friday? 'Cause I could've
He
sworn I
did.
heard that.
It could have been a U-turn. I mean, it's still turning around. So you had to make a U-turn when that's a 3-point turn or not, but it's still.
Okay, but I mean, not to be picky, but sort of my job.
Okay.
A U-turn is traveling in one direction,
He uses them synonymously.
right? Turning the wheel, never changing gear, since it's reverse or anything, just turn it, right? A 3-point turn requires moving forward, stopping, changing gears.
Excuse me, Alan, did you ever think you'd be in court explaining the difference between a U-turn and a 3-point turn to an accident reconstruction expert? Ever? Like ever. Also, I'm going to watch him as he walks backwards because he is now just demonstrating how ridiculous this is.
Moving backward, stopping, changing gears, using a steering input, and then moving off, correct?
Correct.
Well, those are 2 very different maneuvers, right? You agree?
It's, in a sense, I was trying to say she made a U-turn. Like you can say they made a U-turn. it's a 3-point turn. They're still making a U-turn, and I didn't mean it as like she literally had to make a direct U-turn. She was turning around, and obviously the diagram or the trigger shows a 3-point turn.
Well,
Then why didn't you say a 3-point turn?
I mean, I guess you could have said reversing direction, right?
That could be a better way to say it. Yes,
You didn't say that. You said U-turn. So are you changing your testimony from Friday that it was a 3-point turn, or could it possibly have been a U-turn? Just,
it's a 3-point turn.
okay, because you have evidence of the starting, stopping, changing gears, reversing, stopping, changing gears, turning.
That's
Right.
correct.
Okay, so when you said U-turn, that was inaccurate.
Objection, Your Honor.
No, it's inaccurate.
The objection sustained.
Let's get back to the path of travel when you began your analysis. How did you know what the Lexus's path of travel was that day?
I got the directions from Trooper Proctor.
And what did Trooper Proctor tell you in terms of the path of travel specifically? A starting point and an ending point? Tell you the exact path Lexus traveled.
No, all I got was mostly just the addresses.
Okay, so if you've got 2 points on a map, and Trooper Proctor told you Lexus traveled from point A to point B, there are multiple ways to get from point A to point B. You'd agree with that, right?
Yes.
You picked one of those, right?
Right.
Path of travel includes freeways, etc., right?
Yes.
But as you sit here, you don't know what her actual path of travel was, because it could have been something different, right?
It could have been something. That's why I gave a range on my diagram.
Do you have any scientific evidence to establish what her actual path of travel is, or did you just guess at the path of travel?
I got the addresses from Trooper Proctor. I put them into the thing, and then one of the possibilities of 36 miles, and that was
The thing.
after looking at all of them, at 36 miles is a possibility.
I put them into the
Understood.
thing.
So that's what I'm trying to
Into
do.
the thing.
Trooper Paul.
Okay.
Y'all, the
One
thing.
possibility, that it was 36 miles,
Mhm.
one route of travel, right?
Correct.
There were other possibilities, right?
Yes.
So between and among the possibility that you picked and the other possibilities, you just sort of have to guess. And there's no science to it. You just said, I'm going to pick that one.
He averaged it.
Put it in my report, right?
No, that's not how that worked.
Okay, why don't you tell me how that works?
With the
Her
thing.
odometer mileage on the car from the download and time we had the vehicle shows 36 miles. So when I plugged those addresses into Google, it came up as 36 miles as a possibility.
And you
And
knew
it
that there
matched.
was another route of travel to the same location, correct?
What do you mean?
There were alternative routes of travel to the same 2 points, from and to the same points, correct?
Yes. Yes.
You could have tried to extract the location data from Ms. Reed's cell phone to determine the exact route of travel, correct?
I don't know. I don't have access to do cell phone extractions.
So that answers my next question. You did not even attempt to do that, did you?
No.
Right.
You did attempt to analyze the key cycles for the Lexus in order to determine placement of that vehicle. You just talked about that with Mr. Lauper, right?
Yes.
I want to be clear for the jurors because most people have probably never heard of key cycles. A key cycle does not have any location data associated with it whatsoever, does it?
Date and time. data.
Correct.
It just shows you when a vehicle is turned on, the ignition is on, and off. That's one cycle, correct?
No.
Tell me what I've got wrong.
Key cycle, the car doesn't have to be turned on.
Say that again.
It goes from off to run. The engine does not have to be started to off.
Understood. So if it turns on, well, every single ignition is a key cycle. Every time the engine turns on, that's absolutely a key cycle. Once it's turned off again, right?
That gets recorded as an ignition cycle.
Right. So a key cycle can be an ignition cycle, but it doesn't have to be an ignition cycle. It also can be just turning the sort of accessory on, right?
Accessory
The
power.
key cycles turn the accessories on.
All right. But it doesn't, my question was, and where we started with this conversation is, it does not have any location data on it whatsoever.
Correct.
All right. So when you drive your car, you walk out, get in the car, turn the ignition on, start to drive, get to your location, turn it off. That's one key cycle, right?
One ignition cycle.
But and I'm going to use the word key cycles because you use the word key cycles in your report. That's what we're talking about.
I'm using that because that's how the trigger was read.
That's how what?
The triggers were read on the text stream. That's how they read them, key cycles.
By key cycles.
Yes.
I'm going to use that phrase key cycle.
Okay.
We're talking about the same thing. It's an ignition on, ignition off cycle.
Doesn't have to be on.
So you mean the engine doesn't have to be turned on?
Correct.
Right. But if you're seeing triggering events, not trying to be tricky here, seeing triggering events, the car's in motion.
I think
what's that
he's
tell
not
you?
trying to be tricky either, but it's a mess.
The ignition's on or off?
The ignition is on.
Right. That's what I'm getting to. But it has no location data associated with whatsoever. It could be here, it could be in Wyoming. The car wouldn't know the difference. It's not going to report the difference to you, correct?
On the key cycle,
Correct.
on just the key cycle. The key cycle does not give out locations.
Say that again.
Does something else give out locations then? And if so, where are they?
The key cycle does not give a location.
Right. So your analysis is trying to go from a known key cycle that you can figure out and then work backward from there to try to figure out where the car was on a particular ignition cycle or key cycle.
Yes.
I didn't use the key cycle to put it back.
Say that again?
I did not use the key cycle to place the car back in its location. The key cycles were, all I got from the key cycles is that they occurred close within proximity to the time we've had the vehicle, not basically saying that this was the location based off the key cycle.
Well, let's look at Exhibit 591 with the court's permission.
Okay?
He's going to undo himself
Testify on Friday
in a minute.
that this is a copy of the exhibit that was put in 591. This is part of your report, correct?
Yes, it is.
And this is a chart that shows when, look at this era, that era.
So the chart shows the known key cycle 1164, and those key cycles are them testing. Those red arrows are them testing the vehicle at Canton PD, and they know that because the data correlates with what they were doing. So that they know. So Alan's like, so you took the knowns and tried to work backwards to be like, okay, the car would have been here, the car would have been there. And he's like, well, the key cycle. And Alan's like, okay, fuck, let's just go to the exhibit then. And that's where we're at.
Indicates top and bottom where your testing occurred, correct?
Yes.
Okay, we move over to the left. That is key cycle what?
1164.
Right.
The testing
So
at
you
Canton.
testified, and we can turn the lights on. Your Honor, I don't mind if that stays up. We can turn
It
the
probably
lights on
should
if
stay up, actually.
it hurts anything. You stated in your report that there were, quote, 2 triggers recorded on odometer 12629 and key cycle 1162, correct?
Correct.
Yes.
These events were prior to the testing triggers on odometer readings 12665/12666 and at key cycle 1160,
What?
right?
Yes.
Okay. So what we're saying, what you're saying.
That, I was going to have a heart
report
attack. Is
is,
that, yeah, the feed
triggering
cut during
events were
this.
1162, going in reverse, in order. 1162 comes before 1164. They're numerical, is that right?
Yes.
Every single key cycle just tags another number on top of it, right? There's no formula.
Correct.
After 1 comes 2, after 2 comes 3, 4, 5, 6, and then move on, right?
Yes.
So by the time you got the vehicle, there had been 1,164 key cycles on the history of that car, correct?
Correct.
All right.
Oh my God.
And you knew, when you put in your report,
Ooh.
the triggering events that you see under 1164, those are yours.
No! The feed is glitching a little bit.
Clear that you recorded, that you talked to Mr. Lally about, were 2
We're just going to have to ride out the glitches. Sorry,
Yes.
chat.
Meaning ignition cycles, at least, right?
Yes.
Stated in your report, well, let me finish.
What is the weather doing? This is not an
And the
internet issue on my end. This is not an internet issue on your end. This is the feed coming out of court glitching, just so you know it's not you.
Triggers that occurred while testing was 36 miles. You just said that, right?
Yes.
And the key cycle difference was exactly 2 key cycles, right?
Yes.
1164, 1163, 1162. That's the triggering events, correct?
That's correct.
You also reiterated in your report in paragraph 23, 24, 26, and 29, and also in this exhibit in your CARS report, that the triggers occurred at key cycle 1162, right?
Yes.
You were assisted in your CARS report, I think you mentioned Trooper Zach Clark, is that right?
Yes.
Trooper Proctor assisted to a certain degree, correct?
Yes.
Trooper Larini, Carol Larini, is that right?
Yes.
Also Sergeant Sean Good of Canton PD assisted as well, correct?
Yes, in a sense.
In a sense,
Did they all read the report before it was finalized?
No.
Did you have any supervisor read the report before it was finalized?
Yes.
And he agreed with the assessments in the report?
Yes.
So in summary, everybody that read the report and you who authored the report believed, and it's reflected in that report, that key cycle 1162 contained the 2 triggers that you're talking about, right?
Yes.
That's the 3-point turn, I guess now a 3-point turn, right? Changing direction, and then
Yes.
the reverse at 24 miles per hour, correct?
Correct.
And you even went on and tested.
KFAZ in the chat asked what we're all asking ourselves as well. Isn't there car or her phone GPS evidence with time and location? There is phone GPS data, but we've only gotten into some of it last week. There should be car GPS data, but it seems that they don't have it, didn't download it. The data that we had from like Murdaugh's car is not present here. They are using the Toyota triggering event download that seems that Toyota Lexus uses for service. So we don't have it for this. Alice asked about Life 360. That's not from this defendant or this vehicle. So no, they should have had a GPS from the car, but I don't think they downloaded it or could download it or could access it. So
To that exact thing under oath in front of the state grand jury, correct?
Yes. Wait, hold on. I need the text streams?
On the key cycles.
Not in grand jury.
Okay. Testified to it on direct examination on Friday and again this morning.
Yes, correct.
So all we've got is the Toyota text stream data. I don't think they even downloaded the infotainment. I don't know where in this car the GPS and all that data lives, but it
If
seems
your
that they
testing
didn't
occurred at
grab
key
it.
cycle 1164, that means you turn the engine on, the ignition on to start your testing, correct?
Correct.
And that triggering event that we see up there at 1164 initiated your testing, is that right?
You're welcome,
Yes.
Cool Mama C.
So
The quick bits are here for you.
that 1164 is where that's where there's no more unknowns, in other words. Right? You know exactly where the car is, who's in the car, who turned the car on, and what the triggering events were and what they reflected. Because
Right.
You did it, correct?
Correct.
It's you.
Yes.
So that would be the cornerstone, basically, of your entire analysis of the key cycles.
Yep.
Say again.
The cornerstone, in
Like-
other words, the one known that is immovable, it's immutable, is 1164 began your testing. Is that right?
Objection.
Is that right? I'm going to allow the question.
Yeah, that's when the car was in state custody.
All right. So starting at 1164 and counting back, before you started
Right.
your testing, you know that the SUV had to be started, the
Here
ignition
come-
had to
here
be
come all
turned
the
over, and it
questions.
was driven to the Sally Port.
Here are the questions we're going to get to. How do you work back that many key cycles? Because here's where Karen Reed's car went. So Karen went from the waterfall to 34 Fairview, from 34 Fairview back to John O'Keefe's home, from John O'Keefe's home back out to look for John O'Keefe, ending up at Jem McCabe's home, then at some point back to John O'Keefe's home. Then her car went up to Dighton, then it went on a tow truck, then it went from a tow truck to Canton PD's Sallyport, and then it went from the Sallyport outside to be tested. So, where are all the key cycles?
In Canton at 5:31 PM from a tow truck on January 29th, correct?
I didn't know that.
You did or did not?
Did not know that.
Okay.
Wouldn't that have been helpful?
Assuming that the car had to be started and put on a tow truck, that would be key cycle what?
I don't know how. I can't speak to the fact that recorded a key cycle at that time.
I can't hear you.
I can't.
Oh, no, sorry. You said that anytime even the auxiliary power is put on, that a key cycle would have to go on. We watched a video of the car driving onto a flatbread. So if the car's turned on, doesn't it key cycle necessarily by pushing the button?
Can't speak to the fact that we would record a key cycle
It's going to get worse.
at that time.
Okay. If the car was turned on and driven onto a tow truck, would that be a key cycle?
I don't know because these keys record different ways, so I can't speak to how or why it did not record on there. All I can speak to is that those are the key cycles. The odometer mileage is more what I was going after on this whole thing.
The expert just said he doesn't know how the car records key cycles. So if you don't know how the car records key cycles, then how are we here? So you don't know. I don't know. He said a key cycle is every time the car goes on, the ignition doesn't even have to go on. And now he's like, I don't know. What? This is just unraveling for him.
Trooper Paul, you just said unequivocally, when a car is turned on and then turned off,
Tell me.
there's a key cycle.
I said when the car without the ignition on, that's a key cycle.
Right.
That's correct.
That's what I mean, when it's turned on, when the engine turns on.
That's the definition of what it is. I can't speak to why it didn't go on, why it did not record.
Well,
You're assuming it didn't record now because he now sees the problem. He's assuming it didn't record, but you don't know that.
let's talk about the ignition cycles
Okay.
before 1164, okay?
Okay.
Obviously, the car had to get to Canton PD because you saw it there, correct?
Correct.
Assume for purposes of my question, the car was turned on, and there's a video of it turning on, driving up onto a flatbed.
This jury's already seen it.
Yes.
That would be ignition cycle, I'm gonna use your word, key cycle, ignition cycle, 1163, correct?
Again, ignition cycle, key cycles are two different things.
Which word do you want me to use?
If you want to talk about key cycles, key cycles. If you want to talk about ignition cycles, it's ignition cycles when the vehicle gets turned on.
Why
a key
are they
cycle
different?
does not mean to be turned on.
But every single ignition cycle
Is a
includes
key cycle.
You can't have an ignition cycle without a key cycle.
Correct.
Well, if you want to talk about it, just use the key cycles or ignition cycles. I'm trying to make sure this gets out. I'm sorry. I'm trying to make sure that this gets put out the correct way.
I'm trying to make sure this gets put out the correct way. Sir, I think that ship has sailed. You're also the one that's being obtruse
Every ignition cycle
or
includes
obtuse
a key
at
cycle,
the moment.
correct?
In a sense,
By definition, it has to, right?
it doesn't have to.
How?
They record multiple different ways.
You can have an ignition cycle without a key cycle.
I don't know how it recorded, but it could happen.
Explain
How?
that. How could that possibly happen?
How?
Because a key cycle is when it turns on, not engine running, and then turns off.
Okay, so work with me here.
Ignition cycle is when it turns on, engine running for 2 seconds, and then comes off.
Okay, so
Or the 2 seconds, if it's not on long enough, it might not record one.
Okay, let's ignore the 2 seconds.
Okay.
That's not what we're dealing with.
Okay.
All right. Let's assume that it's an old-fashioned type of key.
Okay.
Okay? Halfway on, the electricity is on. It's like it used to be called ACC, accessories,
Yes.
right?
Yep.
That's a key cycle, correct?
For that intensive purpose, yes. This vehicle's not a key cycles. They're not a
Then you
thing.
keep turning,
Okay.
I'm going to
and that turns the
scream.
engine on, right?
It turns the engine on, correct?
An ignition cycle, right?
Yes. Well, then turns off.
Single ignition cycle
Alan sounds like he's ready to
necessarily
scream.
includes the precursor key cycle, correct?
I guarantee you, and this is when you're looking at lawyers lawyering in real time, what we see a lot from Lally is you can tell he's reading through his list of questions. Alan didn't think he was going to have this fight with this witness today because it seems so ridiculous that necessarily the car has to be powered on before the engine goes on. So the two would, the ignition cycle is contained within a key cycle. He didn't think he was going to be having this fight and is now like, how the fuck am I having this fight? And this is where the thinking on your feet, it necessarily has to come in that we are seeing from him, because he's like, how is this an argument? This is so basic. Why are we fighting over this? It's just wild.
Even though every
Like,
key
how are
cycle
we here?
might not include an ignition cycle. Would you agree with that?
In that scenario, yes.
Fine. Okay, with that definition, I want to talk about ignition cycles, because I don't want to get confused about accessories. Just assume the engine
Okay.
turns on, right?
Okay.
If you started your testing at 1164, then if the engine was
Key
turned
cycle,
on,
not time.
thereby indicating initiating a key cycle, driving the car onto a flatbed truck, and then hauling it over to Canton PD, that would be key cycle 1163 in that hypothetical, correct?
It could be.
Okay? Then going backward
It
from
could be.
there, if the SUV was, I'm sorry, let me add one event that I just forgot.
Off the tow
I
truck
had to
into
get off
Canton.
the tow truck
Right.
in Canton and be driven into the Sally Port.
Right.
Did you ever see that video?
No.
Being driven in?
No.
If there was a video showing that the car was actually driven into the Sally Port, that would necessarily be a key cycle, correct?
Possibly.
Okay, so that would be key cycle 1163. My mistake, I was missing one, right?
Okay.
Before that, if the car was turned on and driven onto the flatbed to get to Canton, that would be key cycle 1162 in order, correct? We're going backward,
It's possible.
all right?
He's not even going to fight with
Before
him
that, if the car
anymore.
was started and the car was driven from One Meadows Avenue to Karen Reed's parents' home in Dighton, that would be another key cycle, 1161.
Be
correct?
1161.
Very possible.
Before
Very
that,
possible.
if the SUV was started and driven by Miss Reed from the garage at John O'Keefe's house to Jennifer McCabe's house at 5:07 in the morning, that would be another key cycle, correct? 1160. Isn't that right?
Do you see where
It's
this
possible.
is going?
And before that, if the SUV was started and driven by Miss Reed to the waterfall,
No.
from the waterfall to 34
No,
Fairview,
Fairview to,
at
no,
approximately 12:15
it
a.m.,
needs to go Fairview
that
to
would be another
Meadows.
key cycle, 1159.
No, it needs to go
Right?
Fairview to Meadows.
It's possible.
I want to be clear. The reason that these numbers
And at Fairview, it might not have turned off,
skip in your diagram, they don't go directly in order,
but still.
right? Every single number is in order on this left-hand column, because this is only a diagram of when triggering events occur, right?
Right.
Yes.
Something unusual about the operation of the vehicle, correct?
Yes.
And it's clear that from the data, there was no triggering event at key cycle 1159, was there?
No.
Or 1158.
So assuming the driving events that I just told you, right? Assuming for purposes of my question, that the driving events started at 11:59 driving over to 34 Fairview from the waterfall,
Right.
then driving at 5:07 in the morning over to Jen McCabe's house, 1160. Then driving to Dighton, her parents' house, 1161. Then the car being seized in Dighton by Trooper Proctor, 1162. Then the car being taken off the flatbed and driven into the Sallyport at Canton, 1163. Your testing starts at 1164.
I'm going to back up because that was my internet, not your internet, as Alan is getting to his most important question. So I'm going to back up real quick as Alan is getting to the most critical question of his cross-examination. Listen to this question.
Canton, 1163. Your testing starts at 1164. That would mean that at 1162, that key cycle would include the time in which Trooper Proctor had possession of that car, correct?
No.
Assuming my hypothetical,
Your hypothetical?
yes.
If that's hypothetically how it works, then yes.
Then what?
If that's hypothetically how it works, then yes.
On June 9th, 2022, you were asked by a grand jury whether you knew or had done any scientific testing to determine the distance a body would actually travel struck by a vehicle.
So chat, here was his question. If you're looking at the car, key cycles, and we know key cycle 1164 is when they were doing the testing on the car, and you work backwards from where the car went, he's saying then wouldn't key cycle 1162 have been when Trooper Proctor had possession of the car after it was seized? So that's what they are trying to talk about. Because if you go back through the key cycle numbers, well, you have you testing the car. Before you tested the car, you turned it on. That's your key cycle 1164. Before that, the car got off a flatbed and into the Canton PD Sallyport. Before that, it went from the house in Dighton onto the tow truck. Before that, it went from One Meadows to Dighton. Before that, it went from Jen McCabe's house back to One Meadows. Before that, it left Meadows to go to Jen McCabe's house and all over the place. Before that, it had come back from 34 Fairview to One Meadows. Before that, it had gone from the waterfall to 34 Fairview. So if you tracked the car, then wouldn't this key cycle line up to the car being seized? But what the trooper is saying is, well, we don't know exactly when the key cycles are recorded. Well, then how is that solid evidence of anything if you can't say every single time the on button is pushed, it records a key cycle? He doesn't know the Toyota data well enough to tell you, no, every time it's pushed, it records a key cycle, or no, it only records a key cycle if it's driven for a certain amount of time. He doesn't know enough to know that.
Remember that?
Not that specifically. Not in that way.
Do you remember answering that you had not, I'm just paraphrasing, that you had not done all you hadn't finished your report yet?
Why don't you show him? He said he didn't remember
This is going
it
to
that way.
testimony at the grand jury. So they're going to give him his testimony to refresh his recollection.
May I?
Yes.
Take a look at middle of the page. Your answer starts at about line 12, but the question above it is probably informative. that in mind?
Yep.
There haven't been any sidebars yet,
Yes.
which is stunning to me. But this is a cross where his expert opinion has been dismantled by
You were asked, does that remind you
Questioning.
that you were asked by a grand juror if you could calculate how far a body would move having been struck by a vehicle?
Yes.
And you indicated, quote, yeah, there's certain calculations we can do with that, would figure out if you, say if the car backed up, hit somebody, and then they go a certain amount of distance, and it's based on miles per hour, the speed of the vehicle, the striking vehicle, and stuff. Remember saying that?
Yes.
What did you mean by
his testimony on the explanation of how far a victim would travel from a vehicle strike ended with "and stuff"?
You were asked, does that remind you that you were asked by
Did
a
I
grand juror
hear
if
that
you could
correctly?
calculate how far a body would move having been struck by a vehicle?
Yes.
And you indicated, quote, yeah, there's certain calculations we can do with that, would figure out if you, say if the car backed up, hit somebody, and then they go a certain amount of distance, and it's based on miles per hour, the speed of the vehicle, the striking vehicle, and stuff. Remember saying that?
Yes.
What did you mean by stuff?
I don't know.
You said that the calculations would
It's
be
based on MPH.
miles per hour
And
and
stuff.
stuff. Did you ever do a stuff to test that? The grand juror's question.
No, we could not calculate anything from this collision.
Say that one more time.
We could not calculate anything from this collision.
Who's we?
I'm sorry, me, the role me.
Well, you know John O'Keefe's weight, right?
What's that?
You know John O'Keefe's weight, 217 pounds, right?
Yes.
Did you know that?
I don't know his weight, no.
You didn't know that?
You know the weight of the vehicle?
Yes.
What's the weight of the vehicle, gross weight?
What's the gross weight?
Yeah,
I think it's approximately 7,300 pounds.
okay. Were you able to calculate the mass of the vehicle?
I did not calculate the mass of the vehicle.
Well, you told the grand jury that you were planning on doing that kind of stuff to calculate how far a person would travel being struck at that speed with a car of that
This
weight.
is unbelievable.
You didn't do those calculations?
He didn't do the stuff.
No, because the calculations would vastly underestimate the speed of the vehicle.
You testified
The calculations would vastly underestimate the speed of the vehicle. Wouldn't the speed of the vehicle be one of the factors of the calculations? If you didn't do the calculation, then how do you know what it vastly underestimates? Did you do the calculations and they disagreed with your opinion? Is that the problem here? Because I have questions.
again, my report isn't done yet. I'm going to look into it. I'm looking into all that stuff, end quote, correct?
The grand
Yes.
jurors were questioning
That
him.
word again. It's been more than 2 years since that statement at the grand jury. Is your report finished?
Yes, it is.
Did
Did
you
you-
engage in any of those calculations?
Did you do stuff?
I looked into it. This type of collision I would not be able to use the formulas for this type of collision.
Well, let's talk about those formulas. How
Why?
would you calculate how far a body at rest would travel after being struck by an object in motion? How would you calculate that?
In pedestrian collisions, I use a Searle throw formula.
A what formula?
Searle.
What does that mean?
It's a type of formula that would use for a calculation of post-impact
So
or
that's-
speeds for pedestrians.
That includes certain principles of physics to calculate that, right?
What do you mean?
I'm sorry?
What do you mean by certain forms of physics?
There would be
Stuff.
physics calculations that would be
Sir, the physics are the stuff. That might be the stuff.
required to figure out how far a body at rest would move, having been struck
Oh
by
my
an object
God.
in motion. Right? That's a basic principle of
Yeah, I guess you could say though.
All right. Can you describe for the jurors exactly what calculations you would need to employ to determine how far a body at rest would travel, having been struck by an object in motion?
So, in this scenario, in this collision, it's more of a side swipe. So he did not ascertain, he did not get enough speed of the vehicle post impact with the vehicle to be able calculations. His center of mass was offset.
If he didn't get enough speed from the vehicle from the collision, then how are you finding that he was thrown more than 30 feet?
From the vehicle. So we would vastly underestimate his speed. So that's why I did not do a formula. If he was more in line with behind the vehicle, he would have been projected forward, and using that projection forward, he would have been able to get more closer to the actual speed of the vehicle during that post-impact travels.
Well, that presumes a couple of things, Trooper Paul. That presumes that he was quote-unquote sideswiped, right?
Presumed?
Presumed by you.
By you.
You didn't see how he was hit, did you?
Based on the evidence, it appeared to be a side swipe.
That's your opinion.
That's just reading the evidence.
You're saying that the principles of physics as we know them
That's your opinion based on the evidence. You're an expert. You're there to render an opinion. It is still an opinion.
today in modern mathematics is thwarted by a sideswipe?
Objection.
Is that what you're saying?
Modern mathematics might be the did you use instant grits of this trial?
Presumed?
Presumed by you. You didn't see how he was hit, did you?
Based on the evidence, it appeared to be a side swipe.
That's your opinion.
That's just reading the evidence.
You're saying that the principles of physics as we know them today in modern mathematics is thwarted by a sideswipe?
Objection.
Is that what you're saying?
It's the calculations that are out there. You can get a speed, it will just underestimate the speed.
He's
You
not
would have to know.
he's not trying to determine the speed. He was asking you to determine the force and not whether it awakened. He is oh God.
Know what the initial momentum of the object is that's in motion, correct?
Of what object?
The truck, Paul.
I would have to know that speed.
Yeah, you'd have to know what the initial momentum is, not speed, momentum. There's a difference,
Okay.
right? Did you agree with that?
No.
What?
You wouldn't have to calculate what
No,
the
there's not a
initial
difference
momentum
between
is
speed
of
and
the-
momentum.
Of the object in motion?
Sure,
to
sure,
determine
dude.
The distance of the body at rest would move?
Well, in that sense, are we talking about I'm trying to find the speed of the vehicle? That's usually what we're trying to do.
Right, okay, well, let's put the speed of
He's not asking you to find the speed of the vehicle. He was trying to ascertain the force to determine how far the victim would have moved to ascertain if your calculations were correct. You are what?
the vehicle aside. Let's talk about initial momentum. What's the formula for calculating initial momentum?
He doesn't know.
There's different types of momentum formulas.
Well, there's actually one type of momentum formula. It's to calculate momentum.
Objection.
Sustained.
To calculate momentum, there is a single.
So
Objection, Your Honor. Defense counsel knows too much about physics. Fuck.
sustained. Ask it differently.
Isn't it true, Trooper Paul, that there is a singular calculation
Chat
for
knows.
determining initial momentum? That is P equals M times V, where P is the momentum. You're solving for that. M is mass. You multiply that by velocity. Is that right? Pretty simple.
You wouldn't use that in a pedestrian collision.
Oh, because the pedestrian's somehow magically out of the realm of physics?
Objection.
Sustained.
Is the pedestrian out of the realm of physics and calculations?
No, it's the weight differential between the pedestrian and the vehicle.
So if the vehicle is too heavy and the body is too light, you can't calculate the initial momentum of the vehicle?
Yes,
I imagine that
Where'd you
other
learn that?
experts would not agree.
it's in my math class. We only use momentum for a vehicle to vehicle.
Math class?
The math, the crash reconstruction classes I have taken.
Got it. Would you need to apply the theory of conservation of momentum in calculating these data?
Do I need to calculate the conservation of momentum?
Heard of calculation?
I don't think he knows what you're talking about.
Yes.
You even know what that is? There's an equation for that as well, right?
Yes.
You know what that is?
Not off the top of my head, but yes.
Not off the top of my head, but yes.
Based on the basic principles of physics, is the total
The reason Alan Jackson keeps pushing this is because when they get to their expert, I imagine, and their expert they did not hire, their expert is from the federal investigation. I imagine it's going to be a different situation.
momentum of the collision greater or less than the total momentum?
That's why we're doing this.
After the collision. Total momentum before the collision, is it greater or less than the total momentum after the collision? Basic question.
What type of collision?
Trooper Paul, they're exactly equal in all respects under the principles of physics, right? That's the theory of the conservation of momentum. Momentum doesn't change. It's just
Yes.
transferred from one body to another,
Yes.
correct?
Correct.
Why didn't you say that to the jurors?
Objection.
Sustained.
Oh boy.
Trooper Paul, if you were qualified to, quote, look into all this stuff, you would probably know these answers, wouldn't you?
Objection.
Sustained.
Oh, that's snarky and
Are there any other
argumentative.
calculations that you need to figure out the stuff that you were talking to about with the grand jury?
Objection.
Sustained.
How about calculating the final velocity of the objects after the collision? Would that be important?
What objects?
That would be John O'Keefe's body, sir. Object
I don't.
that you claim was flying through the air 30 feet.
Okay,
Objection.
sustained.
Alan is
How about
pissed.
calculating the displacement using kinematic equations? Would you be able to do that?
The displacement of the body.
In order to calculate how far the body would move based on the mass of the object striking the body, could you use displacement using kinematic equations?
So, like I said before, the side swipe, he would not have gotten 100% of the vehicle, 100% of the speed of the striking vehicle. It would have vastly underestimated this vehicle. You couldn't hit a person and side swipe them, spin them off to the side, and have that and get a speed from those calculations.
So you're saying that
I don't think he's asking you to calculate the
the
speed though.
discipline of physics
Oh my god.
cannot figure out how far John O'Keefe's body would move. But you personally figured out that he would have flown now somewhat, or been projected somewhat 30 feet.
Objection.
And again, while all of this is very helpful, again, I think the issues with the key cycles are probably more impactful to the ultimate determination of this case. But again, when the defense, and we'll see the defense's experts tomorrow, or the experts the defense is calling tomorrow, because there's a whole day of voir dire tomorrow on those experts. So tomorrow we will see in real time how this is going to go before the jury sees it. But this is not good. I wonder if at this point the jury's just given up and been like, whatever, we're done.
Sorry?
Sustained.
Are you saying that the principles of physics are incapable of determining with the proper calculations how far John O'Keefe's body would have moved given the collision at issue?
Objection.
Is that what you're saying, Trooper?
No.
Okay, next question.
You
No.
said because it was a side swipe, all these calculations, these physics calculations are inapplicable, right?
But I'm saying it would underestimate the speed and the distance.
We're not trying to find a speed.
The truth is, Trooper Paul, you have no idea what all these physics calculations mean, do you?
Objection.
Sustained.
You've not been trained in physics formally, have you?
Yes.
You have been,
It's incorporated into the classes.
right? You had a few classes that used the word physics, but you haven't been formally trained in physics, have you?
Objection.
Oh, that's argumentative.
Sustained.
You haven't been formally trained in kinematics, correct?
He went over all
It's in the
this.
aspects of all our crash reconstruction classes.
You haven't been formally trained and hold no degrees in biomechanics, do you?
I do not have a degree in biomechanics.
This is why
In
all of you
fact,
are missing the experts from the Gwyneth
Basically,
Paltrow
what
case.
you did in this case
Biomechanics
was calculated
was their
initial
jam.
cycles. And you even got those wrong, right?
Objection.
Sustained. Come on, Mr. Jackson, ask the appropriate part of the question, you'll get it.
The questions are really argumentative. I hate that he didn't take the sticker off
Based
the
on
bottom of
your
his water bottle.
reconstruction,
That's a personal.
nearly 2-year investigation, exactly how was that taillight shattered? Explain it to us.
How does the taillight, what do you, it gets, so the taillight in this case was shattered when it was struck John O'Keefe's arm.
Exactly what part of his arm?
It, based on what I saw,
Excuse me, sir. How did the taillight shatter and John O'Keefe's arm not shatter? Because from the 2 pictures that we have seen in this case, and we don't have any medical testimony other than the ER doc yet, nobody mentioned that John O'Keefe's arm was shattered, that his elbow was shattered. I've seen people wreck themselves with a lot less, but what is the force between the human arm and the taillight?
for his injuries was from the upper part of his arm down.
Was his arm out? And it just struck the arm like a hinge? Was it in front of him? You did the reconstruction?
It looked,
Here's exactly how his body was positioned when he was struck by that.
so it looks like his arm was more kind of like this, if I can try to get that.
You're indicating out by
You're-
his side, correct?
Yes,
All right.
What damage
And the
happened to his
taillight
shoulder?
Struck his arm, right?
yes,
Not his torso.
yes.
Okay. So the full mass, the full weight of that,
Of that
truck
car?
hit him basically at the elbow. Is that right?
No,
Missing his
no.
torso.
But I said it, yeah, from the upper part of the arm
Right.
down.
The
Yeah,
elbow and the biceps.
I didn't see anything that shows an indication that
But it hit his arm extended out from his body?
this lower torso was struck, but
Okay. So his torso.
it's not saying it could not have been a possibility, but I just didn't see anything.
So his torso was spared from being hit, but the arm took the brunt, the full force of the vehicle, correct?
Like arm and shoulder, yes.
Okay. And you said he then did a spin, like a sort of a pirouette.
He got
I know this testimony has been long and slogging and frustrating to listen to, but what you might have missed buried in that expert's previous answer is that he said, I didn't see anything to indicate John O'Keefe's torso or body were hit by a car in any way.
spun around possibly the way it struck, it looked like it could have turned around counterclockwise.
Okay.
He said it
So
could
it turns around
happen, but he
counterclockwise.
didn't see
Turn
anything
around
that
in
indicated
the air
it did.
Counterclockwise?
Yes, initially.
So he gets hit on the upper biceps, shoulder area, and down to the forearm, right?
Yes,
By an unbroken taillight, right?
yes,
In other words, it's nice and smooth. Nothing, no shards of plastic or anything broken at
Yet.
the time that it made contact with his arm, right?
correct.
Okay. So
And-
how did his arm get all cut up?
Because
Then it
when
broke.
his arm struck the taillight then cracked, and as the car is driving past him, the taillight could scratch it.
Could have.
So he gets hit by the car, not his torso, just the arm. The taillight cracks, and as it passes by, his arm stays with it long enough to get striations, those scratches
Could.
that we see, those lacerations. I'm sorry, those abrasions that we see, right?
In a sense, yes.
And at the same time, he does a pirouette and flies 30 feet to his final point of rest.
I don't know if he did a pirouette.
Well, I'm using the word pirouette. He spun around.
He started rotating counterclockwise. I don't know how far he ran counterclockwise, but he started rotating. According to that, would push him to rotate counterclockwise. Whether or not he went counterclockwise all the way to his back toward the ground,
He was on his back
it's
on the
it
ground
seems like a most likely possibility.
because of the.
Did you account for the fact that his arm is on?
He was found on his back, and the injury to the back of his head seems to be the most significant injury, but we don't know. You know why? Because we haven't heard from the coroner.
Hinge?
Is what? Say again?
Did you account for the fact in this scenario that you just told the jurors that his arm is on a hinge?
On a
Called
hinge.
Shoulder?
The shoulders.
Okay.
Okay? So arm got hit, didn't his arm just swing?
Move.
I said arm and shoulder area, so his arm could have been considered part of it.
Even if his shoulder got, the upper,
Okay.
you're pointing to his upper biceps. Right? There's no injuries on his shoulder, not a single one, not even a bruise, right?
Like I said, it looked like to me it was from up here. I don't know how far I can up back here, but it was up here.
Well,
So
you're the one that talked about his injuries on his arm.
yes.
That's limited to about mid-biceps, about mid-forearm,
boy.
right?
Okay.
Right?
Yes.
No injuries on the shoulder, no injuries on the torso, no injuries on the
Like
ribs.
not even a ripped
no injuries
rotator
on the back.
cuff. Like
Is that right?
Yes.
there doesn't
your
seem to be
theory is-
any ligament damage, tendon damage, like that you would have seen in that picture because you would have seen pooling.
We got
Just
hit
let
on
it
the
go,
arm,
just keep
took the
letting it
brunt
go,
of
just
the
let it go.
force from the taillight on the arm, stayed with the
Cup himself
vehicle
on.
long enough
To get
for the
scratched.
taillight to explode, basically, to shatter. Then these striations get on his arm, abrasions. Does a pirouette, a spin, counterclockwise, and flies 30 feet in the air to his point of rest.
Yeah. It happened probably a little faster than that, though.
What? What is that
His head
answer?
hurt.
I said that's one of the possibilities of when you look at the roadway as he gets spun.
That's one of the possibilities. Y'all have charged her with a volitional second-degree murder. So if that's only one of the possibilities, what are the other possibilities?
Around kind of clockwise, it's a possibility that the curb is there, any blunt force object on the ground, as the ground is pretty blunt.
Well, except in your scenario that you just told us, you flew through the air onto the light dusting of snow, grass, and dirt.
I didn't say through the air.
Say that again?
I didn't say he got thrown through the air.
Okay, I'll use your word. You got projected. Like a
Projected doesn't mean it's not incorporating just throw. Project just means you get pushed forward. There's two parts of that. There's the air, then there's the ground. Like I said earlier, the tumbling, the rolling, whatever that part of the crash would happen.
clothes
Projecting
don't
is just
look
what we
like he
call
tumbled.
what happens to a pedestrian post-impact with a crash.
Okay, so a couple questions. If his arm, elbow took the brunt of that entire impact,
That's one of the
How do you account
possibilities
for
is
the
where
fact
I'm
that-
stuck.
he didn't suffer a broken bone.
I don't know.
How do you account for the fact that he didn't have a fracture?
Objection.
Sustained.
How do you account for the fact that he didn't even have a bruise on the arm?
Objection.
That's sustained too.
May I approach?
Yes.
Yeah, he's allowed to ask these questions because the expert said he relied on the injuries to the victim. So how do you account for, and the jury doesn't know this yet, which is super frustrating. We don't know this yet. We don't know if there were bruises on his arm other than the photos that we've seen. We don't know if there was tendon or ligament damage other than the photos that we've seen because we haven't heard that testimony yet. We don't know if, I mean, it seems that there were no broken bones based on the ER doctor's testimony. This is not good expert testimony for the state.
May I inquire, Your Honor?
Yes.
The truth is, Trooper Paul, you know, having investigated auto pedestrian accidents in the past, that John O'Keefe's injuries do not look anything like an automobile pedestrian accident, do they?
Yes, they do.
Isn't it true, Trooper Paul, you came to these opinions and conclusions
He's almost done.
because Trooper Proctor told you to come to these opinions and conclusions in furtherance of his investigation?
That is not true.
That's why you have these opinions and conclusions that just don't make sense, correct?
That is not true.
And you're just trying to fit a square peg into a round hole.
Objection.
Sustained.
Yeah, that's his last question anyway.
All right. Jurors will take the morning recess.
All rise for court, please.
And I'll see counsel at sidebar about scheduling.
At the end of cross-examination, it wasn't the answers that mattered to Alan Jackson. It was the questions, which is most of cross-examination, right? The questions matter more. The jury is taking their morning recess. We are not. I'm just going to zoom past it. It's why I love being able to start a little bit on delay so we can just zoom. So let's do a quick summary. She didn't ask Lally if he had any redirect, unfortunately. So there might be a few more questions. Welcome, law nerds. We're at the morning recess of day 26 of the Commonwealth versus Karen Read. We have just finished up the cross-examination of Trooper Paul, the accident reconstruction expert, which was less fiery, but more painful than I think we anticipated from watching the testimony on Friday at voir dire. The judge did not allow this expert to get into an opinion about the video of Karen's car backing into John O'Keefe's car. So that was kept out. Lally got in some general information that he may be able to argue, but the crux of this cross-examination really was that, one, the key cycles don't seem to account for all of the times the car would have been turned off and on and moved. The defense asked very pointedly, wouldn't this key cycle showing the accelerating backwards or reversing backwards at a high rate of speed, wouldn't that be when Trooper Proctor had control of the vehicle? It looks like the court's going to put something on the record, so I'm going to pause it real quick and make sure that we don't miss that as I finish up my summary. So wouldn't that key cycle have happened? But it seemed that this witness doesn't know what causes a key cycle to record, and that the only way they have key cycles recorded is because of a triggering event, but he doesn't also seem to know what causes a triggering event to record in that Toyota TechStream software. This witness did not testify at all about any other data from Karen Read's car, any of the GPS data, any of the type of things we've seen in other cases. And as far as his reconstruction, it really does seem that he was trying to truly fit, well, this is where the victim was, because that's what I was told. This is where the pieces of taillight were, because that's what I was told. And this is the broken car, and she hit him with the car, and that's what I was told. So this is how that accident would have happened. It would have been a sideswipe, and he would have spun, and his arm shattered the taillight and then got scratches on it from that motion. But he kept saying that's one possibility during cross-examination. Well, if there are multiple possibilities, I think that that necessarily indicates that there is doubt as to whether or not this is exactly what happened to the victim, because he kept saying it. It is very difficult reconstruction testimony because this witness just simply does not know. And that is really frustrating to watch go on and on and on, that this is the Commonwealth's expert that is supposed to make clear how things happened. And again, it has not made anything clear except that this was beyond, I think, the scope of this expert's knowledge and experience. So with all of that, we've not gotten to redirect yet. I don't know if redirect is going to help. What was most, I think, impactful for me is that the key cycles don't seem to line up with the behavior of the vehicle that is known. So how do we know that that rapid backing happened at 34 Fairview? Is there any way to definitively say that? Right now, no, there is not. No, there is not. And all of the other things this witness testified to were, it's a possibility that. Wow. All right, let's see if the court puts anything on the record about scheduling. Remembering that tomorrow is going to be a whole day of voir dire without the jury. Let's see. The attorneys are back at their tables. The judge is walking off the bench. Oh, and now we are going to only the fan. So I'm going to get to some questions. Let me zoom because we're going to pass the morning break, or we should pass the morning break, back to redirect of this witness. So we're not done with this witness yet. So let's get past morning break and back into court. I will try to answer questions as we can. If not, I'll break them when we break. So my feed is being cranky with me. Probably because we are behind, because I kept pausing to yell about things because I couldn't help it this morning. Also, for the 40,000 of you here, hi, welcome, thank you. Don't forget to download the Lawnerd app so we can keep you in the loop when witnesses take the stand, are subjected to cross-examination whenever we finish the prosecution's case in chief. And ultimately, it's when we will let you know that there's a verdict in the case, and how we will let you know when there's a verdict in the case and I am going live is through the Lawnerd app at lawnerdapp.com. All right, we are coming back to court after the morning break. But just a note, if you want to stay in the loop with this case, or, well, our next case, which will be Baldwin, iOS and Android, free app. We do have a member space that we will be rolling out publicly later, that some of you are already in, which is a lot of fun. But for now,
All right, Mr. Lally, whenever you're ready.
man. Jeff Cook said, I think everyone should go to lunch and figure this fuckery out. We're still code red because I can't even. What am I drinking? Right now I'm drinking
as
a
far as that
chocolate cold brew. The chocolate cold
triggering
foam
event.
cold brew.
Well, the two events on 12,629B.
We are now on redirect from Lally. So even though Cross is done, Lally gets to try to fix it. Good luck, Lally.
You testified that that was consistent with the pedestrian collision, is that correct?
That's correct.
Again, if you could tell the jury, why is that consistent with the pedestrian collision?
The
This assumes that the key cycle is from 34 Fairview, but he says the data on the key cycle is consistent with a collision.
the one specifically with the speeds and everything that we're referring to.
24.2 miles per hour in reverse.
Are there multiple? Are there multiple? Are there multiple key cycles that are consistent with a collision?
Okay, yeah, so why I think that's consistent with a pedestrian strike is because of the sudden change in the speed. It drops down by half mile per hour. The accelerator pedal is staying constant at the same percentage, and the steering wheel angle also turns to the right.
Now, your overall opinion is based on what you did as far as your construction, correct?
Yes.
Was there other information that you had at your disposal in formulating your opinion?
Like from other reports and stuff?
Yes.
Yes.
And that would include physical.
If you know that your expert in a murder case is going to testify in the manner of like from other reports and stuff, you need to have a conversation with your expert about what is court appropriate expected testimony.
Evidence, is that correct?
Correct.
And that would include witness statements, correct?
It's leading.
Sustained as to form.
What, if anything else, would that include?
The roadway evidence, witness statements.
In witness statements, would that also include statements of the defendant?
Correct.
Are you aware that the defendant indicated in a statement to troopers that she conducted a three-point turn in the area of 34 Fairview Road?
I'm going to allow that question.
He's allowed to consider
Yes.
that.
And what you observed in that triggering event is that from that mileage, is that consistent with the defendant's own statement?
Yes, it is.
That's leading.
Now, let me ask you a little bit, if you could, again, for the jury, clarify the difference between what you termed as
Chat, he got to, isn't the 3-point turn consistent with the defendant's own statement? His original testimony is it was a U-turn, by the by. Does anyone feel like they can rely on what he said about what this car did? I genuinely am curious. Am I being too harsh? Because I have worked, most of the reconstructionists I've worked with were from California Highway Patrol and had decades on decades of experience and were amazing. So am I being too harsh? Because I am so frustrated with this testimony. How do you rely on this?
area of impact versus a point of impact.
Yes, an area impact is broader. It's a
Chat's like,
bigger
nope.
area. Point to impact would mean something as obviously right there. That would be the area impact.
If If I could ask, the cell phone that was located under Mr. O'Keefe's body, that location, is that also consistent with the linear path that you were testifying about earlier?
Yes, it was.
When people are hit by vehicles at rates of speed, normally the things that are loose go off of their body. He testified to that. Hats, glasses, shoes. If someone has been struck hard enough to be knocked out of a shoe, a phone isn't going to come out of a pocket or a hand, a drinking glass isn't going to go flying. Please just explain, because I cannot.
And do you know whether or not that cell phone was in his hand or in his back pocket or somewhere else?
I do not know.
As far as let me ask you this. You were shown some photographs of some taillight pieces near a fire, correct?
Yes.
And as far as the area of impact, that was, from what you determined, that was Mr.
The cell phone
O'Keefe's
location
seat,
doesn't
is that
seem
correct?
consistent at all.
Yeah, it was within that. What I've had for non-initial evidence, I said the air impact was a star in that area prior to the
I'm
sneaker.
sorry,
So what I was saying was the air impact was prior to the area the sneaker was. It was in that path, just prior to that area.
And why did you determine that it was in that area?
Because that is the first point of evidence.
And just first point of evidence in relation to what and sort of how the evidence was configured.
Ashley in the chat said, my CHP hubby is appalled by all of this. A lot of the accidents that I prosecuted as a DA, we worked with accident reconstructionists from CHP and they were incredible, which is why I asked if I was being too harsh, because I know the types of experts I've worked with. I'm so curious to hear other attorneys, the defense attorney's lawyer, Runkle, Natalie Lawyerchick, but also Peter works with civil injury. I imagine he's worked with a ton of reconstructionists. I would be so interested I am very interested to hear his take on this when he does a recap over on his channel. But what is CHP? California Highway Patrol. So California Highway Patrol is, I prosecuted in Los Angeles, so we regularly worked with California Highway Patrol. If you ever saw this show Chips, I'm now dating myself. Chips is also CHP. Okay, let's continue.
As it was evident to you.
That was pointed to me. It was the first point of evidence away from, the furthest point of evidence at that time that knew away from the pedestrian.
May I approach the witness, Your Honor?
Yes.
We just need Chips to do this.
Sir, I'm showing you what's been marked.
We need Chips and Mona Lisa Vito.
Do you recognize
That's who we need on this
depicted
case
in that
right now.
photograph?
Which, again,
Yes.
And Your Honor, with the court's permission, if I
all of this sucks for the victim's family.
Okay,
This-
what exhibit number is it?
58.
Thank you.
the victim's family and everyone in Canton and everyone connected with everyone involved in this case deserves answers. Everyone connected to this case deserves answers. And this investigation is not doing that. And it's tremendously frustrating.
Yes, I do.
What do you recognize that?
There's 34 at Fairview to the left side, and there's the fire hydrant.
And as far as these photographs and the photographs shown to you by Mr. Jackson on cross-examination, do you know when those photographs were taken?
I do not know specifically at what time those were taken.
You don't know if those photographs were taken on February 3rd, 2022?
He's,
Is the objection sustained?
because he doesn't know. He said he didn't know. I need to eat breakfast. I'm going to lose my mind.
I know you've done this on the diagram, but if you could use the laser pointer, which is
Yeah, we do. We need Eric Estrada's stat.
direct the jury's attention to where you believe the area of impact to be between the defendants, Lexus and Mr. O'Keefe.
It's probably somewhere out here.
Sir, probably's not going to help.
And as far as that linear path that you were talking about from the area of impact, where did that go from and where did that go to?
So I can say, so from, I think it's from around like this way.
What?
Ms. Gilman, you can take that time. May I approach this retrieve here? Explain to the jury as far as
Explain to the jury what the fuck.
What you were describing as Mr. O'Keefe's post-impact movement, starting sort of with the point of impact between himself and the SUV to the point where he comes to final rest on the lawn.
Yes, so he was struck along the right side in the area of his arm, and then he was, post-impact with the Lexus, he rotated counterclockwise and eventually hit the ground and came to final rest.
And the ground, based on your understanding of the weather conditions, was frozen at the time, is that correct?
Objection.
Sustained.
I don't think he
Watch
can
the
test-
form, Mr. Lally.
He can't testify to that, and it's leading
As far
AF.
as anything in your testimony about Mr. O'Keefe's actions, does that involve a pirouette?
No.
So there's a rotation,
Lally, the pirouette is the least of your problems, bro. Everybody knows that Jackson's being hyperbolic. It seems a little too snarky. The jury might not like him continually classifying it as a pirouette. The key cycles are a real big problem, man. Not the pirouette language, which is clearly hyperbolic. So that, I don't think you need to point that out. We'd love to know about the key cycles, though. Love to.
is that correct?
Correct.
Love to know.
And as far as 30 feet in the air, do you have any opinion as to whether or not he flew 30 feet in the air?
He didn't say 30 feet in the
I
air.
don't have any evidence that he would have flown 30 feet in the air.
And so as far as from your training experience when it comes to pedestrian collisions, are you able to determine or calculate how much distance someone is in the air and how much distance someone sort of rolls or tumbles to their final resting position?
Say it again.
From your training experience,
Sometimes you can
based
tell.
on, this collision, are you able to determine how far Mr. O'Keefe was traveled in the air versus how far he traveled tumbling or rolling after he hit the ground?
I do not have a calculation for this specific style of pedestrian crash due to the side swipe. So if I did, I could use the formula. It would just vastly underestimate the
And the
speed of the
side
vehicle.
swipe comes from the injuries and the fact
Let me
that he
ask you a
wasn't
little bit
run
about-
over by the
you're
car.
talking about the Searle pedestrian throw formula, correct?
Correct.
And that's something developed in the course of physics specific to reconstruction by someone named Dr. Searle, correct?
Correct.
And that's S-E-A-R-L-E, is that correct?
That is correct.
Lally, you shouldn't know more about this than your expert. Because it's not going to help when you just lead your expert and be like, this formula was developed by this person. Your expert needs to elicit that information. Your expert needs to have that information on recall, which is why I would never want to be an expert witness. I am very ADHD. My recall on the stand like this, it would be like, what report written by what person? I don't want to do that. So I didn't pick that as a career field. But I can remember all the facts of this case because I have heard y'all talk about them, and your expert never said where these formulas came from or that he was aware of it.
And with respect to Dr. Searle's formula, why is that inapplicable in sideswipe collision versus some other type of collision?
Because it takes in, it's looking for more, it's not so much the formula, it's how much projection efficiency that would occur, how much percentage of the speed of the striking vehicle would have happened. In order for the formula to work, the more of the body would have struck the vehicle, the more efficient the outcome would be in the speed.
In the center of mass that you were talking about, sort of in the collision sequence, what, if any, role does that play in regard to your ability to do that calculation?
It would just, like I said, it would underestimate the speed of the striking vehicle due to the center mass not within the rear of the vehicle.
And not to twist your words or anything, but as far as when you say underestimate,
He's
that
not
would
trying to
be
twist your words, he's trying to
accurate
fix your words at this point.
Vehicle speed, correct?
Correct.
Now, you asked some questions about the glass and indicated that there are a number of reasons why the glass would travel with him being Mr. O'Keefe. Can you explain what those are?
Yeah, the glass could have struck the vehicle also in that same way. Could have still been.
The problem is, we're in the state's case. Could have probably does not help. Remember, in Massachusetts, the jury instruction reads, beyond a reasonable doubt and to a moral certainty. Do you know what doesn't feel in my bones like a moral certainty? Possibly, sort of, kind of, could have, maybe. None of those feel like beyond a reasonable doubt. So when you are talking to the jury, you need to give them the information where they go, this is what happened. Not this is kind of, could have, sort of, maybe, what if anything, what happened. They need to know this is what happened. From you. You're the expert.
Attached to his hand and still gone with him in the same way. It could have been attached to his body in midair. That's the multiple ways that the glass would have stayed with him.
Could have. There's also ways the glass could have stayed with him if he wasn't hit by a car. That's the problem.
Sequences, particularly collisions involving multiple vehicles. Vehicles are affixed with bumpers, correct?
Correct.
What's the purpose of a bumper on a vehicle?
Lally, good luck with
to help
that.
absorb the
Scope?
Yes.
Sustained.
Your Honor, if I may, I don't believe it.
So
When the court said scope, it's because Lally is getting outside the scope of cross-examination to ask about the purpose of bumpers on vehicles. And he's trying like hell to get something to argue that Karen Reed's taillight wasn't broken by the collision with John O'Keefe's vehicle. And that's what he's trying to get into. The court has kept that out specifically as to the video. And now he's trying to elicit the information that'll allow him to argue it. And that's why Alan is objecting. And that's why the court sustained that as to scope, because it is outside the scope of cross.
why don't we come to sidebar?
Why don't we not? Could we not? You know, the judge can say no. The judge can say we're not going to sidebar. I think she wants to explain it to Lally so they don't have to keep going through it. But this is, for all of you, how many of you, just pop a 1 in the chat, how many of you watched the Gwyneth Paltrow trial either with me or elsewhere? You saw the reconstructionists and they were so incredibly precise with the way they were reconstructing that ski collision, is that when you were looking at that reconstruction testimony, you're like, oh, well, the only way this could have happened is if he hit her. I mean, and then in closing arguments, the plaintiff's attorney did say you don't keep your skis on when getting blown from behind, but I digress.
So I'm sorry again, if I could ask you, what is the purpose of a bumper on a vehicle?
It's there to help absorb energy from a collision.
And with reference to
The experts in the
scratches
Gwyneth
that you
Paltrow
asked
trial were
about,
great.
on the vehicle.
They were
on
great.
Sort of the right rear quarter panel. What, if any, relationship does bumpers or their interaction have, to your opinion, as it relates to that?
Sorry.
Ashley Bounds, your
Say it
comment
again.
is hilarious. And
Back to what you just testified
it got
about
lost, so I couldn't
bumpers,
grab
you
it.
also asked some
But thank
questions
you.
about scratches on the right rear quarter panel of the vehicle, correct?
Correct.
And what, if any, relationship does the bumpers on the vehicle and sort of their intended purpose have with relation to the scratches that you observed?
So the bumpers on the side was more of
The scratches. Remember when Jackson was asking about the scratches and he was trying to get into it could have been, and Jackson's like, no, that's non-responsive. This is why we're getting into the scratches on the bumper, because Jackson asked about the scratches on the entire vehicle.
This wasn't more of a direct on hit with the bumper. It was more of the side scraping of the paint of the bumper.
Now, the presence of
Scratches
Mr.
could come from a
O'Keefe's
side
DNA
swipe
on
of a
the taillight,
bumper.
is that consistent with
I
the
think that's
pedestrian collision?
consistent with the evidence too.
Yes.
Now, as far as the glass not matching, are you aware that the lab's actual findings were that the glass on the bumper and the glass on the roadway was just not found to be consistent with each other? Is that your understanding? If you know.
I don't
The glass on the bumper and the glass on the roadway were consistent. The glass on the bumper and the glass on the roadway weren't consistent with the glass on the lawn.
know.
And were you also aware that the lab's finding was that the glass on the bumper was consistent with the glass on the road?
I'm not aware what the lab said.
You should have been told. That's not his
Now, in
fault if he
order
wasn't
to
told, by the way.
construct Your diagram.
You need to give your
testimony,
experts
I believe was that you had used
the
some
information to rely
diagrams
on.
In the process of that, is that correct?
Yes.
And if I could turn back to that 12629B, the mileage from the text stream data.
I think even the,
Yes.
the in-court videographer is
Three-point turn
bored
that
with
you,
all these questions at this point.
Observed in the 24.2 mile per hour straight line for approximately 62 feet. How far apart time-wise within?
I will say, for the state, the 3-point turn is helpful, but then this witness said it was a U-turn. But the 3-point turn is consistent with some of the marks people saw on the road, the tire marks, and with Karen Reed's own statement. But I don't know if you can fix it at this point because the key cycles are so confusing.
That particular triggering event were those two incidents.
8 minutes.
And as far as any of the other text stream data that you observed, was there any other triggering event that included the 3-point turn?
No.
Now, as far as the defendant's path of travel,
Somebody needs to buy this court
is it your
reporter
understanding that that was
flowers,
obtained from
a
multitude of
massage,
different witnesses?
Yes.
a weekend down the Capes, something.
Now, with reference to, you were asked some questions about the defendant's cell phone. As far as GPS locations, were you aware that the defendant's cell phone wasn't able to be accessed until
I got
by
new
law enforcement
in-ear
until
sleeves.
2023?
We're going to see if these
Sustained.
help.
Were you aware that the defendant's cell phone had GPS locations turned off on the defendant's cell phone?
I'll allow
Oh,
that.
that's interesting.
I was not aware.
I'm going to back up to that. The defendant's, hopefully this will come in, the defendant's cell phone had GPS location off. Well, that answers that question.
Now, with reference to, you were asked some questions about the defendant's cell phone. As far as GPS locations, were you aware that the defendant's cell phone wasn't able to be accessed until by law enforcement until 2023?
Sustained.
Were you aware that the defendant's cell phone had GPS locations turned off on the defendant's cell phone?
I'll allow that.
I was not aware.
But doesn't the car have GPS?
Now, as far as placing the vehicle during that triggering event, 12.
Honestly, a lot of people leave GPS on their phones off. He would have, again, the defense asked about it. That's why he's allowed to ask. He didn't know. Clearly, they didn't give him the entire case file, but a lot of people leave GPS off on their phone. I play too much Pokemon Go for that.
629B.
A lot of these questions are
Did you
leading,
use key
Chad.
cycles to put it back at that location?
The defense doesn't object to all of them because they want
No,
him
I
to be
didn't.
done too.
What did you use?
I looked at the odometer mileage.
And why would you look at the odometer mileage over the key cycle?
Because the key cycles don't make any
Because
sense
I
to
can
him.
physically see the odometer mileage at the vehicle at the time of my inspection.
The odometer mileage
Why
is
would-
helpful.
Let me ask you this. In your opinion, as far as that is concerned, sort of backtracking to a specific location.
Chat, no, we
which is
can't
more
send anything to the
reliable, odometer or
reporter.
the key cycle?
That would be inappropriate.
I
The
would
judge
say the
should do it.
odometer mileage.
And why is that?
Like I said, you can physically see it when you turn the car, and I know that's the odometer mileage that it's reading on the dashboard.
And every key cycle, is that necessarily recorded within the text stream data?
No,
And why not, sir?
it only records stuff that related to the triggers.
They don't what?
They only record stuff that is related to the triggers.
Okay, thank you.
But the key cycles
As far as
should still
counsel's
go up even if there's not a
hypothetical, with
trigger.
regard to the key cycles, is it your opinion that that hypothetical is accurate or inaccurate?
Inaccurate,
And why so?
because it also be you also add the odometer mileage onto the key cycle, so those key cycles and odometer mileage are on the same trigger, and plus the data seems consistent with everything else that's going on with this collision.
Now, Fair to say that you were not outside of 34 Fairview Road on January 29th, sometime around 12:20 to 12:30 a.m., is that correct?
Obviously
That's correct.
not.
And so fair to say that you don't know exactly how Mr. O'Keefe and/or Glass or anything that he's holding interacted with the
Lally, sir, good accident reconstructionists don't need to be there. They can reconstruct it.
defendant's vehicle at that time?
Objection.
I'll allow it. Is that true?
I do not.
And so based on your training and experience and the number of pedestrian crashes that you've investigated, again, if you could, one last time, just describe to the jury how you believe
Objection,
the
cumulative.
vehicle interacted with Mr. O'Keefe and why.
This is cumulative.
Objection.
Yeah.
Sustained.
It's cumulative.
Asked and answered.
Yep.
With reference to what you've described
The
as
court
far as the interaction
Sustain the
between
asked and
Mr.
answered
O'Keefe
because
and
it's
the
just,
vehicle, why-
it doesn't get
why
better
is
the more
that
he says it.
Your opinion.
Objection.
I'll allow that.
Based on the evidence from the vehicle, based on the injuries to John O'Keefe, the tail light appears to be broken and it's sharp plastic pieces that could have ripped his arm, and also the dent with the scratches above it is consistent with a hand holding a glass and the glass on top smashing on the vehicle, and the hand smashing the vehicle. You can see there's a line between scratches and a dent there.
Okay. Nothing further are great words. Next witness. Please.
Just Romeo.
Oh, please. Please, next witness.
Very briefly, I just want to make sure I clear
Recross.
something up about the key cycles. You're not suggesting that every key cycle in the history of the car is on this page, correct?
That's correct.
I'm pulling up Exhibit 591.
Okay?
That indicates key cycles that have triggering events, correct?
Yes.
Yes.
Triggering events are something that the manufacturer includes in basically a list of items that will be a triggering event, correct?
Yes.
It's a list of items basically for mechanics to figure out if there's some unusual driving or unusual event with the vehicle, correct?
Yes.
But the key cycles go in order. They're numerical, 1 through whatever.
Correct.
That's it. Leave it.
And the hypothetical that I gave you on cross-examination, with those driving incidents, each one of those would represent a key cycle, correct?
He doesn't know that.
I don't, so in your hypothetical, I mean, assume that it should create a key cycle, but that you can't just say that key cycle is from that, because I didn't just use key cycles. I used the odometer mileage on top of it. So you have to have key cycle and odometer.
Right. Interestingly, though, when you testified on direct examination, you said your analysis, this was on Friday, before the weekend. By the way, over the weekend, did you watch anything on, I don't know, YouTube or any social media?
Court TV.
No.
Nothing.
No.
No. Did you have any conversations with Mr. Lally about these key cycles and problems?
No.
Did you have any conversations with anybody about the issues with
It's outside
key
the
cycles?
scope.
No.
Did you realize at some point between Friday and today that I was probably going to ask you some questions about key cycles?
Objection.
Did you realize that yourself?
I assumed you would ask me
About
loads of
everything.
information.
So on Friday,
That's a
you
fair
didn't
assumption.
mention that your analysis was based on mileage, did you?
Objection.
Lally's already standing up. He did say that the mileage was important to his determination because he went back and tried to make sure he understood the mileage that would have happened with Karen Reed's card going to Dighton and back and forth. So he did testify quite a lot about the mileage and using the mileage. That he did do.
Sustained.
On Friday, did you mention that your analysis was predicated on mileage?
Objection.
He did say
I'll see
he
you
used
outside there.
both. He did say he used both. Lally's standing to object. The judge has them stand to object in this court, but he did testify that he used both. So let us zoom past this sidebar as the defendant is writing notes, presumably to hand to a attorney, not on a Post-it. I kind of missed the Post-it handing from Paul Tro.
May I inquire?
Yes.
Even Duffy heard there was
Paul, on
lots of
Friday,
Post-it handing.
You indicated pretty clearly that your analysis was based on the key cycles, starting at 1164 when you started your testing, and 1162, which was the key cycle you claimed on Friday was at 34 Fairview.
it wasn't based on it. That's how I describe it. I said key cycles. I based it on they were close within proximity to each other, but I've always said it's key cycles and odometer mileage, plus all the information within the triggers themselves. So it wasn't just one of the other.
And you said
That's
on
fair.
Friday that once you started your testing at 1164, it was
That's fair. He thought the mileage made sense. He thought the triggers made sense. He thought the U-turn made sense. He thought the things in the triggering event made sense with what he was looking at. And that made sense with the key cycles. And that made sense with the odometer miles. I imagine that another expert might see it differently. But for him, he's like, all of this together made sense to me. And the jury will get to decide if it makes sense to them or not.
2 cycles earlier that had the triggering events, meaning 1162, that you claimed were at 34 Fairview.
Yes.
But in the hypothetical, if there were 4 events, 4 key cycle events between 1164 and 1159, it could not have occurred at 1162, correct? 34 Fairview, in my hypothetical.
In your hypothetical, if it recorded a key cycle, then your hypothetical is correct.
Right. And last question, if you got the route of travel incorrect, if your presumption of the route of travel was incorrect on that vehicle in the days earlier,
Then what?
then your mileage would be incorrect also, correct?
Mileage from what? The odometer or from
The odometer reading.
the odometer reading is the odometer reading. It's 36.
My point is, your analysis that's based on the odometer reading, 36 miles here, 12 miles there, 2 miles here, 5 miles there, if you got the route of travel wrong and the route of travel was different, your assumptions about the odometer readings would be incorrect as well, correct?
So what I'm
You got the path of travel wrong.
so what I purposely put down a range on my Google images shown because I couldn't tell you her definitively route of path for every single way.
Right.
But I know that it's possibly a possibility that she could travel 36 miles within those locations that she traveled post leaving Fairview Road.
Or if that mileage was put on at key cycle 1162, then that would mean the vehicle would already be in Massachusetts State Police custody, right? In Trooper Proctor's custody.
Objection.
So that's beyond the scope.
That's all I have.
All right, Mr. Lally?
Just very briefly. The range that you came up with for the defendant's
Why are
path
we allowed to do redirect? Stop it.
to travel, does that fit with the path of travel, the odometer reading, putting the defendant's vehicle in the area of 34 Fairview Road when it does the 3-point turn, and then 8 minutes later when it travels 24.2 miles per hour in a straight line in reverse for approximately 62 feet?
Yes.
Nothing further.
All right, you are all set, Trooper.
Thank you, Your Honor.
That redirect, Riri's like, leave me out of this case. That redirect was, so everything you've seen puts the car doing those things at 34 Fairview, and he's like, yes, and they're like, bye. Next witness, which will be witness 65. Fucking hell, it's so many witnesses.
So jurors, we're going to take another short break to set up some things in the court. Okay?
All rise to the court, please.
They're taking a jury break. We're going to get to witness 65. I don't know what they're setting up in the courtroom, but guess what? We don't have to worry about it. We get to zoom. How you guys doing? That was I keep hoping for things to be made more clear, and then they're not more clear, and then I get more frustrated. All right, we zoomed past break, and we're going to go right back to court. So let us, give me 1 second. Did everybody catch up on Bridgerton over the weekend? I did not get to catch up on Bridgerton. Did you guys, those celebrating Father's Day or celebrating Father's Day with your family, have a good Father's Day? I hope so. Let's go back to court. All right. That's awesome. Back to court. Let's see who our next witness is that will be witness 65. I keep saying it out loud so I don't forget.
Thank you. Be seated. Close back.
Answer chat can remind me because chat is back.
All right, your next witness, please, Mr. Lally.
Yes, Your Honor. The Commonwealth to call Mr. Ian Whiffin to the stand.
Okay.
you, Ian.
And Mr. Lally, you just need to tell me when I need to give that instruction.
Yes, sir.
Which means we're probably going to be getting into either voicemails or text messages because the instruction is you have to determine what was said and if it was accurately said. So witness 65, Ian. I should be zooming, but I'm writing. Still love my e-ink writer and my notes this way.
Just raise your right hand.
Oh,
Do you
nice.
solemnly swear that the testimony you shall give to the court and the jury in the matter now pending shall be the truth, the whole truth, and nothing but the truth, so help you God?
I have no idea what he said.
Okay. Do you solemnly affirm that the testimony you shall...
He does not take the solemnly swear. He solemnly affirms. You can modify, it depends on jurisdiction, the court oath.
You just raise your right hand, please. Do you solemnly swear that the testimony you shall give to the court and the jury in the matter now pending shall be the truth, the whole truth, and nothing but the truth, so help you God? Okay.
He said,
Do you
"I'm sorry, I'd rather
solemnly
affirm."
that the
Yeah.
testimony you shall give to the court in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning.
Good morning.
Whenever you're ready, Mr. Lally.
Good afternoon, sir.
Good afternoon.
And if it's at all helpful, that microphone before you is adjustable.
Oh,
You
we can hear him just
put it in
fine,
any
Mr.
direction you
Lally.
wish. Just try to keep your voice up, okay, sir?
Thank you.
Now, sir, could you please state your name and spell your last name for the jury?
Yes, it's Ian Whiffin. So IAN WHIFFIN.
And,
I'm sorry,
what shift
Ian,
did you
I
use for
just-
work, sir?
Chat, responsible and respectful, chat. You know, the second he said H, the entire chat went, ooh, we very much appreciate you. We very much appreciate you. Yes, yes. Yes, yes. Not a Massachusetts accent. It's chat, breathe. Breathe, chat. Be respectful and responsible.
I'm currently the decoding product manager at Cellebrite.
And what is Cellebrite?
Cellebrite is
Yay,
one of the
tech.
world leaders in mobile forensics software.
And when you say forensic software, can you explain to the jury a little bit about sort of what is forensic software and how is it used, specifically your Cellebrite?
Yeah, so forensic software is used to gain
Yay,
access
Cellebrite.
to people's devices, cell phones primarily, to extract that data and to allow examiners to parse and decode that data to make sense of it in a more user-friendly way so that a report can be created for investigators.
I mentioned
Sir, if I could
Bridgerton.
ask
I
you just a
didn't
few
do it on
questions,
purpose.
Going back to,
I'm
some of
sorry,
your
Ian.
educational and prior work experience with.
It was my internet, not yours. I paused it immediately. I'm sorry. We're gonna figure out what that's going on, but let's jump back in.
Would work.
So-
What, if any, where did you go to school and what, if any, degree did you
I'm
receive?
gonna speed him up just
Okay,
a little bit
I
on
didn't
his
get a degree. I'm
background
originally
training
from the UK, where I did qualifications in computing, a higher national certificate in computing, and then joined the police in 2004.
And what department was that, sir?
That was response work. So South Yorkshire Police as a response officer.
And where
That
did
was
you go
it.
from there?
That was in the
In
UK,
2009,
Raleigh.
I immigrated to Canada, where I was able to continue policing with the Calgary Police Service, where I spent approximately 4 or 5 years, again, working patrol before moving to the digital forensics team of Calgary Police.
And with respect to moving to that digital forensics team, what, if any, specialized training did you receive in regard to that area?
So once I had made it into the digital forensics, I was sent to Ottawa for 3 weeks to do a foundational computer forensics course, covering all manner of digital forensics to begin with. Throughout my 8 years with Calgary Police, I did constant courses each year to keep information updated, including a 2-week course, again, at the Canadian Police College in Ottawa, specifically about cell phone forensics. And then also during that time, additional courses for extracting data for interpreting internet artifacts or any other kind of information found on a phone or computer.
And following that, where did you go from there, sir?
In 2020, I left Calgary Police Service and began working at Cellebrite as the senior digital intelligence expert, where I would use my knowledge of the forensic community to assist the developers with creating and maintaining a program that examiners would want to use. And finally, about 2 years ago, I moved to the decoding product manager position.
And can you explain to the jury sort of what it is, what your role is, and what is it that you do for Cellebrite?
Yep, so right now in the position that I'm in, again, I use my knowledge of the digital forensics landscape in the community. I talk with users about their daily challenges, what applications are causing them problems, what they need to get access to, what they need to understand. And I take that information, create a priority list, and then determine with our developers what we will tackle, how we will tackle it, and how it will appear to the end user.
Now, with regard to your education in this area, what, if any, certifications do you have?
No specific certifications. I've done the Cellebrite
He's like, I don't need
coursework,
certifications. I know shit.
since joining Cellebrite. But other than the 3-week course in Ottawa, and then again the 2-week course in Ottawa, I don't have the SANS training or any of that kind of training certifications.
So what are you here to testify about from
In addition
Cellebrite?
to your work with Cellebrite, what, if any, other
It's just
areas of the field
how
that you
Cellebrite does
work?
things, I would imagine then.
I'm sorry, could you rephrase that?
Sure. Have you given any presentations? Have you published any work in relation to this area?
Yes. So since working as an examiner, I identified that there were times that I needed to parse artifacts from applications that the main vendors didn't support. In response to that, I would do my own research. That research turned into a selection of digital forensics tools, and I created a website for myself to share that research, to share those tools with the community. And directly related to that, I have published articles related to accessing data on phones, related to SQL databases, related to various other artifacts, primarily locations.
Now, over the course of your work, have you had occasion to testify in other courts in relation to this specific field?
Yes, related to digital forensics, I've testified approximately 20 times, mainly in Canada, but also once in Michigan, once in Australia, once in the UK.
Now, as far as questions that come into your company with relation to interpretation of data, other sort of general forensic questions, what parts of the world do these questions come in from, and how widely used is your product?
I don't think he's a forensic examiner, Chad. I think he works for Cellebrite, and he's like, this is the Cellebrite extraction, and then this is what the Cellebrite extraction says. So he works for Cellebrite. So he's going to come in just for, this is from Cellebrite, this is what it says. He is not a forensic examiner, so he can testify as to what the product does, the same way like a Verizon expert can come in and say, these are the Verizon reports, I'm familiar with these reports, etc. So
the product
would be why
is used
he's here.
globally. There are a select number of countries that we don't export
He's a
to, but
product
generally,
manager.
if a police service is interested in digital forensics, then they're using at least some of our tools. We operate an email address which is open to any user called Stump Us, and the idea is that users, if they come across a artifact
Stump Us, I think, which is interesting.
that they can't explain, they can email to myself and some of my colleagues, and we can research that artifact, and we can try and give them an answer as to say why the artifact's there and how it should be interpreted.
You used the term in there as far as an artifact. If you could please explain to the jury
Stumpers.
sort of what
Stump
your
us.
understanding of that term is and how it's used within your specific industry.
Yeah, so I would refer to an artifact as essentially any piece of data which I've recovered from the phone, which is of interest. It could be a web history visit, it could be a text message, it could be a photograph, any piece of information.
Now, sir, turning your attention to September of 2023, at some point in that month, were you contacted by the Norfolk District Attorney's Office and the State Police in regard to this case?
Eventually, yes. Initially, I was contacted by a member of Cellebrite.
And if you know, why was that initial, as far as the initial contact or initial request from Cellebrite, can you speak about that?
My understanding was there was an artifact found on a device, and people were looking for an explanation as to how this particular timestamp was relevant to the case.
Now, if you could explain to the jury sort of what you, what were you provided and what were you asked to look at?
So the original question is just basically how can we explain this 227 timestamp? I spoke to my colleague.
Again, just to 227, again to 227, again. Are we going to get to the defendant's cell phone at any point? What point, if any, are we going to get to what the defendant's phone did? Okay.
And requested if he could contact the investigators and any information that they could share about where this particular timestamp was found so that I could investigate it. I was advised at that time that the case had already been uploaded to our own support network, so the full extraction of the device in question was already in Cellebrite's possession, and I was able to access it from there and start to examine what the issue was that was causing the confusion.
Now, with reference to this issue, can you describe to the jury, just in general terms, sort of what this issue was?
Yes, please.
Yes, so the issue, as I was led to believe, is there was a timestamp for a web history artifact of 2:27 and 40 seconds AM local time, which would be UTC-5, and it didn't make sense to the investigators. And the question was, is there any other interpretation for what this timestamp could mean?
And so essentially you were asked to explain the timestamp and how it came to be, correct?
Correct.
And as far as this particular
Two witnesses
issue,
for
has
this.
arisen in other instances? Have you been asked the same question or similar questions in regard to this type of artifact?
Yeah, several weeks later, so probably around December time last year, I was contacted by a police investigator in Austria with a very similar question, but related to obviously a different internet search. And about a week later, the defense expert in the same case also contacted me asking the same question. The defense expert in that case was able to provide the database, and I was able to provide the answer.
And the answer is?
Now, as far as
No,
the,
Lally, just...
the full extraction
Lally, no, just... And that answer was?
is that the entirety of what you looked at in this instance, or what, if anything else, were you provided with in regard to your review and your analysis in this case?
So I did work with the full extraction, but my interest was focused on just the web history artifacts.
And what, if anything, did you find with regard to the web history artifact?
So the 22740 timestamp was correct insofar as that is the time that is shown within the database. It was indeed a deleted record, but the interesting thing was why the timestamp said 22740. And I did some testing on this and discovered the reason why 22740 was actually listed in the database, even though that's not the time, in my opinion, that the search was conducted.
And
You know how important
what
the
is your
Commonwealth
opinion
thinks
as
this
to when the
is?
search was conducted?
You know how important the Commonwealth thinks this Google search is when they have brought in now 2 experts to explain that 227 timestamp. I think that this expert probably is easier for the jury to follow. The other tech expert was very much in the technical data in her explanation. This is a bit of a higher level explanation. So let's hear what he has to say.
There's plenty of other evidence on that extraction that shows what activity was occurring at 2:27, 40 seconds. And there's plenty of evidence later on in the day that shows that that particular search was conducted at 6:23, I believe 51 seconds, and then a similar search at 6:24 and 18 seconds, I believe.
And before we get to that, Your Honor, may I approach?
Yes.
So two experts with regard to Jen McCabe's search or not. Well, it was searched. What time it was searched, I suppose, is the appropriate query.
This was the internet history, the history.db database table showing activity from the morning of the 29th of January 2022.
May I approach again, Your Honor?
Yes.
I'll seek to introduce in minutes the next exhibit.
No objection.
There are like 500 and something exhibits, if not close to 600 exhibits.
Your Honor, may I return to the witness?
Yes.
Your Honor, if I may, with the court's permission, to republish it for the jury.
Yes.
All right, they're publishing it, so at least we'll get to see it.
Your Honor, may I approach this to retrieve?
Yes.
I'm going to zoom it.
I
till
do,
this
yes.
is up on the screen.
And, Ms. Whiffin, there should be a laser pointer on the desk next to you. What I'm going to ask you to do is,
Husband
if
is-
you could, using
Husband
that
is
laser
calling. Give me
pointer,
1 sec.
Explain to the jury what we're looking at in this exhibit and what, if anything, of significance you observe within this exhibit.
Okay, of course. So this was a table I created based on the data from the phone. The first column shows the local time of a record that was written to the history database. This is a database which is tracking all web pages which are loaded as you use them. The second column starts with the URL, so the Uniform Resource Locator, so what you would type in or how the browser knows which website you want to visit. The title is part of the website which is loaded. One of the top attributes of the website will load the title. Visit count relates to an internal counter within Safari, which just tracks how many times a particular website is visited in order to make suggestions to down the road. And then finally, the last column shows the source of this information. So history.db is the name of the database, history_visits is the name of the table, and then the number is the unique identifier, which is assigned to that particular record.
So 51,
in
50, 51, 52, 53.
consecutive order. So every time you add a new record, that number will increase by 1.
Hey, Mr. Whiffin, probably a couple foundational questions that I should have asked you first, so my apologies. With respect to the cell phone extraction that you were provided, that was from a individual named Jennifer McCabe, is that correct?
That's my understanding, yes.
And fair to say you don't know Jennifer McCabe, never met her, don't know anything about her?
Correct.
And as far as a extraction is concerned, if you could please explain to the jury sort of what your understanding of that is. What is an extraction?
An extraction in this case, all of the files and folders had been extracted from the device, saved on a computer in a zip file container. So essentially in a way that is as close to the original from the device as possible.
And again, what is your title specifically with Cellebrite?
It's decoding product manager at the moment.
And so what, if any, relation does what you do have with relation to an extraction and how that's, what's sort of the relationship between what you do and a Cellebrite extraction?
So once the extraction's been extracted and we have the zip file, then Physical Analyzer is the tool that Cellebrite creates to allow examiners to look at that extracted data in a meaningful way. And my role is somewhat shaping how examiners will see that data when they open up Physical Analyzer and look at the extracted data.
Because he deals with the product side of
How
it.
does your role play into that? What is it that you do that what, if any, relationship does what you do have to do with how examiners will view something from a Cellebrite tool?
Again, so
Can you
after
explain what
being an
product
examiner
means?
for 10 or 11 years,
Thanks, Lally.
I've got that kind of understanding of how examiners work. Being someone who also writes my own software and does my own research, then I can kind of cross that void that usually exists between developers and examiners and help both parties try to come to a meaningful conclusion.
Ms. Gilman, if you could shrink that just a little, or zoom out a little. Now, again, Mr. Whiffin, if you could, using that laser pointer, direct the jury's attention to what, if anything, of significance you observed depicted in this particular case.
Yes, so the lower two records, which are highlighted in green, are two records which occurred at 2:27 and 42 seconds local time. So 2 seconds after the Google search had allegedly been made. And then the second record is 5 seconds after that at 2:27, 47 seconds. Both those URLs relate to a website of hockamocksports.com.
Now, if you could explain to the jury, what is a contiguous identifier?
So again, every SQLite database will assign a unique contiguous identifier number. So again, the very first record created will be given a record ID of 1, the second record will be 2, and so on and so forth. Those numbers are never reused. So if I was to delete record 3, that record number will...
So she was searching Hockamock Sports at, it looks like on 129 at like midnight, because that looks like 0042. And then 1:59 a.m. and then 2 a.m. and then 2:26 a.m. and then 2:27 a.m. That's what it looks like from this record.
never be reused, and I can see that there's a gap
Different
and
pages,
deleted data
though,
in that
from
database.
that. Like different pages within that.
You used another term in there as far
Website.
as a SQLite database. If you could explain to the jury what your understanding of that term is based on your training experience.
Yeah, a SQLite database, essentially, it's a series of tables. It's a way for data to be stored, again, in a meaningful, organized fashion that can be queried, can be examined, can be filtered, searched, etc. It can be useful for anybody who wants to get data from an organized file.
Now, with reference to the searches that you observed within this particular...
And I'm
web
not going to
history,
speed him
what,
up
if
because
any,
Lally's not
relationship
doing a ton of background, which I appreciate.
identifiers,
He's getting right into
range? What, if anything,
the
that-
determinations. So
I'm sorry, can you rephrase that?
What, if any, observations
So I don't
you
wanna
made
miss
as far as those
his
contiguous
determinations.
identifiers in the range they had in relation to the web history that you observed?
Okay, so within the history.db file, there were no missing numbers from the beginning of January, essentially, until early February. That told me as an examiner that no records had been deleted during that time.
May I approach again, Your Honor?
Yes.
So he's going to have to ask why the Cellebrite report and have him explain why the Cellebrite report says deleted. The other expert testified it's because it was not written onto the database and it wasn't deleted. It was just not written onto the database and it was recoverable. So that's not a true deletion. So he's going to need to explain the Cellebrite chart
do,
that
yes.
says
Do you
deleted.
recognize that to be?
This is the browser state record, which identified a search at 2:27:40 a.m.
May I approach again, Your Honor?
Yes.
Almost.
The last chart that he put up didn't have the 6 a.m. searches, but those were all confirmed. The 6:20, the 6:23 and 6:24 searches were all confirmed. There's no, the controversy is
Yes.
whether a search also happened at 2:27 or not. The 6:23, 24 searches are not in
Now, sir,
controversy.
directing your attention to the screen, is that what you have before you as the next exhibit?
It is, yes.
And if you could explain to the jury what we're looking at,
This is what the defense brought up when talking to Jen McCabe. This is also what they brought up in their opening statement.
this exhibit, and what, if any, information you're able to sort of glean as a forensic examiner with relation to
Okay, so this is a searched item exhibit. It's technically a derivative of a different exhibit that we find on the device. So we found what we consider a web history record. So a web history record would just mean we have a URL that was visited and potentially a timestamp and a title. Searched items looks at all of the web history items that we've found and tries to identify were these actually searches that were conducted. So for example, if you were to do a search on Google, you'd see that the website that you're taken to is google.com query, and then it contains the query string that you've typed in. We extract that information, we extract that query and provide it to the user as a searched item. In this case, I can see that it came from the browserstate.db WAL file. The search query itself was hoslong to dying cold, and it shows as a deleted record.
Now, with respect, I think you've used a couple of different terms within that as far as a knowledge C database. Can you explain to the jury what that is?
I don't recall saying knowledge C, but I can explain what knowledge C is in this case.
If you could.
Yes.
I don't think he said knowledge
The knowledge
C
C
either yet.
database is at the heart of iOS. It stores lots of information about the activity on the device.
He's going to explain why it shows deleted, even though it was recovered, because it was not deleted by, the user, is what he's explaining. So.
At any given time. Things like when the backlight's turned on, when the device is unlocked, what application is in focus at the time and how long it's in focus for. And important to this case, which website's on screen at any given time as well.
Now, when you say when a website is in focus, can you expound upon that as far as what exactly do you mean by when you say in focus?
So in terms of iOS itself, when it's in focus, it would be the primary item that's visible on screen. So with iOS, you can have applications in the background that you aren't using, but the one that you are currently using is considered in focus, taking up the entire screen.
I believe you had used the term as far as a browser state DB, is that correct?
Correct.
And can you explain to the jury what your understanding of that term is and how it relates to it?
Browser state DB is just the name of the database, the name that Apple gave it. It's gone through some changes over the last few years. For example, in iOS 14, it did store the state of the tabs that were open within a browser. In iOS 15, there was a significant change, and the only time that records were written to the database is when the tab was closed. So a significant difference in that it doesn't show you what's currently open, it only shows you what's previously been closed.
Now, this search here, what, if anything, did you observe as far as this record in relation to the history DB related to the search term?
This record is not mentioned at all within the history.db database.
And what, if any, missing records from this time frame did you observe either?
There were no missing records in the history.db database. Within this time frame, within the browser state database, there were 3 deleted records.
And when you say deleted records as far as your Cellebrite tool is concerned, what exactly does deleted mean?
These are records that have been deleted, not necessarily by the user, potentially by the system, but they are considered deleted records that we're able to recover.
What are some of the ways that something might be deleted by the system, and which, are you talking about the phone or are you talking about your tool?
The phone. Our tool is designed as a forensic tool. It's not going to edit, delete, or affect the data in any way, just present what is in the extraction. But there are multiple times on an iOS device or an Android device where cleanup essentially happens, and we start to lose data after a certain amount of time.
Now, with respect, let me just ask this for a moment. With respect to Cellebrite, as far as the tools, have there been a variety of different versions of those tools as far as conducting that forensic extraction?
Yes. So Cellebrite Physical Analyzer has been available for approximately 12, 13 years in various versions.
And what, if any, differences are there between, in general terms, between, say, an older version versus a newer version?
Obviously, in the digital forensics landscape, whenever a provider creates a new feature, we have to change.
There was a great question in the chat, and I've seen it's my internet today, not yours. Dr. B has already gotten on the phone. I've seen a number of you guys ask in the chat, and I wanted to pull up one of them if I can. And stuff said, didn't Jessica Hyde say the Cellebrite data was wrong? She didn't, to my recollection, say the Cellebrite data was wrong. She said the Cellebrite data needed to go further because it was pulling from different directories. He's here to explain why you use Cellebrite with other softwares, potentially to look beyond what is in the report and what that's pulling from. So deleted meaning the database could have deleted it, because he's just saying, I didn't see anything deleted from web searches on the phone in a different database. So he's explaining that this was not deleted by the user in the way he's seeing the data. And that's not what it means when it shows deleted. He's saying the deleted on the report that we just saw can mean multiple things. And that's why you need someone to interpret it, because it's just an overlay of the data. Sometimes you need to dive deeper into it. So that's what he's here to explain, is that you need to dive deeper in it. You can't just look at the report and go, aha, that means that. The state clearly thinks that this is a very big deal, because if Jen McCabe was doing this Google search before John O'Keefe was found, it very much goes to the defense theory. If she was not, then the defense theory doesn't have much foundational evidence other than they're saying these things could have happened. The Google search is a tangible bit of evidence that the defense can rely on, that the state is attempting to disprove, and go through what is meant here. So RPB says delete doesn't mean deleted. No, delete doesn't mean user deleted. It can mean database deleted and more. So that's why we're going through what is being used and what Cellebrite's doing. And I think he's going to start explaining the different versions of Cellebrite don't always play well with the newer versions of iOS, and explaining what it means. So this is all going to trying to block the defense's third-party culpability, I think, and not necessarily going to what Karen Reed did. But it's important, because if you're sitting there going, well, if somebody's Googling how long does it take to die in the snow at 2:27 a.m., obviously there's fuckery. If that's not exactly what that means, then there's room to take a look at this and go, well, it was absolutely Google search, but not until 6 o'clock in the morning, which is consistent with Jen McCabe's testimony. So that's why we are going through this. Allison asked, how bad is this for the defense? We're going to have to see the defense experts. The thing is, it's disproving what Jen McCabe is doing. It's not pointing to what Karen Reed is doing. And I still think the state has problems with that they're proving Karen Reed is doing. So this is the state, the Commonwealth, running down the defense's theory, not proving their case in chief. I don't know if the judge is not going to allow them to do much in the way of rebuttal witnesses, because it seems like he would be an excellent rebuttal witness. But I wonder if the reason the state is doing this is because the judge told the defense they have to have established evidence before they can get into a third-party culpability defense, before they can get jury instructions on it, before they can argue it, before they can put on witnesses about it. And I think the state is trying to cut that off before the defense gets to their case in chief. So we will see. That is my thoughts and speculation on why we might be seeing these witnesses in this order. Of course, that is just my thoughts and speculation on why we might be seeing this in this order. So let's keep going. Question, why would someone choose affirm versus swear? What's the difference? It's more of a secular, non-religiously based way to affirm that you're going to tell the truth. So personal choice that really doesn't ring one way or the other to me, like bothers me literally none. So that would be why. All right.
Change our code to adapt to what they've now introduced. There can be research that has been done, so we now learn new things, and we add support over time. So something can be supported in this new version of Physical Analyzer that may not have been supported or even existed in a previous version.
Now, With respect to your work in this field, what if any tools have you designed and or created or something to conduct this type of work?
Aside from Physical Analyzer?
Yes.
Okay, so I have my own tool called Artex, which I've been working on for around 5 years.
It's like, what else did you build? He's like,
since
I
being an
built shit.
examiner myself and struggling to parse any particular application that I needed. So I started to write my own tools, and that's the one that is one that I still maintain on the side in my own time, partly for my own.
Of the witnesses I would love to sit down in this case with and have more of a conversation with, this witness is fascinating on the coding side of the forensic tools, but I also think that the Cameranos and the Kolakithises would be an absolute hoot to, sit down with. But he is fascinating. Okay, I'm going to stop interrupting. I want to just tell me the things.
Partly because I think it still introduces some fantastic features which aren't available in any other tool for research purposes. So yeah, I continue to write this tool to this day.
And could you just
And Chad, I don't think he's not
ART,
so much
yes.
advertising his stuff as explaining why he's an experty expert. When you get into experty experts, they need to show why they are the most experty expert, because the defense experts are going to come in and be like, no, I am the most experty expert. So you have to do all of the puffery that's needed, because when it's a battle of the experts, you absolutely have to explain why you know your shit. And him building his own tool for research purposes is important to him being an experty expert. Amy Van Dyken, don't come in here asking logical questions. Good to see you in the chat, friend. Do we know how the victim died yet? No, but we're learning all about this man. So, experty expert. He's easier. He explains things on a more digestible level to the jury.
What are some of the reasons why this may occur, or why this may read as it does?
Sorry, is it deleted?
Yes.
Oh. The record itself has been deleted. As I said, the reason why it's deleted, through my testing, I've only found 2 ways that kind of record can be deleted by the user. And I don't believe either of those ways was actually utilized on this device.
Why?
What are those 2 ways?
The user has the option to selectively delete history items. So you can delete either one at a time, or the entire day's content, or the last 2 days' content. Or you can delete all content altogether. If all content had been deleted, we wouldn't have found any information on this phone at all related to web history, so I was able to discount that one quite quickly.
Well, it takes really good experts can translate a high level to a, somebody doesn't know anything about this subject. And I think he does a good job at taking a high level and making it accessible to people who have no background in this subject. Okay, let's keep going.
And I guess alluding to what you just said,
2 ways
why
you
is
can
it
delete.
that you
Have you
don't
seen any
believe
history
that,
of this?
Either of those 2 methods of user deletion.
Because they leave a trail.
I'm sorry?
I said objection, may we approach it?
Okay.
It's interesting that Yanetti's doing a lot of the tech witnesses. I dig it. I often dealt with our expert witnesses as well. I'm zooming past sidebar, but he said there are 2 ways that a individual user can delete things or delete search history, and he's getting into why. But everything you do on your phone leaves a record, right?
Mr. Whiffin, moving on from that for a moment, may I approach the witness, Your Honor?
Yeah.
Moving on from that for a moment means there might be an issue.
Yes.
Interesting.
Thank you.
And Chad, I also see you casting this witness in like the entirety of the Akatar series. Yes, I see you.
Yes.
And what do you recognize?
I just can't get distracted.
It's a document that highlights both the search terms that were found in mobile safari.plist and the method of searching.
May I approach again, Your Honor?
Yes.
Commonwealth to seek to introduce and submit as an exhibit. No objection.
Okay. And yes, it is frustrating that we don't have a lot of answers in this trial, and we are spending quite a lot of time fighting over this Google search for a non-defendant. It's just, it's frustrating.
Of course, Commissioner may publish it to the jury.
Okay.
And Ms. Whiffin, do you recognize what's up on the screen as the next exhibit?
I do, yes.
You did use a term in there, I believe, called a P list. Is that correct?
Correct.
Can you explain to the jury what you understand that term?
Sir, can you talk to us more about the search at 1:06:48 p.m. on the 30th about BPD and John O'Keefe? I also want to hear more about that search.
To meet and how it relates to what you're about to talk about up on the screen.
Yes, so a P list or a property list is Apple's way of storing serialized data. That essentially means a list of data with names and values.
And, sir, if you could, again, using that laser point, direct the jury's attention to explain sort of what we're looking at and what, if anything, of significance you observe in this particular slide or table.
Yeah, so again, this is a table I created from the data within the mobile Safari.p list. The term shown down the left is what the user would have typed in to the search bar. Sorry, I keep blinding somebody. The search bar in the bottom of the Safari browser window. The UTC time is the time which is actually recorded within the P list.
Oh, sorry.
It's
It was, I didn't even catch that was UTC, not UTC -5. So Jem McCabe would have been searching BPD John O'Keefe at 8:06:48 p.m. on January 30th.
As a string, so just text as it's presented on the screen there. And then I converted that and subtracted 5 hours to bring it into local time around Campton.
Now, aside from this, just for a moment, with regard to...
Leave that up because I need to make a note.
Are you familiar with what's termed as a
No!
private browsing mode?
Damn it. I'm not done making notes. Sorry, chat. I'm pausing as I'm making notes because I wanted to see, and I have not noticed on the other exhibits, something that's important to me, which is they keep arguing that the reason the Hoslong to die in cold showed up on the tab from 2:27 with that 2:27 a.m. timestamp is because it was the last search. So this chart makes it easy for me to see that the first search was the how long TI, DIE, and CIKD, and the second search was at 6:24:18 a.m. the Hoslong to die in cold, because I hadn't seen them back and forth. So that's what I wanted to double check, that was in fact the last search in this series. But why wasn't the BPD and John O'Keefe the last search if that happened on the 30th? Also, when I'm talking BPD, Boston PD is what I think they mean in that search. So then why wouldn't that one show up when it was extracted? And maybe it's because it switched to a different day. So, and that would have shown for a different day. I don't know. Let's listen.
Are you familiar with what's termed as a private browsing mode?
Yes.
And can you explain to the jury what that is and how it relates to this?
Yeah, so private browsing mode is a setting that you can set on
It's not private.
iOS devices, or primarily most devices, that prevents any of your browsing activity being recorded. So it won't save the searches, it won't save the navigations, it protects everything so that it can't be found later on.
Really?
And what, if any, relation did that have to what your analysis of the extraction in this case?
If these searches had been conducted while in private browsing mode, these searches would not exist within this file.
That's a good question, Lally.
So is it your opinion that they were not conducted in any kind of private browsing mode?
Correct.
Now, you also familiar with...
Lally asked that question for argument. If you knew something horrible happened, why wouldn't you at least switch into private browsing mode?
The term as far as failure to load?
Yes.
Can you explain that to the jury and how that applies to this instance?
Yes, so obviously whenever you try to visit a web page, there's a stream of information coming from the web to the device, which then renders onto the screen. At the completion of the load event, there's a function effectively which runs, and that records the visit to the history database. If for some reason the page doesn't load and it shows up with an unable to load message, so for example, you don't have an internet connection at all, that unable to load will be recorded. If, however, the device stalls and it just sits kind of waiting to load,
You're going to have to be real careful with your use of the word load. I can already see where this chat is going. So I'm just a warning. Just a brief warning.
nothing gets written to the history database. And if you were to close the browsing window prior to the page completing its load event, nothing will be written to history.
Or would that be written to somewhere else within the phone? As far
Yes,
as
if
any
it
other storage
fails,
areas?
if the load fails, it doesn't get written
Technically,
to
the only
history
place I found
chat.
would be the browser state.
Now,
There's literally nothing to write
regard
home
to
about when the load
list,
fails.
Files, does the
Look, every case has a moment.
file save all sort of history items or no?
Primarily, it's used to save preferences. So you'd have a lot of information in there if it's using light mode or dark mode, or when you want tabs to auto clear, that kind of information. But it also records several days' history of searches. The actual number of days searches, I actually don't know.
And what, if any, relationship does that have with regard to the search bar that's located on the bottom of this table?
Chat,
In order
y'all are
for
the
the
best.
search item to be saved to the mobile Safari plist, you need to actually type it into this particular search bar. If you were to just visit google.com and start typing into the Google search bar, it will not be recorded within the mobile Safari.p list.
And so,
So-
what, if anything, were you able to determine?
Private browsing, I see a lot of you asking in the chat, private browsing versus incognito. I'm trying to rein myself back into what we're talking about actually in reality and not just in the chat. Is, I think, different words. Google and Chrome are incognito mode. Safari uses private browsing mode when you're using Safari on the phone.
Determine about those two searches with regard.
You know what's happening, Warren.
So these particular two searches were conducted at 6:23:51 and 6:24:18 respectively. They were searched using the search bar that's built into Safari. The fact that they didn't exist within HistoryDB and that there were no deleted records from history.db leads me to believe that they never successfully loaded.
Yeah,
That's
Prosecutor, Your Honor.
important. There are no deleted records from the HistoryDB database. So that's why he's saying they didn't write because, and were not user deleted. So that's why, that's what he is talking about. So who deleted or how it was deleted or why it showed that it was deleted.
What do you recognize that to be?
This was the additional, the items from the
Twisted Puppet, what he's talking about right now is the note of deletion and saying that it didn't write onto the database, but that nothing from the database DB shows that there were deletions. So the reason Cellebrite would have said deleted is because it didn't write or load into the database. So that's what we are talking about, not the search specifically at the moment.
history.db, I believe.
May I approach, Your Honor?
Yes.
I'm going to seek to introduce and admit as the next exhibit.
Okay,
Objection, I'd like to be heard, is what Yannetti said about the next exhibit. We're going to zoom past this sidebar to get back to whatever that next exhibit is that looks like it's coming in because it's now up on the screen. I was trying to do this
Display that for the jury.
quickly enough to not
Yes.
make the spinning wheel of death happen. And I'm sure the court is already at lunch. I'm just way behind today because I've talked a lot this morning.
What we're looking at in this table and
There was a lot that needed to be talked about I think, with these witnesses today. So this is this user created table that's showing P-list terms. So the search terms, raining men at 16:49:30. Well, now at least we have some context for why the fuck they were talking about it so much weeks and weeks and weeks ago. On 127 at 16:49:31. Then on 128, Antoinette OKO in basketball. I think that was the coach. And then on 130 at 8:06 and at 12:14, BPD and John O'Keefe, Apollo Pizza. And then on February 1st, Canton High School, John O'Keefe. And then on February 2nd, John O'Keefe obituary. And then Jennifer McCabe is now searching for her own name, Jennifer McCabe.
What, if anything, is significant between sort of the two sources of information depicted here?
Okay, so
this is the P-list
first
data.
list, the P-list term shows the term within the mobile Safari.P list, excluding the two that we've already mentioned, which are of note. And the first timestamp column shows the timestamp according to that P-list. The history item shows the search term as recorded in the history database.
Linda and I
And
agree.
then we have the timestamp as per the history database. So the purpose of this document was to show that we have a search for raining men and a history item related to the Google search for raining men, and they show within a second of each other. Again, the next one down, Antoinette Ock and basketball, and the associated Google search. And again, the timestamps are within a second. This list was non-exhaustive. There was hundreds of examples within the history.db, but limited examples within the mobile Safari P-list. And as I mentioned, the two searches of interest, the how long to die in the
I don't know if it's weird that she was Googling herself. I don't know what the conversation in Canton or online was on February 2nd, 2022. I'm interested to hear if it comes up on Cross, because I don't know what was going on like at that time while she was Googling herself. So the raining men came up. For those of you who are new coming into this case as we're getting towards the end, I totally understand. The raining men came up weeks and weeks and weeks ago for something that was going on at 34 Fairview. That night, they were pulling up a video about It's Raining Men, and numerous witnesses talked about it. That is now in these search terms, so it gives us some testimony that is consistent with this. So what I want to hear him explain is the P list versus the history DB and why those particular searches are missing.
and Hoslong to Die in the Cold didn't exist within.
So now I'm going to back up because I paused and was talking.
And the associated Google search. And again, the timestamps are within a second. This list was non-exhaustive. There was hundreds of examples within the history.db, but limited examples within the mobile Safari P list. And as I mentioned, the two searches of interest, the how long to die in the Kikdi and Hoslong to Die in the Cold, didn't exist within the history DB at all.
So chat, I see some of you asking about the It's Raining Men. The testimony from 34 Fairview was that they had found something and they wanted to show the group because it was a video or whatever of It's Raining Men. And Jen McCabe, she didn't say she pulled it up on her phone on the 29th. No, on the 28th at Fairview, but somebody else did because they had seen it and were trying to, it seemed like they were mocking one of her, either her sister, her sister-in-law, or whoever, but that is related to that because they had said they had looked it up right before. So that's what I relate that back to because it relates back to the testimony. So hopefully that helps, chat.
Ms. Gilman, you can take that down. Now, sir, if I could ask you just a little bit now about the browser state DB. Again, can you explain to the jury sort of what that is and how it, if at all, it plays a role in your analysis?
Yep. So initially, pre and including iOS 14, the browser state database would show all tabs that you currently had opened. So as soon as I go into my browser and open a new tab, a record is created. It includes information such as the time that I opened the tab or the time I last viewed the tab, the current URL which is being displayed within that tab. It shows information whether it's in private browsing mode or not. So in that kind of case, in iOS 14 and below, we're able to see current private browsing records and subsequently recover deleted ones. But in iOS 15, things changed. The record was no longer written as soon as the tab was opened. It was only opened when the tab was closed. The record was only created when the tab was closed. That meant that our ability to recover that kind of history was significantly lower. It means that it no longer makes use of the private browsing field because now private browsing records simply are never written to that database. So now we can only really see a list of all of the tabs that have been closed, not which are currently open.
Now, with regard to the browser state DB, is there something referred to as a last viewed timestamp?
There is, yes. That's one of the fields within the database.
And can you explain specifically with relation to that field, sort of what kind of information is kept there and what it means?
Yeah, so
Private
from my
browsing has
research
gotten
based
more
on this,
private.
that timestamp relates to the time that the tab took focus. So that's either when the user creates the brand new tab, when they switch between tabs and bring a tab back into focus, when they close a tab, which automatically brings one of the background tabs into focus, or if Safari has been completely closed and reopened, that essentially acts like almost a new tab.
I mean, me, because I swipe out of all of my
The
tabs
timestamp gets
multiple times
updated
a
at that
day.
point.
My husband,
Can you explain
however,
how an earlier timestamp
chat, let me know. Does this relate to anything that he's talking about? Sort of. But do you swipe out of all your programs? iOS users, I have no idea about Android. Apologies, we'll get into that conversation later. But iOS users, do you close out of all of your programs on your phone, or do you leave literally everything running? Because my husband leaves literally everything running, and then he's like, why is my phone slow? Like, he'll ask me to do something on his phone, and I'm like, this? And he's like, why are you closing everything? And I'm like, why is it all open? It becomes a central feature in our household of why everything is open. I'm like, I can see every game that Griffin has played on your phone for the last 3 months because they are all just sitting here in the background. And then you ask me why it's slow. Sir, what? Anyway, thank you, chat, for letting me know. I swipe everything out. Close everything all the time.
could be associated from, say, tab is open, something is done, tab is closed, tab is reopened, something else is done. How that earlier timestamp could then be associated data-wise with the subsequent search.
This is important.
Subsequent opening of the data.
I think I followed that.
Sir, it's not you, it's him. It's him. It's 100% his question. He wants to know how the Cellebrite report thinks that 227 is the time of search. That's what he wants to know.
That earlier timestamp could then be associated data-wise with the subsequent search.
That's funny.
I think
Subsequent opening of the data.
I think I followed that. Okay, so if, for example, at 12 p.m. I create a new tab, I can do a search for whatever I want. And at that point, if I close the tab, then the record that gets created will show that I opened a tab at 12 p.m. and I did a search. Excuse me. However, if I open the same tab at 12 p.m., do a search, close it, like completely close down Safari and reopen Safari, that would also update the same timestamp to show that I'd opened it up again. What I meant to say at that point is that if I create a 12 o'clock tab, minimize Safari. I can leave it for several hours, for several days, for several weeks. The time difference is not really important. When I come back to it and open up Safari again from a background state, the timestamp is not updated. So it will still show 12 p.m. today, and it will show whatever my most recent navigational event is. So I can search for something in 3 weeks' time using the same tab I opened today, and the timestamp will show today's time.
All right. I think this is a good place to take our break.
Yes,
Mr. Whiffin, we're going to, of course, ask you to stay with us, okay? As the
So-
jurors file up, you can file up behind.
As they go to lunch, and I'm not going to take long for lunch, but as they go to, here, we'll summarize this. I'm only going to take a few minutes, Jack, because I think we'll be able to catch up in real time.
And could I see counsel regarding timing, please?
All day, the judge has said, can I see counsel regarding timing? Your Honor, can you tell us what you're thinking regarding timing? I mean, I've got a concert, VidCon. We have things to do. Everyone would like to know where we're at with timing. The jury would like to know where we're at with timing, I'm sure. And I'm going to wait for the judge to see how long she says their lunch break is. So we have some, if she does, put it on the record. Because Lally is, the defense was supposed to start their case in chief today. That is what they had been anticipating. That's clearly not happening. We have still not gotten into the victim's phone, the defendant's phone, and the medical examiner. There are at least 3 critical areas of testimony we have not gotten to in this case. And yes, I understand leave the most important stuff for last, but did you need to ask everyone where they sat in the bleachers at the Canton basketball game? No, you didn't. And that's why we're still here. So.
All right, so recess until 1:40.
You are unmuted.
She said recess locally until 1:40.
Lunch and recess, 1:40.
So that's about 5 minutes from now. So we should be able to not only catch up to real time, but take like a 5-ish minute break, which I will do, and then come back to court. So I'm not going to take much of a break at all. I'm going to take a break to go to the bathroom and grab a snack and another cup of water and put it in the office. And we're just going to go through, we're just going to keep on going through the rest of the day so we can zoom. So will I start a few minutes back from real court? Probably, so we can continue to zoom. Let's go through what that witness's testimony was as we're at the lunch break real quick. The state has their, 65th witness on the stand, who is from Cellebrite. The Cellebrite witness is explaining, again, Jen McCabe's Google search, why the Safari tab time at 2:27 a.m. would extract in a Cellebrite report showing the last known search and showing deleted when he says there's nothing in the history database to show it was user deleted. That is the core of his testimony. I am sure the defense experts will disagree with it, but the core of his testimony is whenever you open and pull up from the background that browser tab in Safari, it will show the timestamp of the tab activity. Then the searches are later, and the databases show the searches at 6:23 and 6:24 a.m. Why does that matter as to what happened to John O'Keefe? It goes to the defense's theory, because if Jen McCabe was Googling how long to die in the cold at 2:27 a.m., doesn't it indicate something else happened to John O'Keefe? So it's very important to the Commonwealth, it seems, to head that off. I wish we saw the Commonwealth focusing as much on how they think Karen Reed's vehicle hit John O'Keefe, but we finished with their vehicle reconstruction expert, and that testimony was not clear to me. So because there are so many questions, and because the data we got from the Toyota service app that they downloaded was based on when the cycling of turning the car off and on is, there isn't GPS data from the car. And if there is, they don't have it. So is that going to be reliable for a jury? I don't know. We're going to have to wait and see till we get to the end of the state's case, which it should be soon, because Tuesday is an entire day of voir dire with no jury. And the judge has repeated to the jurors, we're going to get this case to you sometime the last week of June during VidCon. So with that, we are going to take just a few minutes. I will come back and answer questions. I'm going to take a moment to use the restroom. Chat, you don't have to go anywhere. But I suggest you hydrate, grab a snacky snack, use the restroom. I will put on our lovely StreamYard music and we will vibe for a moment, because court will be back in just a few. I will be back probably about 5 minutes after court is back, just so I have time, because I'm going to need like 5-10 minutes. We will notify you in the app when I am back if you need to step away for yourself. But it seems that we're almost at the end of the prosecution's questioning of this witness. And if the defense is consistent with prior cross-examinations of expert, we will probably get a briefer cross and then into the rest. I imagine the court is going to try to zoom through the rest of the afternoon testimony and maybe hold the jury till like 4:30 Eastern so that we can get through that testimony because there is no court tomorrow. I have asked if the voir dire is going to be streamed. I think it will be, but I'm waiting for confirmation on that. I intend to be back tomorrow with that voir dire, but mods, take a minute and everybody take a moment to get hydrated. And Miguelina, let's do that after stream today. And then let's roll to our lovely, let's go to our daydreaming music, shall we? It's our vibe. I will be back in just a moment. Chat, let's see. We should set an actual time. 12:45, if court's not back, I will let you know in the chat and I will come back a little after that. So 5 minutes to 10 minutes, Emily Standard Time. I'll see you in a few. All right, let us. Hello, Leonards. All right. Let's bring it back. I had to go put my hair up. It was making me absolutely crazy today. So some days are just like that. All right. We are going to get rid of our soothing music. I'm going to turn down the fan in my office in a second. I was trying to cool it down in here just a little bit because, you know, it's the afternoon and that's when the sun starts making it hot. So y'all ready to go back to court? I'm ready to go back to court. But before we do, just a huge thank you to everybody who's gifted memberships. But Tina this afternoon just popped in with 50 gifted memberships. Thank you so much to all the new Leonard members. Welcome. There's lots of content in our members only spaces. Thank you, Tina. How many of you spent some time closing all this stuff on your phone over lunch? I'm curious. Tina, again, thank you for the gifted memberships and thank you to everyone who's members on the channel because it's absolutely incredible. Y'all are not only generous with each other, but incredibly generous to me. And it helps, especially when, you know, Alan Jackson's favorite thing in court to do is drop the "see you next Tuesday" word. Only when it's appropriate, only when it's in evidence. Are you guys ready to go back to court? I think so. So welcome everybody. It's time to roll. It's time to roll. Let's go. That's not right. Emily, other background. There we go. And court. There we go. Live streaming is dynamic, everybody. So let's roll back to court, shall we? Back with this witness on the stand. I'm interested to see what, if any, cross-examination there will be. I'm sure there will be some, and I'm sure it will be brief. But let's roll. Back from the only fan. Hear ye, hear ye. It is time to, well, you know.
Bring the jury.
I need to put those next to each other on the soundboard. I need to make sure all my sounds are on my soundboard for when I travel. I need to make sure the goat scream's there. Because I got travel coming up. I got to make sure the goat scream's there. Yep. Things that have to be done. All of a sudden, it sounds very loud in court. I'm going to gain this down just a little bit because it does sound
Okay, whenever you're ready, Mr.
awfully
Lally.
loud, which is an unusual thing
Your Honor, may I approach?
Yes.
for this case. No, Remarkable, don't go to sleep yet. We need to take notes. I'm going to bring some of my voice changer to VidCon. Well, I don't get to walk around with it at VidCon, but I'm going to bring it to stream from my hotel room at 6 a.m.
Thank you.
Emily at
do,
8 a.m.
yes.
is spicy. Emily at 6 a.m.
recognize that?
Pacific time is spicy.
This is the entire Google URL that was found on the browser state record. So broken down into each of its important sections.
May I approach again, Your Honor?
Yes.
I'm going to take this here, submit as the next exhibit.
Same objection.
You guys, I'm gonna close out the poll in just a
There are couple
moment.
of different objections. I need to see it, Cyber. I don't know what you're talking about.
The what's interesting is for me, I don't know if this is true on mobile, but on desktop, the polls look a little bit different. They changed the shape of them. So we're gonna have to do that. But yes, I will put Vincent Van Gogh on the soundboard because I have Vincent Van Gogh in person, but I can't travel with Vincent. Well, I could travel with Vincent Van Gogh, but I just travel with it on the soundboard because I don't want to break Vincent Van Gogh any further. But I do, you know, I'm going to need to bring my comfort gavel, squishy toy, amongst other things. Let's zoom immediately past this sidebar as best we can to their objections of the summaries, I imagine.
You are unmuted.
That will be the next exhibit.
And that is being admitted. I am not having a meetup, Kelly. I'm going to be there with a friend, but I always say hi to the EDB Dave friends when they say hi to me. So no, I'm not doing an official meetup. I won't have time with streaming. So unfortunately, this trip is quick because I need to get to
Now, Mr. Whiffin, what's up
California.
on the screen now, is that what you have before you at Exhibit
for
16?
VidSummit.
It is, yes.
And if you could,
VidCon.
again, using the laser pointer,
Vid
direct your
conference.
attention to, what are we looking at in Exhibit 16?
Okay, so the left side of the table is the entire URL that was recovered from the browser state record. What I've done is broken it down into each of its individual components and explained what each of those components means. So the very first row is google.com/search. That just tells the browser that we're going to, the Google website, and that we want to run a search. The second part, the Q equals, is telling the browser what the query term is. So the query term here is host long to dying cold. The little plus symbols in between is in place of a space because spaces can't be part of a URL. Next, we have the input encoding, and the output encoding just explains what kind of characters to use and what language to use when you're accepting the search query and giving it back to the user. And finally, the important part is the and client equals Safari. This is something that just tells Google that this query is being done using the Safari client. Again, if I was to use Safari and just visit the Google web page and type that in, or type a...
Jillian in the chat said, what are they trying to say, that she searched how long to die in the cold before John O'Keefe was dead? Yes, that is what the defense is trying to say. The prosecution is trying to say that that is not what happened, that she searched consistent with, that Jen McCabe's searches are consistent with Jen McCabe's testimony, that she was searching that while they were at 34 Fairview in the morning, and Karen was asking her to search that, and that's when she was searching. Not that she was searching it before at 2:27 a.m. The defense is saying that that search happened at 2:27 a.m. So that.
Searching, that part of the string wouldn't be there. That's only there because I used the Safari search bar as part of the Safari application to do that search.
Thank you, sir. Ms. Gilman, you can take that phone.
We still have so much
Now, sir, with
evidence
reference to
left
that,
to
what, if
go,
any,
though.
relationship does that have to the information you were discussing just prior to the break?
Again, that confirms that this search was conducted via the Safari search bar feature that's part of the Safari browser application, the same one that caused the records to be recorded in the plist.
Your Honor, may I approach the witness again?
Yes.
I'm going to try to zoom through Lally as best I can. Remember, when he says, may I approach to show the witness, he has to show the
I do,
defense
yes.
first.
And,
So he's
when
showing
you
the
recognize
defense, then
that?
showing the witness.
This is the live records from the browserstate.db database.
May I approach, Your Honor?
Yes.
I'm also seeking to introduce the witness.
No objection.
All right, thank you.
We're fully in a trial on Jen McCabe's Google searches at the moment.
Thank you.
Like a full sub-trial,
May I publish after the jury as well, Your Honor?
Yes.
which is probably part of what's annoying the judge, is that we are in a whole,
And
like,
Mr. Whiffin, do you
side
recognize
quest.
what's up on the screen now is what you have before you as Exhibit
The main
619?
quest isn't even
I do,
done.
yes.
Now, turning back to the browser DB database for this particular device, with regard to the timestamp and the last view time.
These are
what, if
from
anything,
129 and
you observed in
131?
reference to that depicted in this, and could you direct the jury's attention to it?
Yeah, so this timestamp is the last viewed time according to the database itself. It's already been offset so that it's in local time. This particular table, we can see there are records missing. Between records 4025 and 4031, we have, 4025 and 4031, we have 4026, 27, 28, 29, and 30 missing. And typically the timestamps that we do have here, some of them are separated by as little.
What's important about that is there are multiple records missing. It's not as if the how's long, that is the only record missing. He's saying that there are multiple records missing in between those times, which is interesting to know.
As a second or two.
Now, with reference to the house long to die in cold, that was record 4028, is that correct?
That's correct.
And so based on the records missing from this portion of the phone as far as that database, what, if anything, did you endeavor to do with respect to ascertaining what?
So first of all, the task was to try to recover the deleted messages. The deleted history records from browser state. So first of all, I was reading the deleted pages, essentially, to find the records that had been deleted from this current version of the
From the
page.
browser state.
May I approach again, Your Honor?
Yes.
Okay. And he's saying the reason there are stuff missing is because it just wasn't written to the phone because Safari was left open. That's what he said. What I have a question about is why is stuff written from 2:27 a.m. and the stuff from 2:26 a.m. didn't write? That would be my first question about that.
Ask you to do that. Helping me finish?
Yes,
And do you recognize that document, sir?
I do, yes.
What do you recognize that to be?
This is the same data source, so it's still browserstate.db, but now looking at it with the unique recovered records.
And what is that last term that you use? What does that mean? I'm sorry.
So typically there can be lots of different versions of a page within a WAL file. So you may have several page ones, several page twos, and so on.
This part is this witness explaining exactly what the other witness, Jessica, explained. He is not so in the weeds with it, so I find it a little easier to explain or a little easier to understand, but he is explaining the same thing Jessica was about the recovered files. So that's what we're about to get into is like, oh, okay, well, this is everything that was recovered. This is what Cellebrite extracted, and then this is what he could go in and recover, and what Jessica also went in and recovered.
What I looked at is doing is recovering the data where the records that I recover are different from each other. So if I recover the same record multiple times, I can ignore it. But if I recover the same record with a slight change, then I would show it in this view.
May I approach, Your Honor?
Yes.
I'll seek to introduce in a minute.
No objection.
Okay.
Your Honor, with court's permission, may I publish that for the jury?
Yes.
And then these are the recovered records. So it's not all the way deleted if it's recovered.
What are we looking at here, and what, if anything, did you uncover during this portion of your analysis?
Yes. So again, the very first column on the left is the unique identifying number. You'll notice that there are some numbers here which are
Look, we've got the full YouTube video for the Weather Girls It's Raining Men. So there's that.
repeated. This is, as I say, because the records are recovered from multiple versions of the same page. There was actually 16 versions of this record across 23 different versions of this particular page. These three had some difference. Primarily, it was what's called the tab order field, but that's the only difference that showed up across these three Host Long to Die in the Cold records. All the rest show the same URL, the same ID number at the beginning, or tab ID number, and the same timestamp. Worth noting, there is no title shown in this particular record. Again, that speaks to the fact that this page didn't successfully complete loading. Otherwise, there would be a title of Google search, Host Long to Die in the Cold, as you saw on some of the other examples earlier.
Now, sir, with respect to the table up here, is there any indication in regard to private browsing that you were talking about before?
No, in iOS 15, as I mentioned, if you are using private browsing mode, there is no records recorded in this database at all.
So the fact that that's not listed in this table, what, if anything, does that tell you?
Everything that was recorded in this database was conducted not in private browsing mode.
Now, with respect to your work within your field, are you familiar with a term called a session?
Yes.
And can you explain to the jury what you understand that term to mean and how it applies to this specific instance?
Essentially the life of the particular tab. So when I start a tab and I start to use navigation, I go to different websites. All of my navigation events would be considered part of the same browsing session, essentially.
Now, sir, if I could turn your attention to the Knowledge C database for a moment. And again, if you could made their
But
opinion.
nobody's going to talk about all the butt dials, and those are so
That
weird.
term
So
what is the knowledge C database in respect to the other databases you've been talking about?
Yeah, so far, the bulk of what we've discussed, the history.db, the browser state DB, and mobile safari.plist are all particular to the Safari application on iOS. Knowledge C is much more global. It's much more ingrained within iOS.
Oh, back in the weeds.
Everything is essentially recorded in
between
there,
the history.db and the
on
knowledge
iOS
C
15.
databases.
So again, backlight activity, unlock activity, application state activity, and web usage activity is all recorded as part of Knowledge C.
May I approach you, Your Honor?
Yes.
So we do live here now. I'm going to see if I can zoom.
I do, yes.
What do you recognize that to be?
This is a document I created based on the Knowledge C web usage records.
May I approach, Your Honor?
Yes.
Commonwealth to seek to introduce and admit the exhibit. No objection.
Thank you.
You know, at least the testimony's clear, well, clearer, and very clear in comparison to the last witness. So there is that.
Thank you.
And Your Honor, with the court's permission, may we publish that to the jury?
Yes.
Sir, again, what's up on the screen, do you recognize that as what's before you as the next exhibit?
I do, yes.
And if you could, again, Ms. Gilman, if I could ask you to scroll down.
So these are the web usage records from the knowledge C database.
Now, if you could, sir, again, using that laser pointer, if you could direct the jury's, well, first, can I ask you?
So
what is it that
Hockomock
we're looking at in
YouTube
this?
video.
Okay, this
Ozone.
is a particular, what's called a stream within Knowledge C. A stream is basically all like.
But those are all from 227. Can you scroll back up? Oh, never mind. I'll scroll back up. Because, let's see. We've got, I just wanted to see the 213. So 213, Hockomock 22657, Hockomock 22705, Hockomock, and then on. But if those were written, I just have questions. All right.
Thank you.
I'm trying to see where they
If
end.
you could, sir.
Because that goes
again,
all the way
using
to
that laser pointer, if you could direct the
228.
jury's- Well, first, can I ask
There are more searches. So why would it write at 227?
you, what is it that we're looking at in this?
Because the searches continue.
This is a particular, what's called a stream within Knowledge C. A stream is basically all like information being grouped together. So in this particular case, the stream is related to Safari. And it's telling us what web page was visible on screen, what time it started and what time it finished.
Now, with respect to this particular tab, there are portions.
I think
that
that's
are
helpful
highlighted
evidence.
in green,
This is showing
portions
what's
that are
on
highlighted in
the
blue.
screen at what time.
Correct.
Can you explain to the jury what the portions highlighted in green represent?
I highlighted the sections in green due to their timestamp. So typically these items last between 2:27:37 a.m. and 2:27:53 a.m. So around the time of the Google search, if you were to believe the browser state.
And with respect to the items highlighted in blue, what if any, what are those?
The ones in blue are the actual Knowledge C records that show when the Hoss long to die in the cold and the how long to die in the KICD web pages were actually visible on screen.
And so from this, what if anything were you able to ascertain as to the searches?
So this should be his
associated
conclusion.
Searches from your analysis here.
This should be his conclusion
At
about the searches.
2:27:40, the only websites that were visible on screen were related to Ozone Basketball and Hockomock Sports, and that the How Long to Die in the KICD first appeared on screen at 6:23:56, and Hoss Long to Die in Cold first appeared on the screen at 10:33 a.m.
What?
So those two
At
searches,
10:33 a.m.?
from your review of this extraction
At 10:33 a.m.? Because everything else said 6:24 a.m.
in this device never appeared on the screen prior to 6:23 in the morning, correct?
Correct.
That's the first time we've heard that the how's long to die in cold is at 10:33. I wonder if that's the UTC time.
All this, sir, what if anything
Not
were you
the-
able to conclude?
I wonder if that's the UTC time and not the other time, but all of these experts have had some version of, wait, that's not what it says. But what he is testifying to is that the only things on screen at the 226, 227 time frame were the Hockomock surges. So that's his testimony. All right. With that, I also want to say thank you real quick for a super chat from SH. Thank you so much. Appreciate you. And even though you're normally replay crew, glad to have you here. And at some point you will see all of this. So good to see you. And thank you for the super chat, SH. Let's continue because Lally's about to ask him what his conclusions are.
With regard to these searches?
So essentially, ignoring the browser state timestamp is important because that is not a reliable timestamp to show when that URL was visited. We have mobile Safari.plist record searches that show 623 and 624, and we show the same searches with very similar timestamps within half a second as showing up on screen in Knowledge C for the how long to die in the Kikdi. And the how long to die in the cold was actually several hours later, which took a little bit more explaining, looking at Knowledge C and when the applications were opened up.
Now, with respect
That's
to
the
your
first
view
time we're
of the
hearing that. That's
extraction
odd to
device
me.
Around these times, were you able to ascertain as to what time this particular device connected to a Wi-Fi sometime after 2 a.m.?
I actually didn't look at any Wi-Fi connection information.
Because nobody probably asked. Witness, I agree with you. The CIKD, his pronunciation of CIKD is a delight.
To 27 a.m., what were the websites that the device had visible, and what were the websites that the device was connected to at that time?
So according to the Knowledge C records, which were mostly also reflected within the History DB as well, it was the Hockomock Sports, YouTube, Ozone Basketball, and that's it for the main domains.
Now, with regard to the Wi-Fi connection, is your memory exhausted as it pertains to that?
Yeah, I don't remember looking at Wi-Fi history.
Your Honor, may I approach?
Yes.
All right, I bet he did then. Well, let's see. I'm going to zoom past Lally approaching with his report. It's odd to me.
In the interest of time, if I could ask you just to look at the next
It's odd to me the way they say is your memory exhausted as to that.
page as well, just briefly.
Californians always say, would it refresh your recollection? It's just it's such an odd phrase. All right, I'm going to go ahead and end our poll. 59% of you close all the things on your phone, and 41% of you let them stay in the background. So I'm going to tell my husband he is vindicated, and it is more common than I tell him that it is. So, you know, he's like, please stop swiping out of my stuff. I'm like, I can't help it.
Do you remember refresh, sir?
I do, yes.
May I approach to retrieve?
Yes.
Swipe out. I see the chat saying, but my memory is exhausted
Mr.
as to all
Whiffin,
of this.
From your
Fair.
review of the extraction report in regard to this device of Ms. McCabe's, about what time was the connected to a Wi-Fi network called McCabe?
I believe it was 0207. I didn't actually remember the timestamp just then.
And with respect to the disconnection from that, do you know when that was?
That's the one
I
Jen
can't
got
recall.
home.
Your Honor, if I may approach?
So Jen
the time
McCabe's
Rona made the
phone
witness.
connected to the
Yes.
McCabe Wi-Fi at 2:07 a.m. I don't name my Wi-Fi after our last name at all.
Sir, if you can, from looking at your report, if you can just indicate to the jury as far as the Wi-Fi connections with.
So what
The
time Jen
Wi-Fi
McCabe
was
got home is
connected
helpful.
at 0212 and disconnected at 0539.
That's helpful timing, actually.
There was no further Wi-Fi.
I'm going to rewind that. So it connected to the McCabe Wi-Fi at 0212 and disconnected. Let's see. I'm just going to make a note real quick. Can you imagine? I can't imagine being a juror and not being able to be like, pause, I want to write this down. And then disconnected at 5:35, which is when she left with Karen Reed.
Get your report, if you can, just indicate to the jury as far as the Wi-Fi connections with.
Okay. The Wi-Fi was connected at 0212 and disconnected at 0539. There was no further Wi-Fi activity until 11 a.m.
And then back at 11 a.m.
May I approach this retrieve your?
Yes.
That is helpful information. Because we've been waiting for, everybody's timeline has been whereabouts, but that actually helps. The
Now, sir,
Wi-Fi
are you
connected at
familiar with,
212, disconnected at
something called write-ahead
5:39,
log
and
or
then
wall
connected
file?
again
I
at
am,
11
yes.
a.m.
And if you could explain to the jury what your understanding of that term is and how it applies in this specific case.
Yes. So a write-ahead log is essentially a temporary store for database pages. When I'm talking about database pages, it's not something that the user ever sees. It's part of the structure of SQLite databases. Just as chapters in a book can span multiple pages, data in a database can span multiple pages also, and it's not necessarily in the expected order. It's up to the database application to find those pages and order them correctly in order to display the data to the user. The WAL file, on the other hand, it still contains pages, but they're organized in frames, essentially. And a frame is the same as a page, but with additional information at the top that identifies what page it is. So I mentioned earlier that it's possible to have multiple versions of the same page within the WAL file. That's because every time I write a record to the database, a new frame is created and the page is updated. So for example, if I was to have a new database, create a record, a new frame is created with page 1, and it adds my record. As soon as I add a second record to that database, a new frame is created again. So I now have frame 1 and frame 2. Both of those frames would contain a version of page 1. The first frame would contain only record 1. The second frame would contain records 1 and 2, and so on. Forensically, where it gets interesting is on the edit or deletion of a record, because the same process is applied. So now a new frame is created. The page number is the same as previously, so we'd still have a page 1. But now only the records that I don't want to delete are copied across. So I could end up in a situation where I have 4 versions of page 1. One has record 1, one has records 1 and 2, one has records 1, 2, and 3, but the most recent version of the page only has record 1 and 3, for example. Now, a normal piece of database software will only look for the most recent version of the page, so you would only see records 1 and 3. The forensic software can look at all previous versions of the page as well, and that's how we're able to recover record 2 in that instance. And that's essentially how we were able to recover the browser state record from WAL.
Now, sir, turning to that.
Y'all's Wi-Fi
issue as
names
far
are
as,
amazing in the
what, if
chat.
anything,
Thank you for sharing them.
Well, let me ask you this first, just before we leave the wall file. So with regard to the
Before
wall
we
file,
leave
what, if any,
the wall
relevance,
file, not the
is
wall
there,
flower.
That certain data only exists within the wall file?
So again, if I create a record that's in the WAL and delete it before it gets committed, which means when it gets merged into the main database,
It's an
then it
uncommitted
exists
load.
only in the WAL. It could be that it's a brand new record that just
That was
hasn't been
earlier.
written yet, or it could be one which was deleted from the database prior to the commit occurring.
Michelle
commit, what
in the
does
chat
that
said
mean?
they're really
What does that
concerned about the
Commit's a
search. They
process
are.
where essentially the database looks at all of the most recent versions of each page in the WAL file, copies them out from WAL and puts it into the main database, and then deletes the WAL file altogether. So at that point, we lose the ability to recover data from WAL because the WAL doesn't exist, but we have all the most recent versions of the page.
Now, sir, turning to the concept or the topic of deletion of data, what, if anything, did you find with regard
Mini
to
Mandy
deletion
with
of
the,
data with respect to
the
search
on-point
that
Doctor Who
applied to the
reference.
P list that you discussed before?
In the Wi-Fi name.
Recovering data that's been deleted from a P list is not really possible. So all we can say is if this record exists within the P list, it hasn't been deleted.
Now, same question with regard to issues of deleted data with regard to the history DB.
There was no records of any, so there's no evidence of any records being deleted from history.db since early January. I think it was like the 3rd of January up to February 2nd.
And how were you able to tell that with regard to the history DB?
Again, every record
'Cause
is
it was
given a unique
recovered.
number, and there'd be a gap in that numbering system if a file or if a record had been deleted. The fact that there was no gaps indicates that nothing had been deleted.
And with regard to deletion, what, if anything, were you able to ascertain with regard to deletion versus web usage in the Knowledge C database?
He's already testified
Knowledge
to
C
that.
contains such a large amount of different type of data that's always being added and deleted for various reasons, none at the discretion of the user. It's a completely system-driven event to delete information from Knowledge C. So we can't say what was deleted from Knowledge C, but we can see that during the times of Safari usage, records exist within Knowledge C that indicate, or
That the
certainly
records
appear
are
to indicate that nothing
there.
was deleted.
What's frustrating
anything
is
were you-
why Lally has not just asked, then why does this record from Cellebrite show it that way? We have not gotten to these simple questions, and I don't know if he's going to ask it at all.
Able to find with regard to deletion in respect to the browser state DB data?
Browser state did have numerous records that had been deleted.
We're not, so Chad, a number of you are saying, but I thought Jen McCabe said she deleted texts and text threads before she turned it over to law enforcement. She did. He's not looking at text threads, phone calls. He is only looking at the databases with regard to that search on Safari. That is all he is talking about. That is all he is looking at. And he is explaining the search from the Cellebrite report and not the search, the result from the Cellebrite report regarding that search and when those things happened and when the Knowledge C database shows those things happened. So that's what he is testifying to, only that.
Some we were able to recover. 3 records from browser state all had a timestamp very similar to 22740. These were 3 records that had been deleted at some point.
And what are some of the options for deleting data from that particular, from the browser state DB?
So the first most prominent option is to delete absolutely everything from the device, or delete all history from the device, which, as I mentioned earlier, we know that didn't happen because we still have other records. So the only other real option is to delete selectively. That could mean delete one at a time, and it could mean delete either the full day, the last 2 days, or the last hour. But in all of those cases, the record must exist in history.db in order to be deleted from browser state. The fact that this record, the hoslong and the how long today and the kikti don't exist within the history database would mean that the user would never have the option to selectively delete that record.
May I vote, Sean?
Yes.
So he's explaining why those aren't user deleted and why they're not there. Okay.
What do you recognize that to be?
So this is a list of the browser state DB records showing a red line where a record or more have been deleted.
And again, the term deleted, as far as it applies to this particular area of the database, what exactly does that mean again?
It means the record has been marked as deleted. If you were to read this database in a regular database application, you would not see it, but it doesn't necessarily mean that we can't recover it.
May I approach again, Your Honor?
Yes.
I'm also seeking to introduce in the minutes the next exhibit.
I think that's as close as an explanation as we're going to get.
The exhibit?
I have no objection to the exhibit, if that was the question.
That is the question.
That is the question. Yanetti's like, my brain is tired.
Your Honor, with the court's permission, may we publish Exhibit 622 to the jury?
Yes.
Maybe it will be clear. I really
Again, sir, what's up on the
hope
screen is
Lally
that
regrets spending all that time on where everyone was sitting in the
It says yes.
freaking bleachers.
And if you could, please use the laser pointer, direct the jury's attention to what, if anything, of significance you observe in this.
What is this?
So again, we can use the number down the left side, which
There
will
we go. Thank you,
identify the
camera
unique identifier given to each of these records.
This says the earliest live record in this database is from January 2021, so it is clear that all time was not used. So he's saying the phone and all the data from the phone wasn't wiped.
And we can see that the red line between the first two records indicates that records between 3986.
Now I just want to know what YouTube videos these all link to. That's just me being nosy. We're not going to get to that, but now I'm just being nosy.
6 and 3993 have been deleted. We can see that record 4001 is deleted. Records between 4004 and 4019 have been deleted. Record 4020 was deleted. And then finally, records between 4025 and 4031 had been deleted also.
Now, sir, as far as records 4024 and 4025, what, if anything, were you able to ascertain as far as the dates and times associated with those?
Yeah, so these particular records show up at 227.31 and 227.33 respectively. And this matched records within Knowledge C that showed that at this particular time when the tab took focus, that particular website was also shown visible to the user in Safari.
Now, as far as the date and time for 4024 and 4025, what, if anything, did you observe with
I'm gonna move
respect to
the-
the date and time for 4026? And what can you tell about that?
So 4026 was approximately a second or two after the record here, 227.33. I believe it was at 227.35. And then again, there was another record, 4027, which again was another 2 or 3 seconds after that time. So within a 9-second period between 227.31 and 227.40, there were 5 records within Browser State DB that had a timestamp within that 9 seconds, all with completely different types of website, ranging from PayPal, banking, YouTube, and the Hoslongstein the Cold.
Now, sir, with respect to, are you familiar with the term called spontaneous deletion?
I believe so.
And can you explain to the jury what that is?
It's not a term that I would use, but essentially a cleanup operation would occur on the device where it would look for orphaned records, records that are old enough to not be required anymore, and they would just be deleted by the system without any direction from the user.
Now, during the testing that occurred, your testing, which occurred with respect to this device, what, if anything, did you observe with regard to spontaneous deletion?
I wasn't able to replicate the spontaneous deletion. I was able to replicate completely orphaned records. So a record that existed in browser state without a corresponding record in history.db. And it meant that there was no way for me to delete that record manually without deleting everything from the device regarding history.
May I approach, Your Honor?
Yes.
He's saying they couldn't be deleted because they were never in the history DB database. I think we were doing better before we got so far afield, but we will see. And the reason he's going into it so much is because there are going to be defense experts on this.
Okay, could you turn the lights on?
All right, as they approach, I'm going to zoom past this sidebar. You know how strongly I feel about not sitting through the sidebars if we can avoid it, but that's going to catch us up in real time.
All right, so you're introducing those 4 pages or whatever it is, Mr. Lally?
Yes, sir.
As one exhibit?
As the next 4 exhibits.
Okay.
Okay. So they need to mark the next
All right,
4
so that
pages
will
as
be-
4 exhibits?
Those will be admitted.
And the court reporter is going to be
I don't
marking
think
all of
that's-
this.
Push them while this is.
I don't think that's,
That's not a full sentence. Whatever.
Sure.
We're zooming
I'm showing your documents, you recognize that?
as these pages are getting
I do,
marked.
yes.
What do you recognize that to be?
This is a report from my Artex tool showing the history database
So another report from a
at,
different tool.
21:39:34 on the 27th of January and 22:55:09 on the 27th of January.
May I approach again, Your Honor?
Yes.
Almost to introduce the minutes of the next exhibit.
All right, so all four are in.
Yeah,
Okay, so you don't need to.
he should have just marked them.
They have not been marked.
There's more? What wasn't marked?
Okay. Exhibit 623. Yes.
I'm zooming.
Now, sir, with regard to this, we're looking at record number 4026, is that correct?
Yes, I believe we are.
And again, if
These
you
are from
could,
127?
direct your attention to what exactly are we
These records are from 127.
looking at in this exhibit with regard to record 4026?
Yeah, so in the right column, we see the source of the information. So history.db is the database. History_visits would be the table. And then the unique identifying number of 31407 and 31408. We see that the start time, or the time that that particular website was navigated to, according to history.db, was, as I say, both on the 27th of January, one at 21:39 and 34 seconds local time, and one at 22:55:09 local time. And both of these websites are related to Hockenmock Sports. We have the URL at the top, followed by the title of the page, followed by a visit count that tells us how many times that page has been visited before.
From 127. Okay.
Sorry, one moment, Your Honor.
Yes.
No! More exhibitties.
This is the same kind of report. This is related to the YouTube record that was part of the browser state database related to It's Raining Men on YouTube.
Is that the record number 4027, is that correct?
It is, yes.
Your Honor, may I approach again?
Yes.
That's the remark of the next exhibit.
Okay. Exhibit 624.
Your Honor, very briefly, may we publish that for here as
Yes.
well?
Okay. Can we? There we go.
And sir, what's up on the screen now, is that what you have before you as the next exhibit?
It is, yes.
And again, if you could, using the laser pointer, just direct the jury's attention to what, if anything, of significance you observe in this record of 4027.
Yeah, so again, we have 5 records related to the
127.
YouTube video, It's Raining Men, starting at record 31398, 31399, 31400, 31401, and 31402. These were all accessed on the afternoon of the 27th of January 2022.
Okay.
May I approach again, Your Honor?
Yes.
Again, it's okay.
Another document, do you recognize that?
Sure.
I do.
What do you recognize that to be?
This is the same again, related to record 4029. Shows that a website was visited on the 28th of January 2021.
And Your Honor, ask that this be marked.
Okay.
Excuse me, as the next exhibit.
I just have to say that across my Instagram over the weekend came a query about the song It's Raining Men. And I was going to post it in my stories, and I'm like, that's probably inappropriate. But
Yes.
then we got here, and my brain has overridden that initial thought because someone posited, what if it's raining men and let the bodies hit the floor are just 2 different perspectives of the same event? And the way that I laughed out loud, I was like, well, that's one perspective on the song It's Raining Men. isn't it? So with that, I wish I remembered the creator that was talking about that on Instagram. So
There was the next exhibit in regards to Record 4029.
It is, yes.
And again, if you could
this is from 128.
Yeah, so this URL, cantonma.org, relates to the URL that was provided
Sorry,
in
my
record
brain is now
4029
looking
of the
for other
browser state
stimulus
database.
at this point.
It shows that this web page was accessed at 1 p.m. And 17 minutes and 0 seconds, and 1 p.m. 17 minutes and 8 seconds on the 28th of January 2022.
May I approach again, Your
Yes.
Do you hear how quickly the court is like, yes, yes, yes,
I do.
yes?
Honor? What do you recognize that?
Again, the same kind of report, again,
Yes, chat.
this time for record
I'd rather be watching Tom
4030,
Holland sing
from browser state,
Umbrella as well.
and it shows access to Ozone Basketball.
And with regard to that report, as far as the same kind of report, that's from your tool, the ArtX tool, is that correct?
Correct.
And that ArtX tool, is that a widely available tool used within the field of forensic
Stuff.
investigators?
Sorry,
yeah,
my bad.
it's something
Wrong
that I say
witness.
I've worked on for around 5 years. I've given it away free to the digital forensics community for 5 years. There's approximately 600 users
Thanks,
globally, and it's taught as part of the SANS digital forensics training courses.
May I approach again just to retrieve, Your Honor?
Yes.
Did you hear?
Yes.
The judge is just like, for fuck's sake! Yes, it's fine!
Thank you.
May we publish that for the
Yes.
Your Honor? Regard to this exhibit up on the screen, record 4030.
The judge is just so over it.
Direct the jury's attention to what, if anything, is
This is from January 25th.
Yeah, so again, we have records from the history database related to Ozone Basketball, and it shows that this website was accessed at 11 a.m. and 26 minutes on the 25th of January 2022.
May I approach, Your Honor?
Yes.
Ms. Gilman, you can.
The court's just like, yes, yes, yes.
Now, with respect to sort of the totality of your analysis, Mr. Whiffin, what, if any, conclusions did you come to as to the timing?
Hold on, chat. Here we go. Here we go. Conclusions. Come on back. Come on back. Pause your game for a second. We're going to get to his conclusions, and then you're welcome to resume whatever it is you are doing while this is in the background and you wait for Cross. So, conclusions. Here we go.
Of the two searches in question with relation to what you observed in your analysis and testing of this device.
Yes. So in conclusion, I determined that the tab that was used was focused at 227.40. So the tab was opened at that time, at which point it was being used to show Ozone Basketball and Hockamock Sports websites. The 6:23 timestamp is when the search was first conducted. Never loaded the page, otherwise there'd be a record in the history database. And while that page was still loading, a secondary search was conducted for Hoslong to Die in the Cold. Again, that page never loaded either, although these both did show up in the Knowledge C database to show that the browser was trying to display these pages.
The browser's like, I'm trying,
Safari
Your
was
Honor.
closed prior to the Hoslong to Die in the Cold record being shown on screen at all. But when it was reopened at 10:33, in regards to whatever other Safari activity was to be conducted, it appeared on screen. So we have a 10:33 record where Hoslong to Die in the Cold was shown on screen, even though the page never successfully loaded.
And with respect to your analysis and your testing here, what, if any, opinion do you have as to whether or not any of the data marked as deleted was actually user deleted, or a user actually actively went through the process of deleting the data?
Yeah. So again, we know that she didn't, we know that nobody deleted the entire history. So that leaves the only option to be selectively deleting records. The fact that there are no missing records in HistoryDB shows that it's impossible that that record could have been deleted by the user. It would have just been orphaned in the database, and I believe would have deleted itself at some stage whenever a particular cleanup function ran. Although, as I said earlier, I haven't been able to replicate that. I was able to continue to read the various versions of the page that contained Hoss Long to Die in the Cold browser state record, and found that it existed at the same time as another record that was created at least 2 days later. Therefore, I can determine that that particular record was not deleted until at the earliest, 10 p.m. on the 31st of January. And that it's not possible that the user could have created or caused that deletion to occur.
Now, over the course of your analysis and testing or review of the extraction in this case, did you have occasion to review an affidavit of a Mr. Richard Green?
I did, yes.
That's the defense
What,
expert.
if any, opinions or conclusions do you have as to that affidavit?
I had issues with several of the statements being made as part of the affidavit.
And what issues were those, sir?
Namely, it specified that Cellebrite report identified that the search was conducted at 2:27:40. And as I've explained, I believe the tab took focus at 2:27:40, not when the search occurred. The report mentioned that Cellebrite report identified it was deleted by the user. We don't do that. We'll tell you that a record is deleted, but we don't specify how the record was deleted. That's something for the examiner to determine. I forget. Oh, and then there was a mention of the purpose of the browser state database. The explanation given was correct for iOS 14 and below, but not for 15 and above, which is relevant in this case.
Because the phone was on
Now,
15?
You mentioned this issue as far as coming up, obviously, in this case and some other instances, phone calls or inquiries that you received from Austria and other places. What, if anything, have you or your company, Cellebrite, done with regard to rectifying this issue?
Well,
I'll allow it.
okay, we
What
recognize
issue?
that this timestamp could be misleading. Regardless of how we label that timestamp, the very fact that a timestamp is there, we feel would be or potentially misrepresented. So the decision was taken to remove the timestamp altogether from that information. So now we show the web page was visited, but we don't attribute a time to that purely because it could be wildly inaccurate.
Thank you. Your Honor, this
So Cellebrite changed the way they do reporting because they realized that the report itself could be misleading. Again, this is a tool that examiners are supposed to start with and then dive into. So he said, no, based on the way that this could be misinterpreted or misleading, Cellebrite has changed the way they do their reports, which is interesting to note.
may be the appropriate time for the instruction.
Okay. All right, so jurors, we're about to see a demonstration by Mr. Whiffin. It's simply a demonstration
Demonstratives.
to help you to understand the evidence that you've heard. It's not evidence from this case, but it helps you understand the evidence in this case. You must decide this case based solely on a fair consideration of the evidence and nothing but the evidence. But this is a
I'm going to just make a note here as we are watching this live together. I wonder if this demonstration is going to be in error because the prosecution is choosing to spend more time on demonstrations with how Jen McCabe did or did not search something at 2:27 a.m. when there are no demonstrations of how this collision is supposed to happen and we don't know what happened to the victim. I think this could be in error to choose to continue to demonstrate this way because where are the demonstrations on everything else? So I don't know if this is going to make the jury go, yeah, that's great, or if it's going to make the jury go, what fucking trial are we sitting in? Because my thought was that the name of the defendant is Karen Reed. So I just wonder if this is going to be a problem. Let's see. Let's watch the demonstration together. You can let me know
Demonstration
your thoughts.
to help you understand that evidence.
Your Honor, rights are preserved, correct?
You know,
Yes.
I need a demonstration to help me understand how
To
a
that point,
vehicle
Mr.
collision
Whiffin,
happened.
Were you able to prepare a demonstration in regard to what you've been discussing through the course of your testimony?
I was, yes.
And that demonstration doesn't specifically reflect on the searches or the extraction report that you looked at in this case, correct?
Correct.
But as far as the overall issues that you've been discussing in your testimony, correct?
That's correct.
And with the court's permission, may the witness now illustrate that to the
Yes.
Okay. So first of all, on the left there, you can see a screen of an iPhone, and that is a phone that I have in front of me live. It's just demonstrating.
We're doing a live demonstration in court. That's bold. Even Apple doesn't do that on stage anymore because so much can go wrong. Everyone in tech knows how badly this can go, but let's see.
What I can see on the phone. This is my Artex tool, and the feature which I continuously use this tool for, which is not available really in any other vendor tools, is the ability to create a live connection between my computer and the phone. The live connection is what I've just started here, and what's going to happen is all of the files and folders that exist on the phone will be mapped to my computer so that I can navigate it, I can look around, and I can take a look at near enough live records on the device. Prior to the availability of this tool, I would have to test a theory on a phone, do an
Okay, we're glad your tool works well, sir.
extraction, and then pass the extraction, which could take anywhere between 20 minutes and several
Lally
hours.
can tell him no. Lally thinks
The
this
reason
is
that I'm
helpful.
using this tool today is because I can do those same tests within 10 or 20 seconds typically.
Lally thinks this
So
is helpful.
I just need to wait for this section to do. So it's already mapped out all the files and folders. It's now asking for a few important pieces of information, which it will then populate on the screen. So information such as the device, serial number, etc. What we're interested in, though, is the browser state record. So I can go to the browser state database and take a look at that and open that up. And you can see that at this moment in time, I have no records in the database at all. Okay. If I go back into the live view of the phone, you can see I have Safari open from last night. So it's been sat in the background overnight and not doing anything. But at 8:10 last night, I performed this search in a brand new window. So started Safari, opened up a new tab, immediately searched for new tab at 2010 on the 16th of June. If I now search for the time right now, 14:42, what I can do is go back to my Artex tool and press this reload button. That's going to delete the database from my computer only and copy the most recent copy of the database and WAL file from my phone back to my computer, where it shows me I still have no records. That's expected behavior because at the moment I've not closed the tab. So if this, again, was iOS 14, there would be a record there to say what tab I had open, but iOS 15 doesn't work that way. If I now go back to my tabs and actually just close this window, I can go back into Artex and hit reload again, and we now see we have some records. I can look at this particular record, and you'll see the title is 1442 Google search. You'll see the Google search record here, so I just need to change the time zone as well to Eastern time. So you see it's the most recent search which I conducted, the 1442 search. The last viewed time, though, still shows as 8:10 p.m. last night, because that's the time that the tab was focused, not the time that the search was conducted.
Thank you, sir.
Okay.
Yes.
Are we done? Are we done now? Are we done now?
Thank you, sir. I have no further questions.
Okay, Ms. Tianetti?
Thank you, Your Honor.
Cross, we're done. Chat, we've made it. He was showing in real time how that would work with the tab.
Good afternoon, Mr. Whiffin.
Good afternoon.
It just he is trying to prove that the time on the Cellebrite report goes to tab activity, not to search activity. That's it. Now we're in cross.
Sir, you had spoken a little bit about what was your assignment here in terms of the data that was sent to you. And I believe that you testified regarding that 2:27 a.m. or 2:27 and 42nd a.m. timestamp that it didn't make sense to the investigators, correct?
Correct.
Were you told that one of the investigators was Trooper Michael Proctor?
I don't recall any names being mentioned. The ticket came to me, or the request came to me via another Cellebrite employee who'd been asked about this case and asked whether we could offer any help.
Okay, thank you. You would agree with me that when you're making or doing a simulation, you want it to be as close to an apples-to-apples comparison as you can get?
As best possible, yes.
And to get truly accurate research results, you want to eliminate as many variables as you can, correct?
Correct.
You wouldn't, for instance, want to use an Android operating system to try to replicate the activity from Jennifer McCabe's Apple iPhone, correct?
Correct.
What version of iOS did you use for your testing of Jennifer McCabe's data?
So this test has been undertaken on various different versions of iOS, from iOS 12, 13, 14, 15, 16, 17, and most recently on the beta version of 18 last week. This particular demonstration was on 15.8.2.
Okay.
Why?
And you're aware, you said 15.8.2.
Was her phone on 15.8.2? Please, somebody answer this question.
Correct. I've also tested on 15.7.
Oh, fair enough. You're
I don't know if anyone's going to say, how do you like them apples? But Chad, I see you being optimistic.
aware, however, that Ms. McCabe was using iOS version 15.2.1, correct?
Correct.
And you would agree
There we
that
go.
the way that an artifact is stored would depend on the iOS version.
The state
that you
never
use,
asked
correct?
that.
Correct.
And your simulation did not use the iOS version that Ms. McCabe was running on her iPhone, correct?
Correct. I used the closest version I could find.
So I'd like to ask you some questions about the characteristics of browser state.db-wall in record number 4028, if I can.
Okay.
That record number, I believe you testified, was found to be deleted, correct?
Correct.
But you were able to recover the date and time associated with it, correct?
The date and time of the last viewed?
Of that
Good.
record number.
Yes. That
And
was
what was that date and time?
2:27 and 40 seconds a.m.
You were also able to recover the content of that particular Google search itself?
I was able to recover the URL for it, yes.
Okay, and what was that Google search?
Hostlong to die in the cold.
And it's true, however, that the session history could not be recovered, correct?
That's correct.
Now, given those characteristics that you've just discussed, did your testing result in a WAL file record, a WAL file record, that matched the characteristics of 4028? In other words, deleted with session history not recoverable?
The issue with the session history, I was able to recover only the first page of session history. What happens is when there's a large amount of data that's split over multiple pages, if it's a live record, all those pages point to each other so that you can chain it together and get one large amount of information. Once they've been deleted, some of those pages can be overwritten and therefore the pointers don't make sense anymore. So the amount of information in this session was way larger than one page, and I wasn't able to recover anything further.
Okay, and you'd agree that the simulation was done using a different operating system, correct?
Correct.
Were you able to recreate the other deletions that appeared before and after that record 4028?
Which deletion, sorry?
Well, you had testified, and I believe there was an exhibit that was introduced that showed that there were multiple deletions both before and after, correct?
Correct.
Were you able to recreate those deletions?
When I manually deleted records from the history, then the records also were deleted from the browser state.
Now, I believe that you testified, and if you didn't, I believe it's in your report, that there are essentially 5 mechanisms for record deletions in the browser state database, correct?
Correct.
You ruled out 4 of them pretty quickly, correct?
Correct.
And I believe you've testified to that today, correct?
Correct.
Yes.
The only remaining option was selective deletion by a user, or there's some internal mechanism for record deletion that is not fully understood, correct?
Correct.
All right.
And that's what he went with.
As you testified today, you know of no internal mechanism for record deletion that's not fully understood, correct?
I've not been able to replicate that function, no.
All right. If there is no unknown internal mechanism for record deletion
Right.
that's not fully understood,
Then-
that would leave selective deletion by a user, correct?
Right.
Not in this case, no.
All right. Well, selective deletion, you would agree, means that a user selects what to delete, correct?
Correct.
And regarding the user, the term user, what is that? Who is that?
Whoever's using the phone at the time.
Okay, so it's actually somebody who is using
Hands-on.
the actual iPhone itself, correct?
Correct.
Not necessarily a computer expert, correct?
Correct.
Would you agree with me that somebody who had access to the data before it was extracted and sent to you could have made selective deletions of the data?
Objection.
I'll allow that.
No, I don't.
Are you aware of an app called MySQL?
Yes.
What is MySQL?
MySQL is just a method for viewing SQLite databases.
All right. If someone had access to the raw data, again, before it was sent to you,
That's interesting.
and used that app, they could make selective deletions.
Is the defense changing their opinion on the download, or are they insinuating that Matt McCabe would have had access to that? So are they insinuating towards the investigators or towards Matt McCabe? I'm interested to see what they're insinuating. But are they insinuating someone other than Jen McCabe at this point?
The data, couldn't they?
I assume you're talking about opening up the extraction, taking out the particular file and editing it?
I'm sorry, I interrupted you. You're right, Your Honor. I apologize. And I apologize to you. If you could restate your question or answer or give me
What?
a full answer.
Okay, so it would be possible with the extraction to take out particular databases, alter them, and put them back into the extraction. But there's something called a hash mechanism that we have in place that would, it essentially hashes the original data, and then it can be hashed again at a later date. It results in a long string of characters, and if there's any changes to the original data, then we'd see that it's been modified.
Would you agree with me that someone with access to that data and an appropriate application or program could also delete and renumber
The hash data?
history.db and knowledge.cso so that it would appear as though there was no break in the numbering, so that it would also appear that nothing was deleted?
But
It's potentially possible, but would require a large amount of knowledge and skill to do in a way that can't be detected.
Thank you very much, sir.
so we got to, it's possible. But that still gets to Jen McCabe didn't do it, right? So it's possible. That's not really your average IT thing, but he's getting to it's possible with a large amount of knowledge and skill. But this, well, we will see. I think it's a reach because the defense originally was saying Jen McCabe deleted it. And now the defense has shifted from Jen McCabe deleted it, which is an interesting shift, but that's their job to keep shifting at things, right? So we'll see. But I think the defense shifting their questions of the IT expert shows maybe that their IT expert is not going to overcome the testimony of these, but we'll see. And by these, I mean both the state's IT experts, both the Commonwealth's IT experts.
On the iOS version and the demonstration that you did, what, if any, impact does that have on what you showed this jury?
So in this particular case, every iOS version that I tested, as I mentioned, from 12, 13, 14, 15, 16, 17, and 18, the timestamp is always referring to the time that the tab took focus. So even though there are some differences with when the record's created, the meaning behind that timestamp has been consistent.
Now, what you were asking about what you were asked about in regard to selective deletion, you indicated that there's no evidence of that in this case. Is that correct?
Correct. Selective deletion would require that the record existed in the history database in order to be selected to be deleted. The fact that there's no missing records indicates it was never written into that database and therefore could not have been selectively deleted.
Now, the hash mechanism that you testified as far as detecting whether or not someone had surreptitiously gone in and deleted things, did you see any evidence of that in your review of the extraction of Ms. McCabe's phone?
I didn't have access to the hash information to see whether any changes had been made.
Interesting.
That's something that the original examiner would have had access to. From my point of view, there was nothing in there that would indicate that tampering had occurred. The timestamps all made sense for the files. The historical pages all made sense. So it's probably possible, but it would take a large amount of skill to do.
Also, the examiner who had the hash data said that the hash data had not been manipulated. Jessica testified to that last week.
Now,
So-
with regard to your analysis and your testing in this case, again, what is your opinion or conclusion as to when these two Google searches were conducted?
I'm of no doubt that the only time those two searches were conducted was at 6:23 and 6:24 on the morning of the 29th.
Thank you, sir. Nothing further, Your Honor.
Prior to today, have you ever heard of spontaneous deletion?
It's not a term that I'm familiar with.
Thank you.
All right, sir, you are all set. Thank you very much.
Thank you.
And this witness is
Need a
done.
couple minutes to put your stuff down?
I can probably be quite fast. Thank you.
He's trying to be quite fast. So the defense, I think, on cross, the most impactful part of their cross for me is if there's no spontaneous deletion, how does it get deleted? But this witness was saying, look, if it's not written to the file, it's not really deleted, it's just not written. So I'm going to zoom while this witness takes down his demonstration and we see who the state's next witness is. The Commonwealth's next witness. My brain has reverted back to a previous file version.
So I hope you got it.
I didn't even hear who they called.
The court and jury of the case are here to the truth, the whole truth.
I was zooming. We're going to find out together.
Yes, sir.
Thank you.
Good afternoon. Oh, good afternoon now. Good afternoon.
Let's see what witness number we're on.
Good afternoon, sir.
Good afternoon, sir.
Could you please state your name and spell your last name for the jury?
Yep, Nicholas Guarino, Guarino.
And how are you employed, sir?
I work for the Massachusetts State Police.
And how long?
I know
have you
he's
been
not
a member
bald,
of the
chat.
Massachusetts State Police?
This is my 9th year now.
Now, prior to working with the state police, what, if any, prior experience did you have in the field of law enforcement?
Okay, Guarino.
I was a local police officer in Norwood for almost 11 years.
Now, with respect to your role within the state police, where is it that you work now?
I currently work at the Norfolk District Attorney's Office.
And within the detective unit, is that
Are we
correct?
just, are you
Yes,
just
that's
calling
correct.
all of them?
And with respect to that,
You don't have to.
What, if any, specialized role do you have within the detective unit?
I don't think it helps.
Attached to the Norfolk DA's office?
Yeah, I conduct cell phone forensics, computer forensics, and I also do sexual assault investigations.
Well, I am interested in the cell phone forensics. I'll stop being snarky.
In regard to the electronic forensics,
is
what, if
needed.
any, specialized training have you received in that particular area?
I have about 300 or so hours, Cellebrite, CCO, CCPA, cell phone repair forensics, Berlin motor vehicle forensics, Axiom magnet, cell phone and computer forensics, X-Ways. These are all different programs used for cell phone and computer forensics.
Chat, shall we just 1.25 his background,
Sir, at
training and
some
experience?
point,
Should we just do that?
you
Let's do
become
that.
involved in the investigation involving a
Background training experience, I'm
Yes.
zooming him up. We're on witness
With respect to that,
66.
let me just ask you, at some point, did you become aware of an affidavit from a defense expert named Richard Green?
Yes, I have.
And sometime following that, did you have occasion to reach out to Cellebrite with regard to what had been posited by Mr. Green as with
Really?
regard to
We
two
just had the
searches
Cellebrite
contained
witness.
within Jennifer McCabe's phone?
Yes, I did.
And eventually, at some point, did you have occasion to speak with the gentleman who came in here right before you, Mr. Ian Whiffin?
Yes, I did.
And so that wasn't Trooper Proctor that had reached out to Mr. Whiffin or had any communication that you're aware of with Mr. Whiffin, correct?
No, I reached out after the defense expert's findings were released, and I read his report.
And did you also have occasion to review a report from a Miss Jessica Hyde?
Yes, I did.
And with respect to those two reports, what, if any, conclusions or opinions did you come to independently?
All right, I'm going to slow him down because they're getting right to his conclusions. He got the defense expert report. He reached out to the other witnesses and said, hey, can we talk about Jen McCabe's phone? Third witness about Jen McCabe's phone.
In relation to those opinions of Ms. Hyde and Mr. Whiffin?
Objection.
Sustained.
Now, Trooper Guarino, you had mentioned
Lay the
that
foundation.
you've had specialized training in regard to something called Burla, correct?
Yes.
Could you please explain to the jury what Burla is and
We're going back to 1.25.
how is it used in criminal
Lally did
investigations?
try to go faster.
So Berla is
Defense isn't
specialized
having it.
hardware and software used to download the infotainment and telematics modules in a vehicle. So telematics module is basically like the SIM card for the car, and the infotainment system is your.
Oh, wait, you also downloaded the infotainment system? Wait, did Lally just move on? So Lally's not going to ask him about the phones. Are you here for the infotainment system? That would be better.
radio head unit that enables you to have Apple Play, CarPlay, or Android or Google Play for the vehicle.
And at some point, were you made aware of a search warrant that was authored in regard to seizing the infotainment system from Ms. Reed's vehicle?
Yes, sir.
And just so the record is clear, can you describe Ms. Reed's vehicle as far as what
Okay,
type of
so
vehicle we're talking about?
Yes, it's a Lexus
Downloaded the
LX
car?
570 SUV.
And specifically on February 2nd, 2022, did you have occasion to remove that infotainment system from the vehicle pursuant to that search warrant?
Yes, I did.
And once that item was removed from the defendant's vehicle, what, if anything, did you do with it?
After we removed it from the vehicle, it was brought back to Norfolk DA's office for a data extraction, or attempt to.
And
Oh.
that data extraction, if you know, based on your training experience, sort of how is that conducted, or what is the process of extracting data from using Burla?
So depending on the system, it's dismantled. They have this specialized hardware that actually goes onto the motherboards of these systems, and we're able to pull the data. Or the other option, if that's not viable, is to do a chip off, where we have to basically destroy the motherboard and take the memory chips off the devices to try to get the data that way.
Now,
Try to
with
get the
reference
data
to
that
this specific device, what, if any, efforts did
I'm
you
not
undergo
optimistic.
in order to extract the information without using the chip off?
So at the time that we pulled the system, it was not supported. I emailed Burla and called them see if they had a timeline of when this might be supported so we could get the data. We deemed chip-off last support, as a last resort because it is a destructive process. So once those memory chips are taken off, the likelihood of trying to reattach them and get it to work again is very slim.
Let me stop you there for a second. When you talk about an item being supported, what does that mean?
Whether or not Burla has the ability to pull the data from that vehicle.
So the 2021 Lexus was not supported.
How is that sort of determined, or how are you able to ascertain whether or not a particular vehicle, make, model, manufacturer is supported by the Burla device?
They have an app, and they also have their tech support. But if you put in the VIN of the vehicle, or if you don't have the VIN, you have the make, model, and trim level, like limited or XLE or whatever, you would be able to go in and look it up and basically say, Burla will tell you, yes, it's supported for GPS points, or it's supported for diagnostic data, or whatever that they're able to get out of the vehicle. And they work with the automakers to get these, get this data. So.
And approximately how many different types of if we're looking at sort of the entirety of different makes and models of manufacturers, if you know sort of what percentage of those types of vehicles are actually supported and Burla can actually extract information?
I don't know as of right now. It's a lot, and they're constantly updating it, so they are able to do more vehicles as time goes on.
Now, at this particular time, as you sit here today,
Oh, geez.
17, 2024, the vehicle that the defendant was operating on January 29, 2022, is that vehicle available or supported by Burla at this time?
The trim level that the defendant had is not still supported. There is Toyota and Lexus support now, but it's not, unfortunately, for her model.
Now,
So
you mentioned that you had reached out to
can't the
Burla
FBI get
company
it? They got
for
Murdaws.
updates as far as the availability or when the defendant's vehicle might be supported. Is that correct?
That's correct.
And about how many times and over what time period are we talking about that you reached out to ascertain?
Immediately, when I did the extraction, I should say extraction, but when I took the system out of the vehicle, I had to reach out to Burla because
Did you ask
where
the
it wasn't
FBI?
supported, they actually had to send me tech diagrams so I could go in and, again, not destroy the whole vehicle as I just took those components out. Over the next, almost 2 years, year and a half of going back and forth with them, with their support and their sales team.
Did you send it to the FBI?
And when you say going back and forth, about how often were you reaching out to them or how often were you getting a response in regard to the Burla?
Usually every few months, I want to say every 3 months, give or take. I forget the exact number, but phone calls or an email to them asking.
Now, beyond that, are you familiar with a National Cyber Crime Conference?
Yes.
And do you attend that on an annual basis at least?
Yes, I do.
And with respect to that, what, if any, time at those conferences did you spend dedicated to ascertaining the availability or the supportability of this vehicle with
What?
reference to Burla?
So Burla has a booth at the National Cybercrime Conference. I spoke with their sales team there.
The sales team?
Their response was to keep calling Burla, keep pestering them, and they might actually get the support sooner than later.
And again, were you ever able to ascertain or get the support to download the information from them?
No, unfortunately.
Now, at some point,
So you didn't download the defendant's car, or did you send it to someone else? What is happening?
at some point, were you able to download any information from that particular infotainment system from the defendant's vehicle?
And not from the infotainment system, but Burla released a new item similar to a mechanic scan tool. It plugs into the OBD2 port, which is underneath the dash. So we're basically, if a mechanic went in there with a scan tool to tell you why you have a check engine light, this does something similar. So you plug it in, and then it pulls the car diagnostic data from that.
And as far as the data that you received from that, what, if anything, did you observe?
Again, I got a series of 14s was the numbers. It was no readable data. I reached out to Burla and asked them, I said, is there a reason why it pulled this data, but when I put it into the software, it's not telling me anything. It's not given me any readable data. And they said they know it is diagnostic data, but they haven't got anything from Lexus to say
What
these 14s, these codes mean this.
mean?
Oh, they only know it as emissions.
So was Burla itself able to read that information and transform that sort of binary code into any sort of readable data for you?
Other than the number 14, no.
Now,
Who else did you ask?
from there, what, if anything, did you do with regard to the Burla and the defendant's vehicle?
Was placed back into our digital evidence lab, and then we did eventually do a chip off to the device.
Now,
Actually, both devices.
with respect, to the chip-off, that was done sometime in December of 2023, is that correct?
Yes, that's correct.
And again, if you could expound upon a little as far as, can you describe for the jury sort of the chip-off process, why you were reluctant to do it, and what's entailed in it?
As I said before, it is a destructive process. As soon as we do it, we take those memory chips off.
Why didn't you send it to someone else?
It's applying extreme amounts of heat to the motherboards to take the memory off. That'll heat it. You lose a lot of the soldering and capacitors, anything that's on that motherboard. So, like I said, once
The material provided by Mr.
Oh, we're back up to real time. That's why I was on 1.25.
Were you then able to cross-reference that eventually at some point with respect to the information in both Ms. Reed's phone and Mr. O'Keefe's?
Oh, hold
Yes.
on. That jumped a bit. Hold on. Like quite a bit. Give me 1 second.
signal, and then
Because now we're on cell phone data. That's an odd jump. Sorry, y'all. I don't know why that jumped like that. Nope. We were at the chip off.
see by O'Keefe, but there were no ring.
Somebody was getting chip faced. Hold on. I don't know why that jumped the way it did. But I don't want to miss it. So. Oh, we missed a whole sidebar. What else did we miss? Hold on. Let me back
The
up.
board. So, like I said, once the
There we
memory
go.
chips are taken off, it's going to destroy the board.
And as far as that chip-off process, who, if anyone, was present with you, or who, if anyone, assisted you in removing that or conducting that chip-off process with regard to the motherboard from the infotainment system from the defendant's vehicle?
I'm sorry, at the time that we actually did the chip off?
Yeah.
Yeah. It was myself, AG Speak, and Maggie Gaffney.
And who is AG Speak?
AG Speak is has his own forensic company, I guess you could call it, for Burla. I could consider an expert in the field, former California Highway Patrol officer that exclusively handled stolen cars.
CHP has entered the chat a lot today. A former CHP officer whose name is AG, who works with Burla.
And who is Ms. Gaffney?
She was a defenses expert. She's the one who actually did the chip off, applying the heat and taking the chips off in our presence. And she, I believe, works for, I'm sorry, the name of the company escapes me at the moment.
Now, with respect to the information that you, Ms. Gaffney, and Mr. Speak were able to remove pursuant to that chip-off process, what, if any, usable information
Why
were you
not
able to glean from that?
send it elsewhere?
As I was told by AG, there was no data that was recovered off the infotainment system or the telematics module from the chip off.
No
And
data
as far as
recovered.
Ms. Gaffney, did you have any conversation with her as far as the information that she was able to glean or read or decipher from?
No, once she did the chip off, I had not spoken with her since.
You have a moment, John.
Yes.
At some point, now, Guarino, at some point in late January, early February 2022, were you provided with some a laptop and/or desktop computers from the home of Mr. O'Keefe?
Yes, I was.
And what, if anything, did you do with those?
One was a Dell laptop, the other was a HP all-in-one
this
desktop.
I'm actually interested in hearing.
Removed the hard drives from both systems and used.
Objection, may be seen, Your Honor.
Okay.
Well, now we can zoom past this. So they tried to crack into the defendant's car to get GPS data and more, and they could not get anything. I think it is helpful to note that the person who physically completed the process was the defense expert and not the troopers, but they tried to crack it digitally and could not. They tried to crack it physically and could, well, by physically taking the chips off and then cracking those chips, and they could not. So there is no more data from the defendant's car. That answers that question. Now let's see what data there is from the victim's computers. Well, I guess I should say what, if any. So we will see. It's a long sidebar. There we go.
All right, Mr. Lally, you can continue.
So Trooper Guarino, there was a Dell laptop and an HP Pavilion all-in-one desktop, correct?
Yes.
These were taken from Mr. O'Keefe's home, is that correct?
Yes, they were.
What, if anything, did you do with respect to those computers?
No! That's the feed buffering. Maybe that's why.
Yes, they were.
What, if anything, did you do with respect to those computers?
Why is there a feed glitch? We're going to give it a second.
And the images were
They
loaded
extracted,
into.
let's see.
They were imaged.
Okay. The drives are imaged.
And the images were loaded into Axiom to view the data that was on them.
Now, when you say something was imaged, can you explain to the jury what you mean by that?
It's a bit-for-bit copy of the hard drive.
The Axiom, like
Instead of
Wally's
us turning
ship,
it on and going through it,
well, it's
which
not
would
Wally's
change
ship, the
data.
ship Wally was on, but
By
yes.
taking the hard drives out and imaging them, it creates a one-for-one copy, so that way we can view it without changing anything in the system.
Should you have told Proctor about that when he was like physically going through the defendant's phone, and he should have been going through a forensic copy?
And
Maybe.
you mentioned a tool called Axiom, is that correct?
Yes.
And can you explain to the jury sort of what is that Axiom tool and how does it work?
Yeah, it's another forensic tool that we use. Can do cell phones, computers. You'll use it to load the images so we can view the data.
And with respect to the imaging that was done with regard to the Dell laptop, and
I'm very
the
interested to
desktop,
hear what
if anything, was it
comes
that
up
you were
that's
looking
relevant.
for specifically on those devices?
We were looking for a Ring video to see if either computer was used by Officer O'Keefe as a login machine to handle the account.
And from your review of what was extracted or imaged from each of those two respective computers, what, if any, information
Wouldn't you generally do that from your phone, though?
gleaned in reference to Ring.com or anything else?
Neither computer was used. One appeared to be used mostly by the kids, and the other, I believe, was the laptop, was used mostly by O'Keefe, but there were no Ring logins.
As far as the Ring connection, what, if any, devices were you, throughout the course of the investigation, were you able to ascertain were actually connected to the Ring cameras at Mr. O'Keefe's house?
Officer O'Keefe's cell phone.
Now, if there were any other devices, whether they were Mr. O'Keefe's or someone else's, ascertained from either
I only heard the
footage
sigh.
or the information provided by Ring, whether or not there were any other devices beyond Mr. O'Keefe's cell phone that were linked to that account?
Not that I know of.
And I'm sorry, just not that there weren't any devices or not that you could tell?
Not that I could tell or that I ever heard of.
Now, Trooper Guarino, let me ask you some questions just in general about a cell phone extraction. Are you familiar with that term?
Yes.
And can you explain to the jury sort of what is involved in that and how a cell phone extraction is performed as far as your experience with regard to investigations that you've been involved in?
Yeah. So most investigations, we get the cell phones from the scene, from a suspect, from a victim. They're put into airplane mode to preserve the data, so that way remote wipe can't be sent to the phone from iTunes. If we can't put it into airplane mode, we'll put it into a Faraday bag, which blocks the cell phone signal. And then it's brought back to the lab and put into a Faraday box, which is has electrical outlets inside of it, so that way we can keep the phone charged.
And with regard to this investigation, you involved in the extraction of data or the examination of extracted data from any particular phones?
Yes, I did John O'Keefe's phone, Karen Reed's phone, and we had 2 witnesses' phones, but I don't remember doing the extractions themselves.
But as far as the data from those phones, have you had opportunity to look at that data? And specifically, I'm asking about both Jennifer McCabe's phone and Ms. Carrie Roberts'.
Yes, I have.
Now, were you also at some point provided with some material from Brian Higgins' phone?
Yes, I saw screenshots of text messages.
Screenshots of text
From the
messages.
material that you were provided with reference to Mr. Higgins' phone, were you then able to cross-reference that eventually at some point with respect to the information in both Ms. Reed's phone and Mr. O'Keefe's phone?
Yes, I was.
From what you reviewed, was the information contained within the material provided by Mr. Higgins, was that consistent with what you observed in Ms. Reed's phone as well as Mr. O'Keefe's?
Yes, I didn't see any differences in those messages.
So no deleted messages or what
Now,
have you.
With respect to
Micro asked, do they know how loud they're breathing onto the mic? No, because the mics don't project in court.
by you on January 29th, 2022.
The mics project to us.
That's correct.
And do you recall about what time it was and where you were when you
So no,
received that
I don't
phone?
think they know.
I want to say 6 or 7 o'clock at night at the Norfolk DA's office.
And who did you receive that phone from?
Trooper Proctor.
And with reference to that phone, what condition was it in at the time as far as you referenced airplane mode, Faraday bag, things of that nature? How was it sort of when you received it?
I believe it was in airplane mode. The phone was in good working order. And it was placed downstairs in our lab plugged in to keep the phone battery charged.
Okay.
Now, the same with respect to Mr. O'Keefe's phone. When and from whom did you receive that, and what kind of condition was that in when you received it?
We're probably not
I
going to
also
get to
got that from
cross
Trooper
this witness
Proctor
today. We're
at the
probably
same
not going
time
to
as
finish direct today.
Miss Reed's phone. Same condition.
Now, with respect to the defendant's phone, at the time that you received it, did you have any passcode or any way to get into the phone?
I'm sorry, whose phone?
Ms. Reed's phone.
Oh,
Reed's phone.
no. The software we use to try to bypass passwords to be able to extract the evidence, or I should say the extraction of the data to look for evidence, her phone at that time was not supported.
Now, what, if anything, did you do with her phone in regard to that?
Again, made sure it was in airplane mode and just kept it plugged in until such time as the phone was supported, and then we could download it.
Familiar with a device called a Gray Key?
Yes.
And can you explain to the jury what that is and what, if anything, you did with regard to the defendant's phone and the Gray Key device?
Yep. So Gray Key is, again, specialized hardware and software used to plug in
For
the
law
phones.
enforcement.
Can do Apple or Android phones to bypass passwords.
And how does that sort of function, or how does that work as far as when you hook something, a cell phone or a cellular device up to a Gray Key tool? What is it doing and how does it work?
If I knew that, I'd be a millionaire. But it basically installs
does things.
software onto it, and
It cracks
instead
it.
of when you put in 10 passcodes to an iPhone,
Also, I think I don't think anyone exactly knows how it works because they're not supposed to know how it works.
on the 10th one, if it's wrong, it kills the phone forever. This has some secret software that's able to bypass that and basically keep hitting the phone with passcodes until
So
it
it
finds the
doesn't
right
wipe
one.
the phone, right? It cracks
It essentially
phones.
runs a bunch of different combinations of passcodes in the phone until it
Don't
comes
think
up with
you can
one.
have one, chat. They're
Yes,
illegal.
that's correct.
Unless you're law
And
enforcement.
At some point, did the Gray Key device actually break into the defendant's phone?
Yes, it did.
you know about when that was in relation to when you received it?
Yeah, so we got the phone in January. It took, I believe support came out in, I want to say May or June, I don't remember the exact month, but we didn't actually get the passcode until August 16th.
It took
of
them a minute to crack
2022.
the phone. Right.
And once that passcode was
Paul's phone in the Murdoch case took quite a while to crack too.
then you're able to look into the phone, is that correct?
Yes, once the passcode's obtained, we download the data, and then we're able to take that extraction data and then open it up in Cellebrite or Axiom or whatever tool we're going to use to view it.
And the tools, as far as you're referring to, Cellebrite and Axiom, are you familiar with those tools through your course of your work as an investigator with regard to electronic devices?
Yes.
And if you could explain to the jury sort of when you say Cellebrite and Axiom, as far as then tools are concerned, how do they work and sort of what is it that you do with the device with reference to Cellebrite?
So what do we do with the extractions once we go to open them?
Well, how is the information extracted, first of all, and then
Yeah,
what, if anything,
Trooper, it's not you. His questions are
So
tough.
Great Key will pull the extraction. Well, it just, once the code's received, it again uses its software, pulls the data out, puts it into an encrypted, it's MD5 or SHA. It's a encryption key that has it's a unique key that, so if you changed anything inside that zip file, it would change the encryption number to show that something was tampered with. We take that encrypted zip file and we open it up in the software, and that's able to say, you know, the call logs, the chats, the photos, the whole timeline of the phone.
Now, in addition to yourself, is there anyone else that works in this sort of capacity within your unit at the District Attorney's Office?
Yes, 2 other people.
And who are those 2 other people?
The director of our lab, Samantha Vogt, and Trooper Connor Keefe.
Now, beyond yourself, Trooper Keefe, and Ms. Vogt, anybody else from the detective unit, as far as the troopers, would they have access to these devices, being defendants, Mr. O'Keefe's, Ms. McCabe's, or Ms. Roberts?
If they're in the digital evidence lab, no. Once the data is extracted from them, normally we give them back to the investigator or
So the
return to family.
investigator gets back the physical
So
phone.
that would be the only time that they would have access to the devices, or unless we kept them in the lab for, just for, I don't want to say safekeeping, but just for storage reasons.
Now, with reference to your review of any of the extractions related to any of those 4 devices, at any point in time, did you observe anything in reference to any information being taken off or deleted from any of those devices at any point in time?
No, sir.
Now, with respect to Ms. Reed's device, the defendant's device, it was sometime in August of 2022 that the Gray Key was able to break into the passcode and get
That's
into
what he
the
said.
phone, correct?
That's correct.
And so then, once an extraction is done, that's then subsequently reviewed by someone within your unit, is that correct?
Yeah, so again, normally the investigators for the homicides know far more information about the crime and what occurred. So if need be, I'll load the phone up for them. They can go through it because they know what they're looking for. If they ask me, I'm happy to go through. If they can say,
When you say load the phone up, do you mean the forensic copy of the phone, or do you mean opening up the actual physical phone? I've got questions.
I'm looking for calls between this time period, or, GPS locations, things like that.
Now, with reference to...
I hope he
defendant's
means
phone,
the
at some
forensic
point were you
copy.
made aware that there was some privileged information contained within her phone?
Yes, I was.
So as a result of that, what, if anything, happened with the phone from there?
We notified our supervisors, and we did not look at her extraction until the privileged communications could be removed, and then we could, again, go back and
It went to like a taint team.
re-inspect the data.
Now, as far as that whole process that was undertaken in regard to that, how long a time period, or when was it that you were able to have the privileged information extracted and then actually get to look at the defendant's phone?
It took months. I don't think we got it back from the AG's office until later, springtime of 2023. ish.
Now, with respect to the extraction from each of these four.
So for those
respective
asking,
devices,
Proctor went through the phone in August when they cracked it. Then they saw that there were text messages between Karen Reed and Yannetti from January 29th, apologies. So from January 29th, they saw text between Karen Reed and Yannetti, and that's when they say that they stopped everything with the phone and sent it out to the AG's office to take out any conversations between Karen Reed and Yannetti.
That being the defendants, Mr. O'Keefe, Ms. McCabe, and Ms. Roberts, what kind of tools were used to conduct those extractions, sir?
Gray key, Windows 10, and then Cellebrite Physical Analyzer and Axiom, their program, Magnets program.
And so as far as, I guess my question is, as far as the different devices that are used, why are there different devices and what is it that, say, one does versus the other?
So they both do great work with
My internet company calling me back.
decoding the
Even though
data.
Dr. B called me. I'm like, I can't talk to you now.
I've noticed that Axiom does a better job at pulling GPS spots because it gives a speed and a estimated range of how strong the GPS signals are, as opposed to Cellebrite. They give native locations, but they don't have that extra data with it. So I like to look at both tools to make sure that I'm seeing everything that I need to.
Now, with respect to the defendant's phone, you at some point reviewed
Speeds will be
the
helpful.
extraction, from the defendant's phone, correct?
Yes, I did.
And with respect to that phone, what, if anything, did you observe?
Speeds will be
with
very
regards to,
helpful.
GPS locations associated with that device.
I didn't see that many, maybe a handful showing different spots in Canton, but nothing that stood out to me.
Now, with respect to your review of the phone, what, if anything, were you able to ascertain as to whether or not those GPS locations were allowed or permitted or turned off or on by a user?
I can't say. I didn't see anything, like I said, that stuck out to me. Normally, if the GPS points aren't there, then location services are probably turned off.
Probably.
What I'm asking, though, is the device itself was capable of retaining that data as far as
He said
GPS
probably
locations,
turned off.
correct?
Yes, if it's turned on.
And there were no real GPS locations to speak of that you observed in your review of the extraction of the defendant, correct?
That's correct.
That's
Now,
not
with
helpful.
regard to Mr. O'Keefe's phone, what, if anything, were you able to ascertain from that as far as GPS locations were concerned?
There's quite a bit, especially on January 29th.
Now, sir, before
That will be helpful.
we get into that, if I could ask you
No.
some questions.
Get into that.
In regard to Ms. McCabe's excuse me, phone extraction. You had occasion to review that, is that correct?
Yes, sir.
And so, in regard to that also, you had mentioned that you had
I'm gonna
reviewed
sneeze. Chad, I'll be right
an
back.
affidavit from a defense expert or defense witness named Mr. Richard Green, correct?
That's correct.
And based on your review of that, what, if anything, based on your review of what Mr. Green said or did, what, if anything, did you then do with regard to Ms. McCabe's phone?
So I basically went point by point through his report to confirm or deny if what he was placing in there was true.
And what, if anything, were you able to ascertain or learn from?
This is about the defense expert report.
With reference to what Mr. Green stated.
Objection.
I'll allow that.
It was mostly incorrect.
And when you say mostly incorrect, what was mostly incorrect?
So he states that there's a Google search that's done at 2:27 in the morning that immediately stuck out to me because when I went back and looked, that file that was parsed was not from the database that should have showed searches. This came from the session state tabs for Safari, which is a big red flag. It also came from a wall file, which is a dropping ground for where data is put before it's actually put into the main database itself. And then once it reaches a certain point, that data is automatically deleted by the device, not by a user, which Mr. Green had stated that a search was done and then it was purposely deleted. There was also items regarding phone calls being deleted. Again, they came from a wall file. Looking at it, again, it's stored in the knowledge seed, the main database. It's also stored in the biome, showing in the extraction, which is another storage area that Apple is using. Again, nothing, most of the stuff that I was reading in his report was either incorrectly, I don't know, written down, or he's interpreted it incorrectly.
Now, with regard to the phone calls or the contacts.
So he says most of the defense report was based on data that he interpreted
deleted by
incorrectly.
the user. What, if any, information did you look in regard to that? What, if anything, did you ascertain in regard to that?
Yeah, so he stated that Ms. McCabe had deleted 18 phone calls from the morning after John O'Keefe's body was found. Looking at the data from her call log, those calls, while they do show marked as deleted, again, they come from the wall file, and they're also located in 2 other parts of the database. Again, as a user of an iPhone, you can't go in and just delete these files. They're handled by the operating system. It's impossible.
So as far as, what, if any, opinion do you, well, let me ask you this first. As far as a wall or a writing log file, can you explain that, what you understand that term to mean to the jury as it pertains to these particular items?
Yeah, so as I said, these files are dropping ground. So when you're using your apps, using the phone, takes that data, puts it into this
Wouldn't
wall
it be
file
on
until
the
you
call
either close
record
the
log?
app or you shut down the phone, or it reaches a certain number of data
Where
in
are
the
the
phone,
call log-
that wall file
what
will
do the Verizon
automatically
records
delete from
say?
the phone.
Or whatever.
So this can be on a first in, first out basis. Again, like I said, it could be when data reaches a certain level, but those calls that are being marked as deleted, Cellebrite seeing, it doesn't mean the user deleted them. It just means they're being removed from the wall file.
And you indicated that from your review of the phone
Just
extraction.
just grab the phone records. Like, that's an easy solve. The search is a harder solve. This is an easy solve. Grab the phone records. What her cell phone records say from the cell phone company is the calls that were made or not made. I guess what they're trying to say is, why didn't those calls show up on Jen's phone? But where are they on Jen's phone and what was deleted? Because some of the calls, she said she removed texts and stuff before she turned her phone over to be extracted. So, okay.
There were other areas or other databases, bases, within the phone that contain that same information.
Yes. So the
Just
main database of the
call records, that's
iPhones
it.
is the Knowledge C database. They're also using Biome, and then if you're using the newest software now, it's another area I won't bore you with, but depending on the
Sir, I
iOS
think
you're
it's too
using
late,
for the
though.
phone,
And that's not your fault.
it's going to depend on where that data
some
is
of
being
this
stored.
Larry's fault.
Now, specifically with respect to Ms. McCabe's phone, one
Can we
of
get back to the
connections
victim's
Mr.
phone?
Green had was in regard to a contact for Brian Albert, is that correct?
Yes, that was another one.
With respect to that, what, if anything, were you able to find within Ms. McCabe's phone in regard to contact information for Brian Albert?
Yeah, so Mr. Greener's report said that he located a deleted screenshot of Brian Albert's contact. That was in her phone. The contact for Brian Albert was still in her phone, not deleted. So I don't know, maybe she just deleted the screenshot.
Like when she saved the number?
Now, with respect to Ms. McCabe's phone, what, if anything, did you do with regard to the call log history in Ms. McCabe's phone?
I exported it all out to a PDF so I could view it. And again, like I said, there's, I think, 1,104 phone calls from going all the way back
So
to
did you-
October of 2020, I want to say.
And that's what I'd want to look at.
Phone calls,
Is the call log
FaceTime.
from the phone?
They're all, the calls are there, all the records, and they're all stored in different areas of the phone.
Call logs from the phone,
The only
call
ones
logs from
that
the
show
cell
the wall
company.
file deleted were the ones from the 29th going up to the end, towards the end of the day, on the 29th.
But are
And
they
now with
still in
respect
the,
to the-
no, but are they still in the call log records?
Call history, where or how is that typically stored within an iOS device?
I believe that's stored in the call stored dash SQLite database.
And with reference to what, if any, difference storage-wise is that SQLite database versus the wall file?
Oh my God.
So again, yeah,
So
that
again,
database where the call logs are sent, it's going to
So
have
again.
a corresponding wall file where the data is going to be put temporarily. And then, as I said, it gets automatically deleted by the iOS, by the operating software. It's not user enabled. Or
And so from your review of those 1,104 phone call history records contained within this extraction of Mr. McCabe's phone, what, if any, opinion do you have in regard to whether or not those items were deleted by any user?
I don't believe they were. And actually, I will say one of the phone calls was from the actual main call stored database. That could have been user deleted but again, it's in 2 other spots in the operating system, so I don't know how or why
so maybe
the
one.
iOS stores it the way it does, and then marks what.
And then marks what?
Now, sir, from your review of the 4 phone extractions that you reviewed in
Can
this
you
case,
tell us what happened to the
be
victim?
able to export or print certain chat reports from specific people's phones or from specific people's phones with other individuals?
Yes, I was able to.
And Your Honor, may I approach?
Yes.
She's like, can we just literally like just zoom. Oh wait, I can zoom.
Eight.
That's a large binder. Is that entire binder Exhibit 84? Yep. That entire binder is Exhibit 84. Or 48. My dyslexia can't tell. But one of the two.
You recognize, excuse me, do you recognize that, sir?
Yes.
And what do you recognize as?
The first page is Facebook Messenger chats between Karen Reed and John O'Keefe.
Okay.
And what's contained in there, is that a fair and accurate portrayal of what you
This I'm
observed
interested
from
in.
the extraction
Tell me about the
from Mr.
Facebook Messenger
O'Keefe's,
chats.
phone?
Yes, it is.
And specifically with reference to those chats between Mr. O'Keefe and the defendant, you also reviewed that material from the defendant's phone as well?
Yes, I did.
Material that you reviewed from the defendant's phone, is that consistent with what you observed in Mr. O'Keefe's phone?
Yes, it is.
So the chats reflect equally on both sides. Okay. Oh. Who said that? Was it this witness? Sir, blink twice. Did this witness say that? Or did Lally say that? I'm rewatching. Hold on. This witness said that.
Your Honor, with the court's permission, if I could request certain portions of.
Sir, you're a cell phone expert in a murder trial. Like, you, with a microphone in front of you. What's happening in this trial today? Because, sir, did you not want this case to go forward either? I don't think that was Lally. That, I think, was this witness. We're going to do that hot mic moment one more time, and then we're going to move on because my brain has to keep going. But I think that was this witness. And I wonder if it's specifically regarding Lally's questioning. That's me speculating and being snarky all in one. But this sounds like this witness saying, kill me, under his breath. But for those of you that are just listening in the background, come back and watch real quick because well, I think he said it.
Yes, it is.
Yep, totally this witness. What this witness
Your Honor,
said
with
was
the court's
kill me.
permission, if I could request certain portions of what's been marked as Exhibit 48.
Wow.
Published to the jury as we go through them.
Okay.
Totally this witness. Yeah, totally that witness.
Sir, if I can just start you out on.
Oh
page
boy.
Okay.
Well, Hallie, your witness is tired.
Now, with respect to what's up on the screen, the portion that you can see, do you recognize this, sir?
Yes, I do.
Now, what you have before you as Exhibit 48.
Yes.
Now, within this particular, from the perspective of this is from Mr. O'Keefe's phone, is that correct?
Yes, it is.
So there will be.
Whoop, I didn't mean to pause. I'm trying to move the
Is that correct?
closed captioning.
Yes.
Which didn't pick that up, by the way.
From, as far as the blue bubbles are concerned, who is speaking?
It's Facebook Messenger.
The blue bubbles will be from Mr.
Chat, yes, I agree with you. Alan Jackson was like, that's going to be a meme. I think this moment is going to be a meme with this man sitting on the stand whispering into the microphone.
Reed, and the green bubbles are from Officer O'Keefe.
Now, Ms. Gilman, if you could please scroll down. Now, with
All right, these are
respect,
he said
to what's
Facebook
contained
Messenger
on this
chats.
page one at the bottom, if you could read the date and the time and indicate who is speaking.
This
and
is
what
1:28 at
So,
3:30 p.m.
The blue bubbles is Karen Reed. And
Hold on, chat. We're going to take a minute just because we all need to take a minute to celebrate real quick. You guys, shit's redacted. Shit's going up on the stand and it's redacted. So we're all going to take a minute to celebrate where we can. Look at that being redacted. Yay, redaction. Let's keep going.
1/28/2022 at 3:30 p.m. Hello. John says
Hello.
hi at 3:35 p.m.
If you were wondering how old the victim and defendant are, they are messaging each other on Facebook. Because everyone I message with is on Instagram, unless it's for work.
Those are the Facebook ones.
How many pages of Facebook messages are we going through?
What's contained in Exhibit 48 is the entirety of the chat
400
report from
pages.
Mr. O'Keefe's phone, correct?
Yes, I believe so.
Okay.
That entire exhibit's
approach,
going to
Your
the jury.
Yes.
My apologies. Showing you another document. Do you recognize that?
All of binder
Yes.
48
What do you
goes
recognize
to the
that
jury.
be, sir?
These are the native chats, native messages from John O'Keefe and Karen Reed.
So these are just specifically broken down as far as the chats between Mr. O'Keefe's phone and Ms. Reed's phone, correct?
Correct.
And as far as your review of both of the extractions from both of those phones, the material contained within Mr. O'Keefe's phone is
Are these-
consistent with the material contained in the defendant's phone, correct?
Cell phone
Yes, that's
chats?
correct.
Your Honor, may I approach?
Yes.
I will proceed to introduce the witness.
You know, I do on Facebook for work. We do Facebook Messenger stuff for work, but I personally
627.
use Instagram Messenger more.
Yes.
The chat's like,
If that
I
could be
use
returned to
Facebook
the witness,
Messenger.
Your Honor, if we could.
Chat, I'm
with
not
the
trying to
court's
attack
permission, if we
you.
could publish that.
Yes.
You guys don't email Alan Jackson about the witness on the stand. Don't. Let the case happen in due course. I'm sure that their legal team has somebody watching. Don't, like a documentary film crew, don't interfere. Just, we're observers of all the things. We're just
Now, Mr. Guarino, do you
the
recognize what's
observers.
up on the screen as the next exhibit, sir? Ms. Gilman, I'm sorry, if you could scroll down just a little bit.
These should be the text messages,
Yes.
not Facebook
Again,
messages.
from this first page, if you could, the blue bubble is from Ms. Reed, is that correct?
Yes, that's correct.
Being from Mr. O'Keefe, is that
These
correct?
are Cellebrite text message
If you
extractions.
could, again, read from this first page as far as date, time, who is speaking, and what is said?
And it's
At 9:49.
again, the redaction is helpful. So this starts at 1/28/2022 at 9:49 a.m. with what looks like them fighting.
9 a.m. Karen says, "You've really hurt me this time." 10:02 a.m. "I'm sorry. This is sorry, it's kind of hard to read. I'm sorry. This has been an issue with me for 8 years. It physically hurts me to see everyone else in their life do things for them, and I'm forced to always be the bad guy."
They're fighting about the kids. This is them on 1/28 arguing about the kids. It seems.
At 10:09 a.m., Karen says, "I am not the same as everybody else. Most of the time, I try to do what is healthy/smart for them. More importantly, I try to support you and what you need. You just lashed out at me and said terrible things. I don't know how you've gotten to this point with me, but I'm just trying my hardest. You made your point and continue to beat me down. I have a lot going on too. Physically, I'm falling apart and trying to get answers and help."
If I could stop you there, sir. If I could direct your attention to...
This is from 1/28 at
Sir, if I could
10:09
direct you
a.m.
to, page 5.
And this is consistent with
Bottom of page 4.
what we've heard from
All right.
from others talking about them
Sir,
arguing over the
move up
kids.
On the bottom of page 4 again, if you could indicate as to...
Why are we
speaking,
jumping
what is said,
around?
and the date and time, sir.
Karen says to John at 1:21 p.m. on the 28th, "Maybe you can call someone."
If you could continue
Yep.
on and through page 5, sir.
I see some of you asking
On
if
the
these are
28th
needed.
at 1:46 p.m.
These are needed because the state's theory, again, we've heard from Trooper Proctor, is that they got in a fight and that's part of what's going on. And there was an ongoing fight. And it seemed the ongoing fight, from the testimony we've heard and from this, is he doesn't want people spoiling the kids because they've had tragedy in their life. And he feels like he's forced, it sounds from this text, to be the bad guy because he's the one who has to say no. And Karen's like, look, man, I am your girlfriend. I am doing my best. We'll see.
John says, "Like who?" At 1:47 p.m., "What time are you coming here?"
So John texting
And
her,
then
what time are you
there's-
coming here?
At 2:05, there's a message but no content.
And the next message at 2:06, sir.
Yes, 2:06 from Karen. "I don't know what
1:28.
time. Feel kind of out of it. Just trying to clear my head." 2:06 p.m. John writes back, "Okay." 2:06 p.m. again. Karen says, "Text me later when you guys settle in."
Text me when
later."
you guys
Sorry,
settle in
text me
later.
when you guys
Yeah.
settle in later. John says, "Sure," at 2:06 p.m. again.
My coffee is empty.
Karen says
about
at
it.
2:16, "I feel pretty shitty about this." I feel pretty shitty about how this morning went down. I know you said sorry, but it really stung, especially when I've been trying pretty hard lately. I feel like a loser turning around, just coming back over after everything you said.
I mean,
If I could ask you to continue on to page 7, sir.
Reed's pretty honest to me. Hey, we got in this big fight. I don't want to just come over.
Okay. At 2:17 p.m., John says, "Not sure what else you want me to do. I said I'm sorry and I was out of line. If you prefer to stay home, I totally get it."
Yeah, maybe she needs a day.
Karen replies back at 2:17, "Things in my own life have been difficult too, you know." John writes back at 2:17, "I know." At 2:25 p.m., "Tell me if you're interested in someone else.
Oh,
Can't think of any other reason you've been like this." From Karen.
so directly from, we're fighting over the kids too. Is there somebody else?
If you could continue on to page 8, sir.
At 2:25, John responds back, "Nope. Things haven't been great between us for a while. Ever consider that?" That was at 2:26. At 2:29, he writes, "Kids are here, not in the mood to talk."
I wonder if she tried to call him in the intervening, because that text message, and this is just me listening to this, that text message sounds like kids are here, not in the mood to talk. Like, I'm not responding to a call, so I'm responding with a text.
And how does the defendant respond to that on the bottom of page 8?
So you're not into it anymore. That's fine, but I don't want to keep trying, and you keep treating me like this at 2:29 p.m.
If I could direct you to the next page 9.
Yep. Ms. Reed says, I'm trying to hug and kiss you this morning, and you whack me in the face with a pillow at 2:29. At 2:30, she says, last night you're basically like, yeah, what about? When we talk about the future, so why don't you just admit you're not into it so much anymore? At 2:30, oh, sorry.
Go ahead.
I said 2:30, John says, not how it went down, but okay.
And how does Ms. Reed respond to that?
Can you please admit your head is out of the game with us?
And if you could, sir, please continue on to the top of page 10.
Okay. At 2:32 p.m., sick of always arguing and fighting. It's been weekly for several months now. So yeah, I'm not as quick to jump back into being lovey-dovey as you apparently, from John. And then John again at 2:32. Oh my God, stop calling.
He did say he didn't want to talk.
There for just a
Okay.
moment, sir. With regard to January 28th,
So this is 1:28:22 at 2:32. Stop calling.
you were also able to extract a report specifically in regard to calls received by Mr. O'Keefe. On
Alicia
that
in the chat said,
Yes, I
this dude
was.
hates reading this. It sounds like he hates reading it because,
Yes.
again, what he is reading are a couple that is, it sounds like, both struggling individually. I said that weird. Both struggling individually and then struggling together as a couple because life is hard. And she's like, I've got shit going on. He's like, I've got shit going on. And they're fighting over it. And she's like, I'm not just going to come back over if you say shitty stuff. And he's like, and I'm not happy with our relationship, so I'm not just going to pretend everything's all right and be all kissy. So that's where we're at. But yeah, it does sound like he hates reading these texts into the record, but we're going to
Yes.
go through a bunch of them. So he's approaching with something else. What are the texts from the 29th though? Why are we stopping? Like what, why are we stop? Can we just go through the text from the 29th though?
You recognize that, sir?
Oh, that's the call
Yes,
log.
it's John
Go through the call log later. Obviously she was calling him a bunch. He texted, stop calling me.
keeps call log.
And that's the entirety of the call log from January 28th into 29th, is that correct?
Yes, from 28th at 9:19 a.m. to the 29th at 6:03 a.m.
May I approach, John?
Yes.
I'm off to seek to introduce the minutes of the next exhibit. No objection.
Okay.
Now the documents, just ask you to review that, look up when you finish.
I wish we would have finished the text.
Do you recognize that, sir?
Yes, this is Karen Reed's call log from January 29th at 12:33 a.m. to January 29th at 6:03 a.m.
I want to hear more about
Those are
that call
specifically
log.
calls between the defendant and Mr. O'Keefe, correct?
Yes, that is correct.
May I approach again, Your Honor?
Yes.
I'm off to seek to introduce the minutes of the next exhibit. No objection.
Are you not finishing the text then? We're just not finishing the text then.
Now, Trooper Guarino, from the text messages that you were just testifying from, Mr. O'Keefe indicates OMG stopped calling at 2:32 p.m. Is that correct?
Yes, that is correct.
Now, from your review of those call logs, how many times did the defendant call Mr. O'Keefe on January 28th from approximately 9:19 a.m. to about 2:58 p.m.?
There's 18 calls from 9:19 to about 2:59 p.m.
Those calls are listed within those records as various as far as rejected, or missed, or answered, or things of that nature. Is that correct?
Yes, that is correct.
How many of them are rejected?
11.
How many of them are missed?
4,
And how many are answered?
3.
Now, following that
Which is consistent.
text message,
It's consistent with all the other testimony that she will obsessively call. That is what he said to the witness that testified in Aruba, that she's blowing up my phone. But that's also what happened between midnight and 4:30 a.m. or after 4:30 a.m., 6:30 a.m., when there were 53 calls. We didn't get into the text, but there were 53 calls from her to John O'Keefe, though I think there are interpretations of that she was looking for him, not that she knew where he was. And I think that's probably what the defense is going to argue, is that, right, she was calling him obsessively. She wanted to talk. He said he didn't want to talk, and she wanted to talk. But again, on the 29th, if she's calling 53 times, why are you calling 53 times if you know that you've hit him with a car? That is a question that I have. So let's see.
at 2:32 p.m. from Mr. O'Keefe to the defendant, asking her to stop calling him. Does the defendant keep calling him?
Miss Mandy, that's a good
Yes,
point.
she does.
Miss Mandy said, you just didn't want to argue in front of the kids, not that he didn't want to talk to her. And he did text that and said, the kids are here, I don't want to talk. The fair
At some
interpretation.
point, does Mr. O'Keefe call Ms. Reed back?
Yes, at about 3 p.m. on the 28th. Double check.
Thanks. May I approach, Your Honor?
Yes.
But also, if they had overcome
Agreed, I
this
can
fight,
take,
it might explain why they are lovey-dovey at the bar. So, okay. Because they went out together on the 29th.
Now, sir, if I could turn your
Black
attention
Cat said,
back
but
to
she also
page-
hired an attorney the same day. I don't know when she hired Yannetti. I know there's text between her and Yannetti on the 29th, but I don't know when she hired him. But the jury can't consider having counsel. But I don't know if Yannetti's an attorney she had worked for previously or worked with previously. I did not mean worked for. So I don't know. We only know that there were texts.
Okay, so, Mr. Lally, when you put your head down and when you walk away, we can't hear you. And so there won't be a record of this, so you have to keep your voice up.
I will do, Your Honor. I apologize.
Well, you just said, you just put your head down and your voice went down.
Yeah, Lally, pick your head up and try your case, man.
So keep your voice up. It's really important you do so.
Trooper Guarino, turning your attention back to page 10 of these text messages, would read from Ms. Reed's response to Mr. O'Keefe at 2:32.
Yes, so 2:32 p.m., she says, why would you start with me this morning? And then followed up by 2:33, you're setting me up to fail.
If I could turn your attention to page 11 and ask you to continue from there.
Ms. Reed says, you start a number of fights from your end. John, and that's at 2:33. At 2:33, John writes back, I've explained it a few times already, not doing it again.
And how does the defendant respond to that?
So you're not into this anymore. And then John says, not into fighting all the time, correct. That's at 2:34 p.m.
And if I could turn your attention to the top of page 12.
Yes, 2:34, Ms. Reed says, if you tell me you're interested in someone else, you will never hear from me again. You can have all the space in the world. John writes back, but there's no
Nothing.
contact at 2:34.
Just
And then at 2:34,
bubbles.
she says, then stop starting with me.
How does Mr. O'Keefe respond to that?
I'm not answering.
At
Stop
2:34,
calling.
he writes back, I'm not answering, stop calling.
And if you could, if I could turn your attention to the top of page 13.
Ms. Reed says, can you please answer after how you treated me earlier?
And he's like,
John responds back at
No.
2:35, Kaylee is right here. Ms. Reed says, you're starting a rager with me out of nowhere, and then you tell me you're sick of fighting with me at 2:35. And she writes at 2:38, I'm going to grab a drink in a bit.
If I could direct you to the top of page 14, sir.
She says, can you answer please at 2:38? He writes back at 2:39, no, Karen, not sure why you need to announce that you're going drinking, but have fun. Karen writes back at 2:40, seeing if you want to meet me later. Can you please call me right after that?
And again, if I could direct you to the top of page 15.
John writes back at 2:40, have to take him to the doctor, he has practice. Mr. Reed writes back, yeah, 5 minutes. John writes back at 2:43, my father just walked in. Aaron writes back, okay, can you please call me for 2 minutes at 2:44.
I don't think that's going to happen for 2 minutes. That conversation's not going to be 2 minutes long.
2:44, John writes back, not right now. Karen writes back, I'm there when anyone else needs me at 2:44. 2:46, yes, John, you gave me utter grief this morning. I'd like you to call me for a minutes.
And the last one.
Right,
from that page,
she's
sir.
wants to
2:47, I've been
talk.
trying
He
to get
doesn't
over the
wanna
hump
talk.
with is arguing, and now you tell me you're not into things. And if you don't want to
Not what he
fight
said.
weekly, but fly off the handle at 8 a.m. with me, like you're setting me up to fail.
Sir, if I could draw your attention to page 42.
Page 42. So we're skipping forward in time till, later the same day.
Sir, if I could ask you to start reading from the top of page 42.
Yep. At 7:41 p.m., Karen writes, okay, let me know if you end up leaving. John writes back at 7:42, why? Now you're not coming? Karen writes back, I'm waiting for the plumber. Actually think he's in the driveway. 7:42. John says 7:43, we're taking Mike's car, so I'm relying on you for a ride home if he leaves.
This is her going
Karen
to
writes
the bar
back at
that night.
7:43, he's not going home after. John writes back at 7:43, 8 on a Friday. He may have to get Michael. And you have a plumber coming over at 8. Knowing me and Papa could have handled it. Good luck. And that was at 7:44.
So that's before
I could direct
she
your
shows up
attention to
at
page
CF
49.
McCarthy's. Okay.
Okay.
If I could ask you to.
He lives right down the road, the
Page
plumber.
Page 49, sir.
8:29 p.m. Yeah, but he lives right down the road. John writes back at 8:30. Karen, this storm is going to be intense. Can't drive. 8:30. She writes back, okay, well, if he can't, he can't. John writes back, I'll do it Monday.
Talking about the plumber.
Karen responds at 8:31. Ha, I better not still have this problem on Monday. John writes back, plan on being there. Karen writes back at 8:32. I'd like to know I could take a hot shower here if I need to.
Fair.
John writes back, figured you'd be in Canton until Monday.
He planned on her staying over with
If I
him.
could direct you to the top of next page.
How did they get from fighting to, what do you mean you're not staying at my place all weekend? Okay.
1.
John, I'm getting off my phone. Let me know what you're doing. Karen writes back at 8:33. I think the four of us together is toxic to this relationship. Would like to limit it. And says,
Before
you've said
who
so
together?
yourself for probably a year now. And John writes back at 8:33. Blizzard tomorrow. Nobody is going anywhere.
Sir, if I could direct you to the top of page 52.
Okay. Karen says, maybe I'll come back late tonight. Bad snow is in the early a.m. That's at 8:35. And again, 8:35. I'll head up there in a few minutes. Let me know if you leave.
That's them
John
heading
replies
out
back,
to
sure. And then
CF McCarthy's, I
the
imagine.
next one's not until 12:55 a.m. on the 29th. I'm going home.
So the last text seems to indicate she's planning on heading to CF McCarthy's. That's at 8:35. We've seen the video from CF McCarthy's. I think she arrives around 9. And then at 12:55:31, she's texting him, I'm going home on 1:29. So I would imagine by this point at 12:55, she is back at, or we believe that she is back at John O'Keefe's home, and he's not back.
And the I'm going home is from the defendant. It's 12:55 a.m., is that correct?
Yes, that is correct.
And if I could direct your attention to the top of page 53.
Yes, 12:55 again. See you later. At 1:02, your kids are cucking alone.
I
120.
imagine that's a fucking mistext. And we know she didn't leave, so.
1:04 a.m. I'm back in Mansfield. The kids are home alone.
Thank you, sir. Your Honor, may I approach to retrieve?
Yes. Can I see counsel at sidebar about scheduling?
You are
I bet they're ending for the day. And we're getting close to ending for the day.
I know it's been a long day
Yep.
with this witness, but can we go until 4:15? I know it's been a long day, but does that work for you all? All right, thank you very much.
She was looking at the jury. It sounds like they're almost done with this witness, so they're going to go for a few moments.
you are unmuted.
May I have one moment?
Yes.
Able to get
I'm zooming.
chats as well as some phone calls between the defendant and certain individuals. Is that correct?
Yes.
And may I approach, Your Honor?
Yes.
If you hadn't asked where everybody sat at the basketball game, maybe we would have more time to get through the actual text messages and number of phone calls between the victim and the defendant that actually might matter one way or the other, or at least give some context, or at least seem more relevant than where everybody sat at the bleachers. But no, we spent weeks talking about high top tables. And now they are trying to cram in all of these text messages in 5 minutes. Why? I think he was just saying oi, oi, oi under his breath.
Okay. Okay.
And do you recognize those, sir?
Yes, I do.
And what do you recognize those to be?
The single page is Karen Reed to Laura Sullivan phone calls, or I should say, yep, calls from Laura Sullivan to Karen Reed.
Wait, which one is it?
The other one is Karen Reed and Laura Sullivan's chat messages.
What's contained in those documents, is that a fair and accurate portrayal of what you were able to extract from the defendant's phone?
Yes, sir.
May I approach again, Your Honor?
Yes.
I'm about to seek to introduce the minutes and next exhibits. No objection.
Okay.
Those are being marked. I'm zooming as they're being marked. There is more stuff being marked.
Sir.
The jury's not going to see it, apparently.
A phone call.
And what is contained in that, is that a fair and accurate portrayal of what you observed conducting the extraction of the defendant's phone with regard to the communications with Aaron O'Keefe?
Yes.
May I approach again, Your Honor?
Yes.
So phones and messages with or calls and texts with Aaron O'Keefe.
There's no objection, Ms. Giannetti, right?
And we've heard the sum and substance of those calls and texts from Aaron O'Keefe. She was one of the first 3 witnesses to testify 168 million years ago, back as the
Your Honor,
Earth
may I
was
approach the
forming.
witness?
Yes.
And Katie Camerano. Yes, these are phone calls between Karen Reed and Katie Camerano. And 52 is chats between Karen Reed and Katie Camerano.
May I approach this to retrieve, Your Honor?
Yes.
So these are all being admitted into evidence as documents. Those aren't being highlighted.
Contained in those exhibits 51 and 52, is that a fair and accurate portrayal of what you observed during the extraction of the material from the defendant's phone?
Yes.
What else is coming in?
Sir, showing you what's marked as exhibits 94.
Massive binder.
Yes. Sorry. They are chats between Karen Reed and Jen McCabe, text messages. And 95 is Karen Reed and Jen McCabe phone calls.
And again, what's contained in those records before you is that a
He's
fair and
just laying
accurate portrayal of what you
foundation
observed in
for
the
all
defendant's
of
phone during the
this.
course of your extraction of
Some of those call
materials from her
logs look
phone.
like they're from the
Yes.
cell phone company.
I approach the retrieve, Your Honor.
Yes.
So these are already in evidence, Mr. Lally, so that you don't need the fair and accurate depiction.
She's like, you don't need foundation. The foundation is there. He's trying to lay foundation for things that he apparently is going to either argue later or will talk about with other witnesses, but this is pulling in all the rest of the stuff from the cell phone extraction. And remember, they need to be shown to the defense, they need to be shown to the witness, and then they need to be marked by the court reporter. All right, I'm zooming. Yannetti is going through each of those. Looks like a series of extracted text messages.
I need to see counsel at sidebar for just a minute to figure out the next 2 days.
You are muted.
And in the middle of Yannetti reviewing that, the court has called everyone back to sidebar. Can you feel the judge's stress over getting this case to the jury in time? Sailed. But you can hear it, right, in her voice today. Every time Lally says something, she's like, yes, no, yes. Like you can feel, you can just feel it. All right, we're zooming.
Important that you don't watch TV or. We
You
will be
are
in session
unmuted.
tomorrow, but you won't be, all right? So it's very important that you don't watch TV or listen to anything.
So tomorrow will be streamed. We're gonna do all of the voir dire tomorrow.
Or read about anything. So we will be here tomorrow. Wednesday is the federal holiday, so we're not in session. I know there's supposed to be some big heat wave this week. I really appreciate that everybody dresses respectfully for court. I suggest you come in comfortably. It's an old building. The air conditioning's been great today. I don't know that that will hold up when really pushed. So feel free to dress comfortably. We'll plan on seeing you on Thursday. If that changes, the court officers have your contact information.
If that
Plan on
changes?
seeing you on Thursday. All right, so please, those 3 cautions, do not.
There's a
discuss
possibility
this
that that
case with
changes?
anyone. Don't
Why is
do any
that on the
independent
table?
Research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it. Let us know. We'll see you Thursday night.
We'll see you Thursday. I think she's telling them they can't wear tank tops. Loose fitting clothes. For the heat, they're letting the jury out. Tomorrow's, I wonder what time they're going to resume tomorrow for voir dire, because that's going to change when we resume. Lawnard, you have successfully crashed the Lawnard app. We are working on that. Thank you. Lawnard's break shit. It's kind of how we roll. So thank you for that. We are working on getting it back up and running. So if anyone got error messages with the app, y'all are incredible. And when we tell people the Lawnards break things, they don't always believe us. But, you know, believe me, we did. But we are working on it. So we will have that back for all of you. So you know when we start tomorrow, I'll also put it up on the channel and on socials. I love that the Lawnards break stuff. It just means that a lot of you are excited. So I am curious what time they're going to start their voir dire tomorrow, but I'll be here with you when they do. What does voir dire tomorrow mean? Here's the thing that's interesting about this case. I'm going to just put this up at 1.25 and we'll see if anything else gets put on the record. But they are going to bring in a number of the defense witnesses tomorrow because the defense has not prepped those witnesses because they are from the federal investigation. The court told them not to. So the defense and the prosecution have reports and perhaps grand jury testimony from these witnesses, and that's it. So they're going to voir dire the witnesses outside the presence of the jury
Tomorrow.
to disclose what those witnesses are going to testify to. And by the time the audio cut back in, the court said, we'll see you tomorrow. So, all rise and the court is done. So do we know what time tomorrow? No. But will I check out feeds from the reporters in court later? Yes. And then we'll decide what time we are back tomorrow. And we will be back tomorrow. So tomorrow is voir dire. I was just briefly explaining what that meant. Which that means is that we are going to get like the testimony twice. Remember, if you watch the Murdaugh case at all, this happened in Murdaugh. There was like a full day where they did all of the direct and cross-examination of the witnesses, not a ton of objections because the court just wants to hear it to decide what comes in and out. And they are going to do that again tomorrow. So we will hear it all, and then you guys will hear it again later. So we're going to hear this testimony likely twice because I imagine that this evidence will come in twice. The last witness on the stand is not done, but tomorrow we're going to get into defense witnesses and hear what they have to say. I'm very interested to hear from the accident reconstructionist from the federal investigation, because again, the defense said, hey, we'd like to use these witnesses. And the court said, so you haven't prepped them? And they said, you told us not to. We have their reports, and we have, if they testified at the grand jury, we have grand jury testimony, and that's it. So she's like, am I supposed to believe that the defense is going to put witnesses up without prepping them? And he's like, yeah, we have their reports and we're going to just go from there. And I don't doubt that. Honestly, I don't doubt that the defense is just like, yep, that's what we're going to do. They're both former prosecutors. So tomorrow, those witnesses will be doing voir dire. Just because I see some confusion in the chat, the prosecution is not done with their case in chief. These witnesses are coming in out of order to determine if they're going to testify and when in the defense case, because the prosecution made a motion to exclude them for late disclosure. Let's do a quick summary. I think that'll help. Instead of getting ahead of ourselves, hang on, chat. Let's do a quick summary. All right. And talk about what's happening the next few days. We are at the end of the day on trial day 26th, and it's clear that the judge is struggling with the schedule here. It is Monday, June 17th. Tuesday, the jury will not be present. Wednesday is a federal holiday for Juneteenth. The current witness on the stand who did cell phone extractions for the victim's and defendant's phone is in the middle of direct examination and will not resume that direct examination until Thursday. That witness was just starting to get into text messages and call logs between Karen Reed and John O'Keefe, Karen Reed and others. We have heard that Karen Reed made 53 calls to John O'Keefe in the early morning hours of January 29th. We have not gotten back into that testimony yet. We've also gotten into text messages where Karen and John are arguing over text over something that had happened in the morning of January 28th, and it seems like an argument over the kids, and that is consistent with other testimony that we've heard, and they are back and forth over text, and she is trying to call him, and he is saying, the kids are here, please stop calling, and they are bickering over text message about the state of their relationship, how they move forward. And both of them are expressing that they are each individually struggling and seem to be struggling between or as a couple. So then there's text messages about, are you coming to, CF McCarthy's? Yeah, I'll be there in a minute. I've got a plumber coming. I figured you'd be staying in Canton. So John O'Keefe is texting Karen Reed, I figured you'd be staying in Canton until Monday, and they're talking a bit about the snowstorm. So that's what's happening as we leave testimony. What happens tomorrow? First, I will let you know in the Lawnerd app when I am going live. I'm not sure what time they are starting voir dire in the morning. Voir dire is questioning witnesses outside the presence of the jury. So these witnesses, like we saw in Murdaugh, are going to testify direct and cross-examination to see what their testimony will be and if it's allowed in. The prosecution made a motion to exclude a number of these witnesses, so the court is going to evaluate their testimony and then decide, probably later, what of their testimony will come in. I think most of these witnesses will be allowed in. It seems particularly 2 of these witnesses were hired in the federal investigation of this case, not hired by the defense. And then those reports were turned over to the prosecution and the defense said, we're using these witnesses, thanks so much. And the state's like, I don't know any more about this. And the defense is like, we don't either. We're all going to find out together. So we're all going to learn together what's going on with the defense witnesses. The prosecution has not rested their case. They are in the middle of a witness, but these defense witnesses are coming in from out of state, and it's very important to this court scheduling. So the jurors get a 2-day break on Tuesday and Wednesday. We will be here together Tuesday for that voir dire at whatever time it starts. I will let you know. Everyone will have a federal holiday on Wednesday. Thursday, fingers crossed, the state's going to rest their case. Fingers crossed. And then Friday is a half day in court. I will be streaming from my mobile setup as I will be traveling. So maybe we get into the defense case Friday. Maybe we don't. Maybe we get into the defense case the Monday the following week. Either way, I'm taking you with me. We won't have the fun lights and be able to go code red, but I'm taking you with me as I travel. Fingers crossed, we're here together. Like, we're here together, and we're just gonna make it work. So the prosecution still has maybe more evidence. Is the medical examiner gonna be the last witness for the state? It seems like they might be at this point. It seems like they might be, but the state is not rested, and that's what we're doing. So with all of it, okay, Miguelina, I can't, okay. With all of it, that's kind of where we're at. I'm going to try to answer some questions, and then we are going to be back together tomorrow for voir dire. So we will have to make a reminder that the jury is out all day tomorrow, but the jury is out all day tomorrow. The jury is out all day tomorrow. So yes, I see on my end, I do not have lagging issues, but I see that that is happening on YouTube, and that is a YouTube issue at the moment. Hopefully it will not be an issue going forward. I don't know if refreshing it will fix it on your end, but I can also refresh on my end. So give me 30 seconds. Beg the chat's indulgence for 30 seconds. I will refresh too, just to see if it will help. One never knows at this point. So let's see. Let's. Maybe that helped. Maybe it didn't. Will we ever know? I don't know. Hopefully it helped on your end. All right, let's get to Q&A, shall we, chat? I hope that helped. But there are errors that we are seeing on YouTube. It's tough, but there's not much we can do. We have streamed to many more people at other times, but who knows? Who knows? So sorry that it's a YouTube issue. But it seems like a YouTube-wide issue, not an EDB issue. Frustrating. All right, I'm going to do a few questions, and then we are going to roll. I've still got to record a podcast today. I'm going to go see how the family's doing. You know, the things we need to do. And it looks like we're also getting storms. So I'm going to be able to restart the browser or my router so that hopefully we don't have any stream issues tomorrow. Let's get to questions. So sorry that YouTube's being wild. I'm sure we've let, it seems to be a known issue, so it just is. Karen Russell said the text messages are so sad watching things fall apart. It is sad. They were struggling as a couple. I don't know if the state is if the jury's gonna find that to be motive or to be that they were struggling as a couple. But I'm still frustrated that we got through that whole accident reconstruction expert and nobody talked about the fact that Lexus is known to have auto braking and it's not even come up. Like, it's not even come up. Cumulus Cloud said the fact that there is this much fight about Jen McCabe's phone activity signals, it doesn't match the narrative. I don't know whose narrative, but I think the state, Commonwealth, my brain has stopped. I have been critical of the Commonwealth chasing down defense theories and not just proving their case first. And I stand by that. The state is chasing down defense theories and not standing by and just prosecuting their case. We're going to get a whole nother perspective tomorrow because we're going to get some defense experts. Well, not defense experts. We're going to get some truly neutral experts out of order. I've never seen a case, and I don't know if there's been one, not one that I've covered, but I've never seen a case where there is like an independent federal investigation going on into the case, and then those reports were given to the teams before trial, and then that trial still proceeded. It's wild. Like, it's just wild. So the defense has truly neutral experts. They were not hired by the defense. They looked at this case independent of the defense asking them to look at the case. And that's staggering. Like, it just, that does not happen. So we will see what those experts have to say, but obviously the defense thinks it's good for them because they're bringing these witnesses in, and the Commonwealth still proceeded forward, so they know what's in these reports. Everyone asked for this case to be continued. The prosecution and the defense, they all asked for the case to be continued, and the court said no. So here we are. I still don't know how they chose to elevate this from a hit and run causing death and a DUI causing death to a second degree volitional homicide. I don't think that the reconstruction expert for the state helped, or for the Commonwealth helped them at all. Tiffany said this man is not bad on the eyes. I imagine that was regarding the tech expert earlier. Abby said, car data, taillight video, and dog rehomed. I don't know about the taillight video being rehomed, but the dog was, and definitely some of those calls were. Melanie said the Commonwealth has 80 witnesses, so the medical examiner is last. I don't know why they're putting the medical examiner last. Lally has to know you don't have to call them in order, because you don't have to call them in order. I work in cybersecurity analytics, and the SQL references have me smiling. There were lots. Oh, today was lots. Jody said Emily is bitter about the bleachers. So am I. I'm bitter. I'm fucking bitter about the bleachers. It was a absolutely mind-numbing waste of time. And we're getting to something that actually might help the jury understand what was going on for both the defendant and the victim. And the prosecution is zooming through it at warp speed, which feels like it doesn't maybe help their case. But people, where they sat in the bleachers at the Canton game doesn't really matter for fuck all. And they wasted weeks of time on it. What was going on with the victim and the defendant? And how did this accident happen? And what caused the victim to die? And is there only one explanation for that? Because if there's more than one reasonable explanation, and one of those reasonable explanation points to something other than Karen hitting him with her car, then that's that, right? It's really, really frustrating. Laura's feeling the way I think a lot of us are feeling. Laura said, maybe I'm stupid. You're not. Laura, you're not. This case has been presented in a very frustrating and difficult to follow way. But how does any of this prove Karen killed him? It doesn't. I think the prosecution thought that their reconstruction expert would do that. Their reconstruction expert didn't do that for me. If that expert helped for you, please explain it to me, because I don't have answers from that reconstruction expert, because he said possibly as much in his testimony as he said anything else. Clarissa's Yoga said, and we thought Proctor would be the worst witness. Proctor's texts are horrific, but Proctor's texts give a lot of context that I think is needed. So for that, I'm glad that they all came to light, because Proctor's texts show that at the evening of January 29th, the investigative team and the lead investigator, Proctor, had determined that, quote, she waffled him, that this was a motor vehicle versus pedestrian, and everything, it seems, in this investigation was going to point that direction from that point. So when Alan Jackson keeps saying, so this was an objective investigation, they're like, yeah, no evidence pointed to anything else. Okay. This doesn't make sense. Disney Gal said, how can Trooper Paul be an expert witness when he doesn't have the basic knowledge or any in-depth studies in the field? I don't know how the court qualified him as an expert because the court has not qualified experts. The court has not put that on the record at all. So he's their accident reconstructionist. And I imagine that we're going to see a different style of accident reconstructionist from the federal investigation presented by the defense. We've seen, in cases we've covered together, we've seen good accident reconstructionists. In the Gwyneth Paltrow case, there were great accident reconstructionists. This is just wild. Franny said, can the state even arrest without an ME? I mean, not well. I don't understand why they're waiting so long to put them on. I don't either. And after the ME testifies, maybe I'll have more clarification on that. But I'm frustrated because you would normally have the ME and then be able to check all the other testimony against what's known, right? Okay, what's known from the victim is that the injuries are this, the bruising is this, the cause of death is that. So taking those things that are neutrally known, what happened to the victim, regardless of any way that it was caused, what the injuries are, you can start to check it against other testimony. But we don't have that, which makes it really hard to have anything but questions. And I don't know if the state will tie it together in the end. I'm not optimistic at this point because I am still confused. And when I went into this case, I was like, opening statements, and we're going to clearly know what the state's theory is and what the defense theory is. Did that happen for you that watched opening statements? Did you feel like you clearly understood both theories after opening? Because I did not. EQ said, can you explain what is meant by a continuous that both sides asked for? Both sides asked for the trial to happen later, not now. Both sides asked for more time to do this trial at another point. And the judge said no. I've never seen the judge say, I was convinced. I told Team Baker, I'm like, look, man, we're going to cover the Karen Reed trial, but it's not going to trial in June. I was like, y'all, both sides are asking for a continuance. Like I don't know why a judge, when there's an ongoing federal investigation and the prosecution and defense are saying we need more time, I don't know a judge that would be like, nah. And I was wrong. Just wrong on wrong. Because the judge was like, nope, go to trial. DK said, are the experts allowed to say they're from the FBI investigation? Not necessarily, but they can say that they can say where they work. They can say where they work. I don't know how the defense is going to get around, but you weren't hired by the defense or the prosecution in this case. No, but no, they can't really say. Ozzy Lawnard said, hubby is a mechanical engineer and lost his mind. Jen Beasy said the iPhone 15 was released in September 2023, right? I don't remember the order of cell phone release dates, but the iOS is, we're on iOS 17 presently. So the iOS is what they were talking about, not the model of the phone. If that helps. Blue Vero said, so this is telling me I should make her reset my phone once a week. Well, if you manufacture or reset it, stuff gets deleted is what they said. Mello, thank you for the conversions. Note, disclaimer, only catches search in the field as shown. Melanie said, so he's proving it wasn't deleted, but not proving it was searched. But not proving it was searched at 2:27 a.m. The state's expert said it was not searched at 2:27 a.m. and said definitively that those searches happened later and then were written to the database later. I think the state's experts on the Google search of it all were quite good, but we have not seen the defense experts yet. So I am keeping an open mind on that. However, it's not going to matter what Jen McCabe did or did not do if they don't prove what Karen Reed did or did not do. It's just at this point a side quest about Jen McCabe, which is frustrating because I would like you to answer the questions. How did Karen Reed do the thing you said she did, and is that consistent with the victim's injuries? Can we do that first? Like, can we just finish that thing first? And I am frustrated. I wonder how many times Jen McCabe has yelled, "Why am I on trial?" at YouTube. Probably lots. Or Jen McCabe is like, that's right. Get in there and prove that I didn't do the things people have said that I did. Get in there and prove that the defense was just beating up on me. Get in there and prove that the defense is just looking for straw men. Well, the defense gets to do that. They're the defense. So their job is to zealously represent their client. The Commonwealth's job is to prove their case, not disprove the defense's case. The defense has this particular prosecution chasing its tail, and that is not a good place for the prosecution to be. And it can be hard as a prosecutor and as a prosecutor's office to just focus on what's in front of you, but they are not focused on what's in front of them. They are focused on what the defense is throwing at them. And the defense has done a really good job at that. And you see it every single day when you're trying to watch this trial. If you came into this trial with no outside knowledge, you're watching it every day being like, why are they doing this? Why are they on and on about this? Why are they on and on about Jem McCabe's phone? What happened to the victim? What are his injuries? And it's frustrating, just frustrating. So, yeah, it's really, really frustrating to watch. I'm going to try to get through a few more super chats and chats in the chat. Not all of the super chats stayed when I refreshed on my end, and I apologize for that because we've been streaming for so long. I lost some of them, so I'm sorry about that. Marianne said this witness was set up to fail like Dr. Anderson, and the J. Hatch trial was set up to fail, unknowingly giving false testimony based on lack of true info. I think the reconstructionist did not have the full case file, which is a real bad look for the prosecution. Emily read my mind. Poor guy needs some Baileys in his coffee. That witness was nervous, and I don't know how often he's testified in court, but it did not go well. It just did not go well. Gen X shenanigans. Me regularly. I just want to know if the SUV sideswiped him, spun him around, and he hit his head on the curb or the street. How did he end up 10 feet into the yard? And if we knew what the medical examiner said, we might know a little bit, but we don't. So it's hard to know. I think, and this is Emily trying to piece things together from what we've seen, it looked like there were some vertical blood drops on the victim's clothing. It seems to me that after he started bleeding from the head or face, because he also had scratches on his face, that he was still upright for a bit. So I don't know, because we don't know the injuries, because we don't have the coroner medical examiner's testimony yet. And it is really frustrating. Dominique said, thank you, EDB and team. Slept through my alarm and the app notification woke me up for work. Law Nerd app for the win. Dominique, look, we're here for you. I'm waiting for the day that the Law Nerd app wakes me up and reminds me that I need to be streaming, because today was one of those days when I was like, oh my God, I'm so tired. Today was a lot. Did today feel like a lot to you? I don't even know how we're going to quick bits this shit. Today was a lot to me. Today was a lot for you. Today was just a lot. And with all the issues YouTube is having, you guys, I'm going to wrap up because it's frustrating for me and I can see that it's frustrating for you. I'm going to go figure out how the Law Nerds broke the app. Generally, we break things with enthusiasm. So yay us for breaking the internet with enthusiasm. I also have to wonder if the Law Nerd app issues that we're having today and the YouTube issues are actually Amazon Web Services issues, which it might be. So I'm going to go see if we can figure that out. And hopefully YouTube will get its shit together. I appreciate you guys. Thank you for making this the #1 place to watch trials. I know there will be tons of recaps and everyone will be losing their mind about today's testimony. Today was wild. Just wild testimony. I will be back tomorrow for voir dire. I can't wait to watch it with all of you and then remind everybody that we're not actually out of the chat or not actually clear from the state's case yet, the prosecution's case yet. But today was just wild. So, Law Nerds, I'm going to go get ready for the podcast, get ready to pack. And I will see you in the chat tomorrow for, well, not day 26 of trial, day voir dire of trial, day extra of trial. So, Law Nerds, thank you for being here. Thank you for being a Law Nerd. Thank you for doing all the YouTube-y things. I appreciate you. I don't think I've said that once today, but that's okay. You know what YouTube-y things to do. I'll see you all tomorrow. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.